So,
But here's the problem with that. Let's say they come back in the jury verdict form and they list 183 as one of the overt acts that they find, right? We don't know if they found that
right.
because they found that Mr. Kendrick.
Agreed. So, here's a possibility.
All right.
So I'm going to throw this out here and y'all can let me know what you think. If we have a 183 that alleges that the three people that are included, Arnold, Kendrick, and Williams, possessed marijuana with intent to distribute and a firearm during the commission of a felony, because those are still live with regard to Mr. Kendrick. And then maybe a 183A that says, you know, or posits that Arnold and Williams possessed the codeine and the cocaine. And then we know, okay, it's 183. They think they all, or somebody at least, possess those two things. Or we think maybe Mr. Williams or maybe Mr. Arnold possessed the codeine or the cocaine, but we know it can't have been Mr. Kendrick because I've already determined that.
So is the, just want to make sure I understand the court's suggestion. There'd be essentially I'm going to do a slightly different numbering system. There'd be a 183A, which has all three individuals listed, but you would remove the codeine and the cocaine. And then there would be a 183B, which would just be Arnold and Williams with the
codeine and the cocaine. Yes, that's what I'm proposing.
My only question with that is, are we facing the same situation, or with a question of can we then go and modify? I guess we can modify these overt acts. I don't know if we can modify.
Like that's an easier question because it's based on me having directed a verdict that Mr. Kendrick can't have done those two things, so it inures to his benefit.
I'm willing to go with your suggestion as long as it's not taken by the court or anyone else, that I'm conceding that the ability to modify this overt act for A and B due to a directed verdict is a concession that you can modify those other overt acts that we referred to earlier.
Understood. And if we find out that you in no way can modify, then I guess our solution would be to just strike those two things entirely. But I don't think that is actually fair to the state when it could be that, you know, they asserted that all three of them did that, and it could be that the jury thinks one of them did that.
Yeah, and I'm not, while I probably should, I'm not disagreeing with the court on what you're saying with respect to that. The real key is going to be if we can find any law and what that law says.
Sure.
That'll be determinative of some of those issues.
You say I probably should, but you shouldn't if you, I appreciate that you take your duty of candor seriously. I really do. Thank you. Yes, sir.
Your Honor, with regard to count or Act 183, if the jury unanimously finds that this overt act was in furtherance of the conspiracy, I believe with the instructions the court will be giving when you have multiple parties, you know, and could mean, you know, and can be or in pleadings. And so if the jury finds that this, which includes Mr. Arnold, Mr. Williams, and Mr. Kendrick, if they find it's an act in furtherance of the conspiracy, it would be attributable against Kendrick and Stillwell. So I believe the state's current belief is that the way it is worded is safe with the instructions the court will be given about possession, constructive, actual, how you read and in indictments or pleadings, so that the jury, who's presumed to follow the court's instructions, will use those legal principles. And if they do find this overt act is in furtherance, it will be following that law.
Here's the challenge with that, and just kind of think through this hypothetical with me. We have got overt act 183 that says Arnold, Kendrick, and Williams. Let's assume that the only overt act the jury comes back with is 183. And all we know is they found 183. But how do we know then that they didn't say, you know what, I think Mr. Kendrick possessed codeine with intent to distribute. That is all I think, and that is why I'm finding this count. When I have already directed a verdict against the state and on the side of Mr. Kendrick with regard to that, that seems problematic. And then the whole case gets reversed, assuming that that's what happens.
Understood.
And
John.
I doubt if that's going to come to fruition, but legally speaking, that's my worry with leaving it the way it is.
Understood, John. I'm thinking through it with the court right now.
Okay.
So if we could come back to this.
All right.
Thank you, Your Honor.
I guess what doesn't make sense is we didn't have to charge the separate offenses. We could have just split those offenses like we did in the Overt Act, and your directed verdict on those obviously would have had no.
That's true.
There's no directed verdict.
That's true, but I'm worried about an inconsistent verdict, which is not allowed.
Well, inconsistent verdicts in Georgia are allowed. There is no. Georgia doesn't have inconsistent verdicts. They don't go.
Well, what is it that we phrase it? It's not inconsistent. What is it called? Repugnant. And I don't know, this would qualify as that, but it's factually, I don't know the answer.
Your Honor,
I just know the question.
I think we'll have time to return to this.
Okay.
I'd like to bring you, I'd like you to bring you some authority. But
Okay.
I can tell you that my understanding under analogous federal law is that there is not such a thing as an inconsistent verdict as between a substantive count on a charge and that being an overt act. The jury could find it to be the overt act, even though the substantive count they rejected explicitly.
Okay, but that's not them. All right. If you can, I think that would be an inconsistent verdict, which wouldn't be problematic. Our situation is not that. Let's assume that nobody else is charged, that it's just Mr. Kendrick who is alleged to have done Overt Act 183. And I have directed, and it's only, Cody, and I've directed a verdict on that count with regard to the substantive count. Could we then leave that overt act in? When I've said as a matter of law?
Actually, I believe the answer.
So that's our question.
Right, understood. It helps to frame the question.
Okay.
And we're going to come back and talk about it, so I don't want to.
All right.
I'd like to be.
Think it through before we know what the case law is. Okay.
Thank you.
Appreciate it. All right. The next thing is on the overt acts that allege possession of a firearm by a convicted felon that aren't also substantive counts. We were adding definitions of, like, if, I don't know, Mr. Arnold was alleged to have committed an overt act of possession of a firearm by a convicted felon while he was convicted of, I don't know, dealing in some kind of drugs. And we would need to have defined what is that underlying crime in our overt acts definitions. But that would only be true, I think, if we then had, well, let's not have it be Mr. Arnold. I'm talking about Mr. Kendrick and Mr. Stillwell. They've been alleged to have been convicted felons based on convictions for gang act and burglary with regard to Mr. Stillwell, shoplifting and possession of dangerous drugs out of Arizona. As to Mr. Kendrick, I just want to make sure that those convictions are in evidence, and that ought to be easy enough to check. And honestly, I think Ms. Hilton, you maybe even cited what the exhibit numbers were. I just want to make sure that is what those matched up to.
Yes, Your Honor.
So I think it was what you said was 60G, 30Q, and 487VV. So can we just pull those and?
In
Or if you've got it on this, you had it as a slide, actually. If you want to just pull that up too, and let's look.
And there are other convictions for Mr. Stillwell that were admitted as well.
Right, but I'm just, at this point, trying to figure out which crimes not otherwise defined do I need to define for purposes of overt acts. And we have not yet defined shoplifting, burglary, or whatever that Arizona dangerous drugs thing is, and I'm not even sure how to define that one, but looking at the indictment, plea, and sentence would help. And are we sure that was a felony shoplifting? Because shoplifting isn't always a felony. So can we just pull those convictions?
You want me to pull what I posted in the,
I mean, the actual
you want me to pull
piece
the
of evidence would be probably the easiest. Thanks.
Good morning, ladies and gentlemen. Good morning, good morning, good morning. Put a one in the chat if you can hear the sound of my voice. Good morning to everyone joining in today. Today is the day of the jury charge, which should be given within the next hour. But good morning. Shout out to my co-host today, attorney Aikisha L. Shabazz is in the building. Ike, say hello to the people.
Good morning, people. Good morning. Good morning. Good morning. Can you hear me? Can you hear me?
I can hear you.
Can you feel me? Can you? Good.
Yeah.
Very good. Very good.
You see it, ladies and gentlemen.
I'm sure. Well, now.
Get ready. We about to start this.
Too much. Come, Dennis, got music now? Got music now?
Oh, yes.
Hey. I'm so happy this trial is over.
Yes, ma'am. Okay, here we go. Oh. Good morning, everybody. Good morning. As we can see from the background, the lawyers are in the courtroom. Jurors are not in the courtroom right now, but we want to talk about the closing arguments from yesterday, last night. We did have an opportunity, both of us, to watch the closing arguments. I was in the courtroom yesterday. I stayed until I couldn't stay no more, and I rushed home to beat the traffic in the darkness. You know, some of us can't do driving too late at night. I can know firsthand. I can't drive in the daytime.
No, listen. Dennis tried to kill me a couple times, y'all. I was like, I'm gonna need you to pull over and get the fuck up out the driver's seat. I think I'll be driving. Thank you. I think you need to move. Let me drive this. I got this.
Pull over on the highway in the middle of the expressway.
Yes.
Get out.
Yes.
I'm driving.
I got this. All right. I need to be responsible for my life. If I go out, y'all, I want it to be on my terms. You know what I'm saying?
Oh, my goodness.
Yeah.
I remember that moment like yesterday. Oh my goodness. Get out. I can't either, but I'm taking the wheel.
Oh my God. I saw my life flash before me. I was like, oh, this is not gonna work. We're not gonna make it. Abort.
So yesterday, ladies and gentlemen, we both saw the closing argument of I guess it was the rebuttal from WDA Hilton.
Yes.
And it was a lot we gleaned from that very colorful closing. But I brought in a veteran in law professor, college professor, and former New York City prosecutor. And I needed to get her point of view because she's been a part of a lot of closing arguments.
Yeah.
So, Ike, what did you think yesterday? What did you think about the closing arguments of everything you caught? But let's hone in for that right now. It's on Ms. Hilton's closing.
Okay, so ignoring all of the noise in the room, I thought she did a fairly decent job of trying to put the pieces together, right? Because the evidence so far has been very hodgepodge and piecemeal. So I think she did a fairly decent job at trying to link the evidence, the pieces of the evidence, in such a way that she could paint a picture. I thought she did a decent job with that. Considering, again, I said all the noise in the room. Now, she undermined a lot of her own arguments with saying things like, it probably happened like this. I don't know if you remember that.
Mm-hmm.
Remember, she was like, it probably, and it probably, a few times she said, it probably, and I'm thinking, if I had been the defense, I so hope that they addressed probability.
Now, you had cited.
Look, we can't do both. I can't talk over the judge.
Closing presentation.
Oh, should I mute her? Because we're gonna look at the final. We're gonna watch the final closing.
All right.
I mean the
so it doesn't look like
anyway.
The Arizona conviction came in. So
what do you say? You wanna? I could pause.
Let me see what they're doing real quick.
Okay.
They look like they're just going over the charge.
Yeah, exactly. That's what they do.
Yeah, we don't need to see that.
Okay, hold on. One second.
I just hope, that the defense put all of their objections on the record after her closing, because I didn't hear them objecting during. And I get that. Sometimes you don't want to object during because the optics of it. But after, typically, you are given an opportunity by the court to make a record. You get the court reporter and you go to the side, or you have either sidebar, or you send the jury out. That way you can make a record as to all the objections you have based on that summation. So I really hope that they did that.
Okay, so with that, there has been a lot of talk on social media about how people viewed her closing. Obviously I went to bed late last night. obviously
Right.
watching.
And that's why I said ignoring the noise in the room, right? Because I get that there was some very colorful language she didn't need to use. She was speaking incredibly fast, and her words were being eaten up. She did not articulate very well. Her diction was at times not there, let's say, right? Some people say she was, going in and out of, the ebonics. I don't know. She was talking ghetto, so to speak. But I don't know who you're trying to appeal to in that. And then there are the other side of that is when Kamala did it, people jumped to her defense and said, that's how we speak. We code switch. So, we can argue both sides of that, right? We do code switch. Some people will say that, that's what we do.
Well, I
Don't
thought,
lo-
and I agree with you. We do code switch, but I thought what was interesting was when Judge Whitaker blurted out the N word while she was reading some lyrics, and then she came back and apologized. Simone Hilton was the one that gave the reaction to the camera.
Right,
So,
but what's the obvious difference between Simone Hilton and Judge Whitaker?
well, the obvious difference.
Okay, so that's why.
Okay.
That's why. I don't know if Judge Glanville has said it. I believe he said it. And I don't think anyone got that reaction, and I don't think he apologized.
Right.
Right? And so he got the pass because he's Black. I mean, the unwritten rule is you can say it if you're Black.
Yeah. Yeah. We'll come back to that conversation later. So do you, based on what you've heard yesterday, and obviously closings are not evidence, do you think that the prosecution has proven in not just with their closing, but all the evidence that was obviously put forth in the trial with these two defendants, they have reached the necessary requisite to get a conviction?
So everyone is going to hate me, right? Because this is not what you want to hear, but I never come on to tell you what you want to hear. I think the prosecution has done enough to establish accomplice liability under a conspiracy theory. So you have to understand they don't need direct evidence, right? And circumstantially, I believe they've done that. Circumstantial evidence allows you to draw the natural inference from a set of facts. Mm-hmm. So they've presented a set of facts, and they've got Woody in the jail cell, which seems to be corroborated by the physical evidence recovered at the scene of this man's murder and the bullets. It appears that way, right? I'm not going through the evidence with a fine-tooth comb. Hopefully they will. In association with some of the conversations that they were having, it appears that this man was involved. And so under the theory of accomplice liability, you're in for a penny or you're in for a pound, you have the same criminal liability. It doesn't matter. So she was trying to explain use this bank robbery analogy to show how it didn't matter what part you played in the crime or the criminal enterprise. You all are equally criminally liable. So if it was a crime to paint a wall and I bought the paint and I did the painting and you just looked out while I did the painting, we're equally as criminally liable for doing the painting because we had the same mental intent to paint the wall. You are my co-conspirator, sir. Co-conspirator. You are enabling me to do this. If you don't look out, I can't paint the wall. But for you looking out. So it doesn't matter how much you do or how little you do with accomplice liability. And so the fact that he may not be the shooter or he may only be the driver, is of no moment if he's involved, if they find that he's involved. Now, the standard is, and why she kept saying it's not your job to find out. The standard is whether or not this evidence convinces you beyond a reason for you to doubt the defendant's guilt. What are the reasons to doubt the defendant's guilt? And that's what that's what it comes down to. I mean, it's mountainous, the evidence, right?
It is.
It appears to be mountainous, and based on those summations, when they put them together, it seems compelling.
And to your point, it's a mountain of evidence, and I don't think that there will be a verdict. No time. Not
Oh
right.
No. There are way too many charges, so they're probably not going to even really get into the. I don't see this coming back before Thanksgiving, unless they are so sick and tired of this trial that they just compromise.
And that's
which is a loss for the defense.
Right.
That's what defense attorneys fear most, is that there will be a compromise verdict. And while jurors, some in their mind think that they're doing the right thing because they're giving a little bit to both sides, that way nobody feels bad. No, somebody going to jail for the rest of their life with that bullshit.
Right. And they don't know what
and they don't get that. They don't get that part. They don't
know what they're facing. They may think it's something minor.
Right.
We're assuming they're not watching any of the social media or news coverage and everything, as the judges instruct them not to do. But
I still think, though, that even if they get a conviction, I think this trial will come back on appeal. And I think some of Hilton's summation was objectionable and maybe reversible error. So now I don't remember if the evidence about this shooting did the evidence come in? Did they say that there were children outside during the shooting? Because on summation, she said that.
I don't know if I remember that, but she did say that. But she said some other things that wasn't said.
So that's called the safe streets argument, and it's problematic because it causes jurors to act out of fear, right? And so you're asking jurors to vote guilty because they fear that the streets will be safer without this person on the street, without regard to the quantum of evidence and whether that evidence convinces them beyond a reasonable doubt. So that's a problem. That's a straight, if in fact, she made that safe streets argument and there was no good faith basis, or it's not fair comment on the evidence, meaning that someone did in fact testify that there were children outside that day.
Why didn't the lawyers object to it?
So again, like I said, sometimes you don't want to object because the optics of it, right? Objecting during the summations are frowned upon unless it is, so incredibly egregious. But like I hope that they preserved and put their objections on the record after her summation was finished. Usually the court allows some room for that to happen. Well, if not, you have to request it.
Yeah. That didn't happen last night.
No?
Oh, it didn't happen last night.
So that would be a mistake. That would be a mistake for the defense to not put your objections on the record for Miss Hilton.
Okay.
Yeah.
What's your thoughts on how she told the jurors essentially to tell on other jurors? Talk about that.
So there was a part where she said to the jurors, if you get to the back and there's a juror who just refuses to deliberate, you come back and you tell the marshal or you tell the court staff and let us know. And so you're inviting the jury to be snitches on each other and to undermine each other's trust. I don't think that's the approach I would have taken.
But Glanville did that in the beginning. Glanville told the jurors.
Right, but it's one thing for the judge to do it. It's another thing for you to do it.
Right.
When you are asking them to do something for you, right? It's another thing for them to feel threatened or intimidated. And that's not the approach you want to take with jurors. You don't need to. Why not just invite them to deliberate because it's their duty.
Right.
And because this is why we chose you. Out of all of the people that showed up, we chose you. Right? And you've been here day in and day out. And you've been committed. And I don't expect that you would abandon that commitment now.
Right.
That's what you appeal to.
It was kind of insulting.
Right? It is insulting. Like these people have been coming to court for how long? And you have the temerity to suggest that one of them might just abdicate their entire shit. Like, if they didn't want to be here, they could have been I got COVID. Come on. There's 1,000 ways to get out of fucking jury duty.
And they've been together so long. The jurors, they're
friends. They're friends.
You insult any of us. And I think about the O.J. Simpson trial and how the jurors were how they were in that jury room where they had the opportunity to get to know each other and people were losing it. But then you have the prosecutor basically trying to prosecute the jurors.
Trying to bully them around. And you better get back. You better go deliberate. And if you don't, I'm going to make sure one of y'all tells on the other one of y'all. Like, why are you doing that? That is not the approach. Yeah. That is absolutely not the approach. It
was so much to dissect, and obviously we don't have the time yet, but we will have the time once this trial comes to a conclusion, because as a professor yourself, will you be extracting anything from this entire trial, some parts of this trial, to use for your class or your students?
Yeah, I actually have shown some parts where they're qualifying experts. I think I've shown part of that. I think I've shown part where they were arguing about the relevance of evidence, because I teach evidence, right? And so Georgia models the federal rules of evidence, right? The Georgia Code of Evidence, or whatever they call it, it models the federal rules of evidence. So it's pretty much a mirror to what I'm teaching. So it gives me some demonstrative evidence to show them exactly what these arguments look like and what it looks like to proffer a witness when you're trying to qualify them as an expert. So some of this is helpful for that. So I have used it. I haven't used it this much in this class this semester. I may have used it once or twice, but I did use it last semester as well. I mean, this is how long this trial has been going on for, right? So I have used it.
What impact do you think if the prosecution prevails in a actual conviction by way of jurors will have on the other RICO cases that are approaching in Fulton County? Because there are at least 1, 2, 3 RICO cases pending now in Fulton County.
Right.
What impact a positive and or negative outcome for the prosecution would have on these other cases?
I mean, if they are able to secure a conviction, then obviously the other cases, those defendants might consider taking a plea, right? Because they have the same charges. It's going to be the same evidence, more likely than not, and could be the same outcome.
And you had the expert was part of the architect, one of the architects of the RICO statute in Georgia, sitting right now. He's in the courtroom right now, Mr. Floyd, who was also in the courtroom for the election interference. But I have yet to see Ernest Williams. Those are the 3 cases: it's the election interference.
Well, that's not happening. That's not happening.
No time soon.
Election interference. Come on.
Right. That's not happening.
It's not happening. That case is so I know it's not a federal case, but I assure you that case is moving nowhere.
Nowhere.
Just like his New York State case is going nowhere. And all the federal cases are over.
Oh, wait a minute. What happened in New York with this one? Because the sentence is supposed to be the 28th.
Oh no, they put it's indefinitely postponed, last I heard.
Oh wow.
Yeah.
An indefinite.
Something like that. Yeah. I was like, I'm not even. I won't even engage with you, Alvin Braggs. You coward. You coward. Why would you even bring this? Why would you even start Why would you start this and not finish it?
Mm.
Why would you wait so late to start it, knowing the length of time it would take, and not have the foresight that you would need to finish it? Come on, man.
Right.
And so it makes it look all the more political.
Well,
Right?
Judge
It makes
Machan, I think his name's Judge Machan.
Marshawn.
Judge Machan. Right. He could have dismissed this. He could have did a few things.
He could have.
Yeah.
I thought he and I thought he was. I thought he was.
Right.
And maybe they think he's poised to do it as well, which is why they, want to hold it in abeyance or whatnot.
But the prosecutor can also concede because it's there. Well, can they concede? Well, I don't know.
I don't get the point of it because. So here's what I don't understand. First, you have a right to a speedy sentence as well. So his lawyers would have to be consenting to him not being sentenced all this time, right? So you're walking around with these convictions, but you're not sentenced. That's ridiculous. I wouldn't stand for that bullshit if I was his lawyer. I'd be like, fuck you, shit, or get off the pot, right? That way we have something that's appealable, and we can move forward. But you holding me in this state with nothing to do. And who's to say Alvin Braggs is even going to be the DA in 4 years?
Yeah.
Right. So
right.
Then what? It's just it doesn't make any sense.
But what would a sentence look like for a soon to be sitting president?
Probation. That way, at least he's got a felony. Let him go appeal it and do all of that. But at least you finished, and your prosecution is done.
And what would probation? You can't be out. What would probation look like for a president? I couldn't even. We've never been.
Let the Secret Service work that out. Let probation department and the Secret Service work that out.
Okay, Secret Service that he controls.
I think that they would have to suspend it while he's president, but he's not president. He'd be on probation till January 20th. Then they suspend his probation until he is done with the presidency. And then I guess they put him back on probation. I don't know. By then they'll probably it's just stupid. It's stupid.
Considering,
but at least he'd have the felony.
Right.
Right now, he's in limbo. I don't even know how this registered when you go get a background check, because it's not entered. The conviction is not entered because he hasn't been sentenced.
Okay, so you have to be sentenced, then it has to be okay. So right now it's in limbo.
Right.
Okay.
So this shouldn't affect. This should not affect his security clearances because he hasn't been convicted. In the sense that on paper, that conviction is entered and he's sentenced.
Interesting.
Yeah.
Well, someone said that the reason why the prosecutors were wearing red yesterday was to support of Trump.
I seriously doubt that.
That's
so sick. I got on red today. It's important. It's supportive Yiddy. Because it's right now, I got so much running around to do. I'm like, I need something. I need an all-in-one. Throw that on and keep it pushing.
Hey, well, I know you have a class today, and I appreciate.
My class not till 6. My class is not till 6. It's the last class of the semester. It's been a good semester we've had. Okay. Thank you, Succeeding too. I bet your class is amazing. It is. I'm biased though. No, my students tell me it's amazing. Because it's a lot of fun, and it's not a fun subject. Evidence is not a fun subject. It is not.
I want to listen in on the court, see if it.
All right, let's listen in. I got a few more minutes. I'll stay till 11.
Okay, hold on. Looks like Miss Hilton is checking my Twitter, looking at my Twitter. Let's see who else.
This guy. I thought you was putting the audio in the courtroom.
The audio's there. You don't hear it?
Oh, no.
Okay, so they're not saying anything. It's
No.
there. Hold on a
Okay.
second. Oh, there you go. Sorry. You hear now?
They're not saying nothing, I guess, because I don't hear nothing.
They're not saying anything yet. But they will. The jurors are due at 11 a.m. And tell people about what we should expect from. Tell people what explain to me what happens at this stage of the proceeding.
Okay. So this is the part where the court is going to instruct the jury on the law. So the court, and this is going to be the most tedious, most boring part of the trial. The court is going to go through all of the law, has to define all of the terms in all of the law, has to go through all of the counts in the indictment, and then has to explain to the jury their role, then has to go through how they are supposed to evaluate the evidence. She's going to give a charge on credibility, which is going to tell them different things to look for and how to evaluate a witness's credibility. I'm sure she's going to give them a charge on the defendant remaining silent, that they are not to draw any negative inference from the fact that the defendant did not testify, that it is his right not to testify, their right, I should say, not to testify, and that they cannot draw anything. They can't hold it against him. They can't speculate as to why they didn't testify or anything like that. I'm sure she's going to give that charge. She may give what's called a false in one, false in all charge, which says if there's any part of this testimony that comes from a witness that you believe to be false, you can disregard all of that testimony, or you can believe the parts of the testimony you believe to be true and disregards the parts that you believe to be false. Right? There's a whole gamut.
Yeah, that right there. That's kind of tricky
false
words.
In one, false in one, false in all. That's not tricky words. Some people tell parts of truths, right? And when you mix part of the truth with a lie, it sounds better. So some people specialize in doing that. And so you may find that in a witness's testimony, you believe part of their testimony, but you don't believe the other part. And that's permissible. It's allowed. The court doesn't require that you disregard those parts of the testimony that you found to be true. And that's an instruction, because you want to tell people how they should consider things. You may not think that way. You may not be thinking that, okay, I didn't believe that witness, but some of his testimony was true. You may not know what to do with that. And so the court is giving you some direction, some instruction, and letting you know and understand that you can accept the parts of the testimony you believe to be true. And you can throw away the parts that you thought were bullshit. All right? That's fine. That's fine. There's going to be a charge on witness bias, right? Or what's called an interested witness charge. Hopefully, the defense requested that. All of the witnesses for the prosecution that testified under a deal, they are interested witnesses, because they're what happens in their
y'all continue to research. I need
probation or whatever is contingent on whether they testify successfully for the prosecution.
Saved on my computer up there that aren't saved in a document down here. All right.
Don't worry about that. That's the judge.
Okay, I was talking about interested witness charge, right? So say, for instance, those witnesses that went to jail after their testimony. Well, the court is going to instruct them that they might consider whether or not how much weight they'd give that testimony, considering that these witnesses were interested in the outcome of these proceedings, right? And so the jury would then be free to say, I don't really believe what you were saying. It seems like you only testified that way because the prosecution promised you that you would go home. Right. And so maybe I don't give that testimony so much weight.
Okay, something happened in the courtroom. Hold on. But they moved Kokomo. Okay. All right. Judge is off the bench. All right. So whenever the judge is off the bench, cameras go to the cell. I'm sorry.
Yeah, that's fine. That's fine. That's fine.
So I caught a few things that was going on in the when the camera panned the room yesterday, like Miss Love, doing all this. What did you think about?
Yeah. Ah, man. I hate that. And so these are the things that they don't teach you in the law books, right? These are the intangibles, things that are happening in the courtroom that a lot of people are going to miss. Miss Love making a lot of gesticulations, huffing and puffing and sighing and leaning over and having conversations and turning around is incredibly distracting. It is incredibly distracting, and she's doing it by design, and it's so unprofessional. It is so incredibly unprofessional, and I have called prosecutors out on it. I have said, Judge, I would ask that you instruct the people, because I want the jury to know that they shouldn't be doing that shit.
Right.
So I would say, Judge, I would ask that you instruct the people to stop distracting the jury and these proceedings by passing notes and whispering and huffing and puffing and gesticulating. I would make the record. I would do it. I would do it, because you're gonna stop. I'm gonna call you out. And if you did it again, Judge, I'm gonna ask you to instruct Miss Love that she's doing it again. It's very distracting. Do it. Make a record of it. It's disgusting. It's unprofessional, and I don't see them doing that when they're doing closing arguments.
Right.
You know what I mean? You turning all the way around and talk to somebody else. You don't think the jury right there is distracted by that? And the moment you do that, you're taking the jury's attention away from paying attention to what's being said. Why? That's I don't
There's
like
some judges that once they are at this phase of doing the jury instructions, they said no one can move in the courtroom, or you can't come. Lock the door.
Yeah, no coming, but yep, they do not come in and out. Yes.
I don't want swinging doors.
Listen, I had that happen in Nassau. I mean, they had a class. I'm in the middle of summation. They brought a whole fucking class in. Yes, a whole class. I'm like, really? This is what we doing? This and y'all, they just don't play fair. They don't play fair.
I saw yesterday.
And so I'm the type of lawyer will stop, because the record needs to be clear when this gamesmanship happens. I'm like, I just want to put on the record that the prosecution now has, in the middle of my summation, bringing in a class. I'm going to just wait. The time now is, let's see how long it takes for them to come in and get settled. That's what I'm on. That's why they don't like me. Because listen, I'm gonna leave this courtroom holding my ankles. But y'all gonna know I'm gonna scream a little bit. I'm gonna scream a little bit while it's happening. That's just how that's going.
I noticed one point yesterday where Mr. Weinstein was giving his closing. Miss Hilton got up and walked over to the far left, and he caught it. Oh, wow! It's my sign. But like to lose things are distracting.
He better than me, because I would have been like, excuse me, what are you doing right now? Can you please have a seat? I'm in the middle of my summation. I did not do that to you.
She got this big red jacket on, red.
No, that's not saying. But he didn't say nothing.
No,
he say anything.
What he said was, "Oh, I need to move my sign, my sign is, his display,
right?
So she can see it." But she could have easily said, "Can you turn it around?" Something.
But was it blocking her and she had to get out of the way to see it? Oh, that's different. I thought you made it seem like she got up while he was there and was like, let me walk on by. No, okay, stop, Dennis.
Listen, I want to
jump on Miss Hilton for no reason. There's plenty of reasons to jump on her.
Yes.
For that information.
I did that yesterday. I walked in the courtroom. It was Doug was giving his
no
closing. I walked in.
They should lock the doors.
Yeah,
they should not. Or post somebody outside. You know what I mean? To say like, what are you coming in and out for right now?
I walked in, everyone looked at me. I'm like, wait,
Or have the court make an announcement. I do not want walking in and out or distraction during these summations.
Yeah, I probably have to apologize.
Crazy.
Yeah, I don't know. Judges now on the bench, ladies and gentlemen. So we got the seal. I'm watching the seal. The jurors will be back. Let's see here. Another 12 minutes.
Yeah, this charge is going to take the rest of the day. I can't imagine it's less than 3 hours. I can't imagine it's less than 2-3 hours. How many counts?
Yeah. Yeah.
Every count.
Verdict watch will stop.
So, and here's the thing. They go through the count. So defendants are charged on count 57 with so-and-so and so. And they say, to find the defendants guilty of this count, the people would have to prove beyond a reasonable doubt, element this, element that, element that. If the people fail to prove each element, you must find the defendant guilty. If the people do prove, you must find the defendant not guilty. Guilty, right? Not guilty. They got to do that for each count.
And let's talk about how the jurors are are they able to take the instructions back to the jury room and read
Every court is different. So she may not. She may or she may not. And I don't know. I haven't heard what the ruling is on that. I'm sure they know by now whether or not they're going to get a copy of the instructions. Considering how long they are, they may. The problem with sending jurors back with the instructions is that when they have a question, then they don't come to you. They try to answer it themselves, and that's not what you want, right? Okay. Right? As the court, you don't. If the jury has a question about the instructions, you want them to come to you. And so sending them back is, that presents that danger that they then don't ask you. They figure it out themselves, and they usually come up with the wrong answer.
Well, and to your point, this is going to be a very, as the judge was crafting and the lawyers were crafting these instructions, I said, this is kind of confusing. The jurors are probably going to need to have that as a reference tool while they're back there. And maybe they can go and say, listen, we have a question about this instruction on page 22. Can you give us a little more guidance on this?
So, and I'm saying, so she can send them back, but she needs to send them back with the instruction that if they have a question, that they should write a note to the court that we're sending them back for reference only because we don't expect you to remember every single definition or every single element of every single crime, right? So for reference purposes, right? So if you don't remember what the elements of, possession of a firearm, then you can look to the indictment and to the instructions, and it will give you the definition of that or the elements of that. But if you have a question about what something means or how it should be applied, please send a note to the court. As long as she gives them the right instruction on that, then I can't see why they wouldn't be able to have a copy of the instructions.
What type of evidence do you think will go back to the jury room?
They will probably ask for the medical examiner's reports for the deaths, maybe crime scene photos. They may want to hear, if they ask for Little Woody's testimony at the precinct, it's a wrap.
Why do you say that?
Because I think if they focus on that, then they believe him. And he gave some pretty damning statements about how those murders occurred and who was involved and what guns were used. And that, according to Hilton's summation, seems to be corroborated by the physical evidence. I think he said that Yak Gotti was the driver or something to that effect, or he had a AK. I think he said somebody had an AK, and was not AK fragments recovered from this man's body, bullet fragments. What, something to that effect? That's if that's what the evidence shows, then it looks to me, right, that's pretty convincing.
So Woody's testimony may come back and actually help the prosecution, while Mr. Short has said that he could have been the person who committed these heinous acts, but they never charged him with anything. As a matter of fact, not only did he not get charged in this indictment, but the pending case that he had involving a false claim made about one of the jail officials spraying them with some kind of mace.
Right.
Let's look at the video, proved that it didn't happen. So they had that case on him, and he learned in the trial that case was pretty much dropped.
Right. Right.
So he has incentive to help the prosecution.
He does.
You know?
And it really depends on how much credibility they give any part of his story. Maybe they disregard all of his testimony, because without it, there's really nothing else linking. I mean,
he's the strongest piece of evidence that they have.
The video in the gas station is suspicious.
Yeah, it is.
It's it's one of those things that make you say, what's happening right here? What is going on? And then with her filling in the narrative, it's not implausible.
I mean, she made a good point. Why are you hanging in the gas station for 30 minutes? You're not
getting gas.
You're not getting gas. You're not having, sometimes we hang,
Right.
I don't block pumps when I come in.
I don't, but right. If you're just gonna hang at the gas station, or you just waiting for someone, why are you blocking the pump? I wouldn't block the pump. Yes, I was at the gas station yesterday. It took too long. The guy behind me was beeping and so on like a crazy person. I was like, well, Jesus, relax. Right? You can't block the pump for too long. Somebody gonna pull up.
So she appealed to the jurors' common sense in that instance.
Right.
Because it's not something that people would normally do. So hey,
right. And the fact that's the physical evidence recovered matched the guns that were discussed.
Yeah.
He said 45 and an AK and 45 shell casings and AK shell, according to
that's
damning summation.
Yeah, that's pretty damning.
That seems pretty damning.
Right, because how would he know what they recovered? Are you saying that
unless Max Shart's argument is he knows all of this because he's the one who's responsible for all of this, and it's not anyone else?
Yeah, that could be a possibility too, but you have several guns there.
And what about the conversations in the songs? It doesn't help. You know what I mean? It doesn't help.
And the jurors are going to ask these kind of questions. They're not just disregard, because they like one side versus the other. They're going to look at the evidence.
No, they are going to look. They're going to look through the evidence, and they're going to question why people would do these things and come up with different explanations. Some of them consistent with innocence, and some of them consistent with guilt. And then they have to determine whether or not there's enough reason to doubt that these are the people responsible for these crimes. And you only need one reason. And if your one reason is that because Woody did it, that's only getting you out of a few of those counts. That doesn't get you out of all of the counts.
Right. In the gang participation, you have a gang charge there. That's going to be hard.
If they consider Woody, and I don't know if this argument was made, an unindicted co-conspirator, then whatever he did, they're responsible for it too. Mm-hmm. So if Max Shart's argument is it was Woody, then if I'm Hilton, I'm going to say, well, if it was Woody, they're responsible for that too, because he's YSL, and so are they. Right? This is a conspiracy.
But that wasn't. I get your point, but that wasn't an argument.
But that's fair comment, is it not?
Yeah, it is.
That's fair. That's a fair response to the defense's argument, right? Because Woody did admit he was YSL. And you have a conspiracy charge. That's fair comment to make the argument. I would have made it.
I saw a clip of an interview that he did with someone, and someone had said something to the effect, and you guys in the comment section might have seen the clip as well. And someone asked him, they said, "You killed this person." He said, "Prove where I killed. Show me where I killed two people at, or show me." So he said two people, and the person was talking about one person. It was something weird when like, dude, are you confessing?
It's like an
again.
unnatural. It's an unnatural response.
Right.
Yeah.
And
Yeah.
he corrected himself, but even then, he's still not indicted on anything, which is
That's okay. You can be an unindicted co-conspirator.
and nothing to say he won't be indicted down the road either. Down, 6 months
That's
from now,
true too. That's
know?
that's absolutely possible.
because there's no statute of limitation for murder.
Yak was the lookout in the Pontiac. Jayhawk said, right. So that's I think I said earlier. I think they said he was he driving as the lookout? I believe that he was driving, but in any event,
Well, the lookout's still a part of
the lookout is equally guilty is equally as guilty as any other participant in accomplice liability legal theory.
and this may come out in the jury instructions, but what do you think the jurors would glean from not seeing the other defendants in the courtroom? Because they all for almost a whole year they saw Nichols, they saw Mr. Williams, they saw Mr. Huey, they saw Mr. Ryan. They saw these.
I'm sure that the court is going to re-instruct them, as the court has already instructed them, that they are not to consider where those defendants are, why they're not here. They're not to speculate as to where they are, and they are not to draw any negative inference against the remaining defendants because those defendants are not here. Now, whether or not those people watch the news or have social media, what's the odds that they don't already know?
Right. Yeah.
That those other people pled guilty? And what's the odds that they can compartmentalize that in their minds and say,
well, they're guilty.
Exactly. And they admitted their guilt.
Yeah. And no, the fact that Doug took a plea and that if the jurors know that Doug took a plea and
they know. How do they not know? How do they not know?
That's where the problem's gonna come in for
the news.
Right. The fact he took a plea, they were like, wait a minute. So if the guy we didn't think was that culpable, it took a 40-year plea. Yeah, these guys are probably guilty. They're just, they. Yeah.
Now I don't know if Max Shark did he say, listen, even if you think our client is probably guilty, that's not enough.
He said something about the gang, something toward as related to the gang being
Did
involved.
He say probably though? You have to hit that shit straight on. Because that jurors probably think that. So just address it to him. Address it with him. You might be sitting there and you might think he's probably guilty. And I'm going to submit to you, ladies and gentlemen, that's not enough for you to find him guilty, even if you think he probably is. The law doesn't allow it. That's what you have. The law does not permit it. And you are not allowed to do that. And I'm going to ask that you hold yourself and your fellow jurors to the standard. Like, you got to hit them right on the head. And I don't know if that was said. So, what happens is jurors get back there and they don't know what to do with the feelings of probable guilt because you didn't address it with them. I'm going to write a book. I should write a book. I got so many jewels.
Yeah.
I got so many jewels. Man.
We need to do a collaboration.
For real. For real.
Just the last 10 years. Oh my God. It seems like about 10 years. It seems like it's long.
I feel like 10 years. I feel like it's more than that. I feel like it's been more than that. Time goes by fast. It does.
Yeah.
It does.
Like you just want to say I'm mad. Okay, you better be. You better be, Jacques. You better be. I don't bring the best on.
Thank you. Appreciate you.
I'm like Doug Weinstein. He said, I'm gonna steal something from Max. Something about I'm gonna steal this quote from Max Shard.
Only steal from the best.
Only steal from the best.
Yeah,
right.
I saw that. That's what's up.
How do you say someone is guilty off of a reasonable doubt?
How do you say someone is guilty off of reasonable doubt?
Well, that's too.
I don't understand the question.
Well, you may have reasonable doubt. They may not. They may believe he's guilty. So the reasonable doubt, I think how do you say? Well, what?
So I think, well, first, I think people don't understand the standard,
Right.
right? Reasonable doubt is a when you have doubt and you have a reason for that doubt. That's it. It's not some super technical term.
Right.
Now, the reason that you have has to be grounded in the evidence or lack thereof. Right? The reason can't be based on speculation or sympathy or concern for the outcome or the punishment that might be a result of your decision. Right? That can't be, none of those can be the reason.
Right. So
there has to be an articulable reason for which you can explain, you can put your finger on it. This is why I don't believe that this person is responsible for this act.
So I'm listening, I'm reading what Wiggs is saying. So the jurors in their the jurors are the ones who are going to decide if they have reasonable doubt. And if they had said, if all of them say that it's reasonable doubt.
No. The jurors, if the defense did this properly, and I didn't watch all of their, the jurors should be starting from innocence. They should be starting from the presumption of innocence. If they go back there, their immediate vote, right? If I would have ended like this, ladies and gentlemen, if you had to vote right now, your vote would have to be not guilty because you haven't deliberated and you haven't been convinced beyond a reasonable doubt. So the evidence has to convince you. It has to be so convincing that you would apply this quantum of evidence in a matter of importance in your own life, that you would take a detective Viverito if your child was missing and you would rely on that detective. Right? That's you have to be so convinced by the evidence that you abandon the presumption that this defendant is afforded. I would argue that you can't be convinced. You can't be that convinced, right? That's the argument to make from the defense side. From what I was arguing before is from the prosecution side, because we were talking about Hilton, right? From the prosecution side, and whether or not, if you are countering what Max Shard said about Woody's testimony, he's the one who did it, right? Then that's the counter I would give. But listen, I don't know if the defense did what I that little dramatic reinterpretation of how I would have did my summation. You know what I mean? I don't know if they did that. Maybe we should have did it 3 days ago so they could have got a little piece. I don't know. If you really want to steal, okay. I'm not gonna. That's all I'm gonna say. That's all I'm gonna say.
Max Shard. Okay. This is.
But that jurors often don't understand how to work in the jury room, and so that would have been the last thing I said. My last bit of my summation would have said. Now, when you go back in that jury room, ladies and gentlemen, or I would say, now when I sit down, I'm not going to be able to speak to you again because Miss Hilton is going to have the last word, and they get to have the last word. They have the verdict. He said that. Okay, yeah. That's standard. That's standard.
Yeah, Weinstein definitely said that.
Okay,
and it's so.
But did they say about how they should be looking at the evidence, and did they say any of that? Well, I didn't get to watch it, but hopefully they did, or at least they said something to that effect. Because when I talk to jurors after the fact, they often think that they often are deliberating in the reverse, right? So they're looking for innocence. They're looking for, and that's not what you should be doing. He's already innocent. He's already presumed innocent. You're working backwards.
Yeah. They're looking for it. They should go in.
They should go in with the presumption of innocence. Exactly. Throughout the trial, you have to remind jurors that your client is presumed innocent.
Right.
Unless and until you are so convinced. And then I would tear that evidence up like you can't possibly be convinced by this. You can't.
I think Judge Whitaker did a better job in making sure that that messaging was clear to the jurors versus Glanville.
Okay.
I do commend her for that, even though she took a shot at me. I'm salty. I'm still salty.
I get
I'm
it.
still salty, but
I get it. I get it. I dig it.
I don't
I
want to
dig
take
it.
it to the place.
I
It's
can
like
dig it.
I think about the old Abbott and Costello. It was Abbott and Costello where slowly I move inch by inch. He starts reading. Don't remind me of that part.
I don't know that.
I want to give her credit.
I don't know.
I went in the courtroom yesterday. She was staring me down. She looked as soon as I walked
Yeah.
in. I mean, it's like, Judge, it's everyone in the room. Why are you so like holding on? And I'm like, this is what you. When you looking at me, I'm looking at you.
You ain't give her the. You should have gave her the heads up.
I swear I did it. If she looked
You
at me,
did. What's up? I'm good for the head nod, brother. What's up, Judge?
she like, yeah. So you still came back, huh?
She would have liked that, you know. I think. Let me not say too much on here, but
No, we're gonna be good.
I want to get in trouble. The other defendant, Qua, was able to get his murder charge deleted. He was in the second vehicle. Both cars were party to the deletion. Why was he allowed to walk on that charge? Because prosecutions are selective.
Right.
Prosecutions are selective, and there is no requirement that anyone be charged with anything. Prosecutors are allowed to pick and choose who they want to charge and what they want to charge with very little oversight, almost with no oversight. Let me keep it a buck, with no oversight, right?
No.
And it's not a mystery why the prisons are disproportionately filled with Black and brown bodies. It's not a mystery when most of the prosecutors are not Black or brown, and they get to select who they'd like to prosecute. The police get to select who they'd like to police.
Facts.
And historically, their purpose is to police Black and brown bodies. So who do you think that they're arresting disproportionately? Black and brown people. These statistics aren't just numbers. Right? That's what sickens me, because the numbers are the numbers because people made them the numbers, right? Somebody had to do something for there to be the numbers. There are people behind the numbers doing this, right? And all too often, anyway, that's your answer. That's the short answer. Okay. That's the short answer, because prosecutions are voluntary.
But Wiggs, listen, Wiggs, I appreciate I do appreciate you coming in, and she's, you got a professor here, so you might plug
Remember
up.
Judge Tracy Hunter, who was dragged out of court. That prosecutor had more power than the judges and messed her whole career up. Yeah,
I remember Tracy Hunter.
Nobody is safe. Nobody is safe. Nobody is safe. And when people get too comfortable, that's typically when they come for you. when you start getting too comfortable, that's typically when they come for you.
And let's be honest. We had another judge in
Fulton County, right? Recently.
Well, I'm talking about the judge who got removed. She was the judge who actually lost a judgeship.
That's the one that was at the club, or is that Tracy Hunter?
No, that's the one who was at the club.
What's her name?
Oh my goodness. You know her name. Just supposed to judge's name in.
Save him, y'all. Will y'all save him? Thank you, Wiggs and Wine.
You know what judge I'm talking about. The judge from Douglas County, the probate judge.
Yes, I remember the video when she injected herself into
Judge
something.
Judge Christina.
Yeah, okay. She was trying to help, or allegedly trying to help someone, another patron or a woman who was assaulted. I don't know.
Yeah, there was assaulted. Do you know that club was actually closed down? They went out of business
after that?
2 weeks afterwards.
Wow.
Yeah,
They didn't want that smoke.
Well, they had other issues.
Yeah, I'm
And-
sure.
and
And I'm
obviously-
sure the attention didn't help. Whatever
it-
other issues they had, I'm sure having that attention around didn't help none.
It didn't help. Someone said,
No.
Doug saying the defense will not be calling witnesses because they don't feel it is necessary was strategic and smart. Okay, hold on. He's back. Judge is back in. Hold on. And they're still looking for law, and the jurors are there. And
It's a lot. The charge, it's a lot. It's a lot of charges. And then they're not in every count. So I don't know if they're, making some type of concession to not read the counts. They're not in.
Main cases, United States versus Elliott 571, F2nd 880, it's a former Fifth Circuit case. Elliott dealt specifically with the question where the defendant argued that acquittal on a
well, they got Yacht Gotti looking like a gentleman and a scholar.
required acquittal on RICO conspiracy. And the court said no, it did not.
Yeah, that's not.
It's an often, it draws the distinction, but that being said.
So what's happening now? That she doesn't want to.
Yeah, hush.
Forwarded to us,
Okay.
and think that there, for the vast majority of these, there may be a pretty simple direct workaround that addresses the issues.
Okay. Well, I'm
Okay,
sure we need to
they
decide
go ahead,
before
Dennis,
the
sorry.
jury charges anyway.
Hold
So.
on.
All right. Anything else then? Otherwise, I'm going to have the jury out and go ahead and charge them.
Uh-oh. Dum-dum-dum.
All right, let's get the jury out.
All right. Why they coming? I'll answer that question, Patrice. It could go both ways. One, the jury is extremely tired, and I don't know if they would have had the patience or tolerance for defense witnesses who didn't have something substantive to add to this trial, right? The other side is when you put witnesses on, you tend to open the door to burden shifting, where if the jurors don't believe your witnesses on the defense, then by default, they just vote for whatever the prosecution has slapped on the wall because they don't believe you. So there's the potential of you shifting the burden when you put a case on. So that's part of the strategy. The other side is we don't think that there's anything for us to put a case on about because that prosecution case is so weak, right? And so, you're signaling to the jury that the case is weak. So,
All right. So what I'm going to do is I'm going to put the screen up real quick. I know jurors are coming in, so I'm going to put this here real quick, Ike.
mhm.
And let's go. All right, ladies and gentlemen, the jurors are in the courtroom, and we are here live well, not inside the courtroom, but we're here live, waiting for the judge to give her jury instructions, which will be a long day. Judge has a mic off. It's not me. Ike, can you hear me?
Yeah, I hear you. I don't hear her.
Yeah. So why did they turn the sound off in the courtroom? It is not us.
Hmm.
Okay. Okay. Did someone let me text law and crime? Tell them turn the sound on. Judge, your sound is off, Judge. It's not us, ladies and gentlemen. Okay, hold on.
The beginning is the general principles of our law.
Yeah, let me.
Violation of the
There you
Georgia
go.
Controlled Substances Act. 61, possession of a firearm during the commission of a felony. And 63, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. Mr. Stillwell has been indicted for counts 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act. 2 and 49 are counts of murder. 50, participation in criminal street gang activity pursuant to subsection 1 of that statute. 51, participation in criminal street gang activity pursuant to subsection B of that statute. 2 counts of possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm in counts. Those are counts 52 and 64. And then count 54, which is possession of a firearm during the commission of a felony. You will have a copy of the indictment with the relevant charges with you during your deliberations. Each defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The instructions that I give you will apply to each defendant individually. So when I say the defendant or a defendant, the instruction applies equally and separately to each defendant. Further, your determination of the issues set forth in the verdict forms must be made as to each count and as to each defendant individually. A defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is
Max Shard
beyond a
looking like
reasonable
I
doubt.
should have said that in
The
my
burden of
summation.
proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It's a reasonable doubt is the doubt of a fair-minded and impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt. It's a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence.
Oh, somebody just told y'all that.
After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If after considering the evidence, you believe beyond a reasonable doubt that a defendant is guilty of an offense alleged in the indictment, you would be authorized to convict the defendant of that offense. If the state fails to prove the defendant's guilt of an offense beyond a reasonable doubt, it would be your duty to acquit the defendant of that offense. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged or that merely raise a speculation or conjecture of the defendant's guilt are not sufficient to authorize a conviction of the defendant. Your oath requires that you will decide this case based upon the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes the testimony of the witnesses, the exhibits admitted during the trial, and any stipulations of the attorneys, which are facts to which the attorneys have agreed. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. The parties have entered into stipulations about certain facts, and these 4 stipulations are marked as joint exhibits. Where parties stipulate facts, that is in the nature of evidence, you must take that fact or those facts as a given without the necessity of any further proof. You make all decisions based on the evidence in this case. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and to reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. There's no legal difference in the weight that you may give to either direct or circumstantial evidence. Direct evidence is is that which can be seen or heard or otherwise directly sensed. It may be brought into court in the form of exhibits or the testimony of a person who asserts that he or she has actual knowledge of a fact by personally observing or otherwise witnessing that fact. It is evidence that points immediately to the issue in question. When direct evidence points by inference to an obvious, likely, or reasonable conclusion, even though that conclusion is not directly observed or otherwise sensed, that's said to be circumstantial evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that tends to prove or disprove another fact by inference, that is, with consistency with such a fact or elimination of other facts, or that only tends to establish a conclusion in question by its consistency with such conclusion or its elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence alone, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or a greater degree of certainty on the part of you, the jury, to return a verdict based on circumstantial evidence than upon direct evidence. There's no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for you, the jury, to decide. And whether it's dependent upon direct or circumstantial evidence or both, the true test is whether there's sufficient evidence, whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. You, the jury, must determine the credibility of the witnesses. In deciding credibility, you may consider all of the facts and the circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or their lack of interest in the case and the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are witnesses who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it's properly entitled to receive. In determining the credibility of a witness, you may consider, where applicable, evidence offered to attack or challenge the witness's credibility, and this may include evidence of a character for untruthfulness, bias toward a party, or felony criminal convictions. In determining the credibility of any witness whose credibility has been attacked or challenged, as I've described above, and any testimony given by him or her in court, you may consider, where it's applicable, evidence offered to support the credibility or believability of such a witness. The credibility of a witness may also be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony that the same witness gave before the trial started. It's for you to decide whether there's a reasonable explanation for any inconsistency in a witness's pretrial statements or testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. In assessing the credibility of a witness, you may consider any possible motive in testifying if that is shown. In that regard, you are authorized to consider any possible pending prosecutions, negotiated pleas, grants of immunity or leniency, or similar matters. You alone shall decide the believability of all of the witnesses. The testimony of a single witness, if believed, is generally sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. An exception to this rule is made where the witness is an accomplice. The testimony of an accomplice on its own is not sufficient to warrant a conviction. An accomplice's testimony must be supported by other evidence of some type, and that evidence must be such as would lead to the inference of the guilt of the accused, independent of the testimony of the accomplice. It's not required that supporting evidence be sufficient to warrant a conviction, or that the testimony of the accomplice be supported in every material particular. The supporting evidence must be more than that a crime was actually committed by someone. It must be sufficient to connect the accused with the criminal act, and must be more than sufficient to merely cast upon the accused a grave suspicion of guilt. Slight evidence from another source that connects the accused with the commission of the alleged crime and tends to show participation in it may be sufficient supporting evidence of the testimony of an accomplice. In order to convict, that evidence, when considered with all of the other evidence in the case, must be sufficient to satisfy you beyond a reasonable doubt that the accused is guilty. The testimony of one accomplice may be supported by the testimony of another accomplice. Whether or not the testimony of one accomplice does in fact support the testimony of another accomplice is a matter for you to decide. The sufficiency of supporting evidence of an accomplice is a matter solely for you to determine. Whether or not any witness in this case was an accomplice is also a question for you to determine from the evidence in this case. Any out-of-court statements made by one of the defendants on trial in this case after the alleged criminal act has ended may be considered only against the person who made the statement, and only if you find such statement was freely and voluntarily made. If you find that an out-of-court statement was made to the police freely and voluntarily by a defendant on trial in this case, then you are to consider the statement only against the particular defendant who made it. A defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. However, a defendant does not have to present any evidence nor testify. If a defendant chooses not to testify, you may not consider that in any way in making your decision. Sometimes evidence is admitted for a limited purpose or against some parties and not others, or for some counts and not others. I have previously instructed you as to how to consider particular evidence that was limited over the course of this trial. Such evidence may be considered by you only for the sole issue or purpose, or against only the party, or only for the counts for which that evidence was limited, and not for any other purpose or against any other defendant or for any other counts. You have received evidence of certain prior convictions of these defendants as well as certain other witnesses in this case. You may consider the conviction of Mr. Kendrick only against Mr. Kendrick and only as to count 1 and as to the required element of being a convicted felon in count 63. You may consider the convictions of Mr. Stillwell only against Mr. Stillwell and only as to count 1 and as to the required element of being a convicted felon in counts 52 and 64. You may consider the convictions of any witnesses only insofar as they may relate to attacking the credibility of that witness and not for any other purpose. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all of the factors previously charged to you regarding credibility of witnesses. In addition, some but not all of the factors you may consider in assessing the reliability of any identification are the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident, the possibility of mistaken identity, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have had, whether the witness on any prior occasion did not identify that person as the alleged perpetrator, and the length of time between the crime and the out of court or any out of court identification. It's for you to say whether under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify someone beyond a reasonable doubt as the alleged perpetrator or a party to an act. It is not necessary that the defendant show that another person committed the alleged act. The burden of proof never shifts to the defense. Defendants are charged with crimes against the laws of this state. A crime occurs when a law is violated by a defendant's intentional action. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided that you, the jury, believe it existed from the facts proven before you. It may be inferred from the proven circumstances or by acts and conduct, or it may, in your discretion, be inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a criminal statute, but it simply means the intention to commit the act that is prohibited by a statute. A defendant will not be presumed to have acted with criminal intent, but you may find such an intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. Whether or not you make any inference or inferences such as that is a matter solely within your discretion as the jury. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person directly commits the crime, intentionally helps in the commission of the crime, or intentionally advises, encourages, hires, counsels, or procures another to commit the crime. A party to a crime who did not directly commit the crime may be prosecuted for commission of the crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted, has been convicted of a different crime or degree of crime, is not amenable to justice, or has been acquitted. Knowledge on the part of the defendant that the crime of murder, that's counts 2 and 49, possession of marijuana with intent to distribute, count 58, or possession of a firearm, counts 52, 54, 61, 63, and 64, was being committed, and that the defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt in order for you to convict on those counts. If you find from the evidence in this case that the defendant had no knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts that I just referenced was being committed, or that the defendant did not knowingly and intentionally commit, participate in, or help in the commission of the alleged offense, then it would be your duty to acquit the defendant of that count. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts I just mentioned was being committed, and that the defendant knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict the defendant of that count. You are not authorized to find a person who is merely present at the scene of the commission of a crime at the time it was committed guilty of consent in and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in its actual perpetration of the crime, or participated in the criminal endeavor. You are not authorized to find a person who is merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of a crime, unless the evidence shows beyond a reasonable doubt that the person helped in the actual perpetration of the crime or participated in the criminal endeavor. Next, I'm going to define for you the elements of the crimes that are alleged as counts against either defendant. Then I will define the meaning of any crimes that are alleged as an overt act, but that I have not yet defined. When a count of an indictment charges that a defendant committed a crime in more than one way, the state does not need to prove that the defendant committed the crime in every one of the ways alleged. The state may prove that the defendant committed the crime in any one of the ways charged. If the evidence shows that the crime was committed by the defendant in any one of the ways charged, you would be authorized to convict him of that count. And RICO is one of the counts that is charged as having been committed in more than one way. In order to convict, the state must prove that the crime was committed by the defendant in at least one of the ways charged. For conspiracy to violate subsection A of the Racketeer, Influence, and Corrupt Organizations Act, which I'm going to refer to from now on as the RICO Act, the state must prove that the defendant knowingly and willfully conspired with one or more others, co-conspirators, to acquire or keep money or other personal property through a pattern of racketeering activity, and that any of the co-conspirators committed an overt act after May 10th of 2017 to further a criminal objective of the conspiracy. For a conspiracy to violate subsection B of the RICO Act, the state must prove that defendant, while associated with an enterprise, knowingly and willfully conspired with one or more others to participate in the enterprise through a pattern of racketeering activity, and that any of the conspirators committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. Conspiracy means an agreement between at least two people to commit an unlawful act. The agreement may be express, that is, stated or written, or it may be tacit, that is, a mutual but unspoken understanding to accomplish or to pursue a common criminal objective. The existence of a conspiracy may be inferred from the nature of any acts done, the relationships, interests, or conduct of the alleged conspirators before and after any alleged offense, and other circumstances which may disclose a common criminal design. However, mere association with an enterprise is insufficient by itself to establish a conspiracy to violate the RICO Act. The state does not need to prove that each conspirator agreed with every other conspirator, knew all of his fellow conspirators, was aware of all of the details of the conspiracy, or contemplated participating in the same interrelated crimes as every other conspirator. Whether a conspiracy existed is a matter for you to determine. Overt act means an outward act made in furtherance of a conspiracy. The overt act may, but does not have to be, a crime in and of itself. Some of the overt acts alleged in this indictment, if proven, would be crimes. You can tell which those are when you have the indictment back with you, because they will list a cite to a criminal code section. Later in these instructions, I will define for you alleged crimes that are alleged in the overt acts that I have not already defined when I'm defining the substantive counts. Enterprise means a group of individuals who are associated in fact, whether or not all of the members know each other. To be an enterprise under the RICO Act, the group must have a common purpose and ongoing nature sufficient to pursue its purpose or purposes, and at least a loose or informal relationship amongst those involved. The group does not need any form or structure beyond what is necessary to conduct a pattern of racketeering activity. The group may be associated together for both legal and illegal purposes. In determining whether an enterprise existed, you may consider any evidence of a pattern of racketeering activity. When people conspire together in an unlawful enterprise, any act done by any of the conspirators to further the unlawful enterprise is considered to be an act of all of the conspirators. However, each conspirator is responsible for the acts of other conspirators only to the extent that those acts are naturally or necessarily done to further the unlawful enterprise. If you find that the defendant did not knowingly and willfully join a conspiracy as described above, then you cannot contribute the statements or acts of another person to the defendant. Racketeering activity means committing or attempting to commit any of these crimes: murder, attempted murder, aggravated assault, aggravated battery, theft by receiving stolen property, armed robbery, terroristic threats, use of an item with an altered identification mark, possession of a firearm during the commission of a felony, possession of a machine gun, possession of a firearm by a convicted felon, possession of a firearm by a first offender probationer, possession of a weapon by an inmate, possession of a cell phone by an inmate, possession of codeine with intent to distribute, possession of hydrocodone with intent to distribute, possession of marijuana with intent to distribute, possession of MDMA with intent to distribute, possession of methamphetamine with intent to distribute, possession of cocaine, or possession of oxycodone. I will define these crimes for you shortly. Racketeering activity also means any act or threat that involves murder, robbery, theft by receiving stolen property, or dealing in narcotic or dangerous drugs. A pattern of racketeering activity means engaging in at least 2 acts of racketeering activity within 4 years of each other in furtherance of one or more interrelated incidents, schemes, or transactions. Interrelated here means acts that have the same or similar intents, results, accomplices, victims, or methods of commission, or that are otherwise interrelated by distinguishing characteristics and that are not isolated incidents. The criminal objectives of the conspiracy alleged here are preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder, assault, and threats of violence, obtaining money, weapons, or other property through acts of racketeering activity, including robbery, theft, and the unlawful sale and distribution of drugs, and obstructing law enforcement investigations and court proceedings through witness intimidation and attacks upon law enforcement officers. A person commits the offense of violation of the Georgia Street Gang Terrorism Prevention Act, which I'm going to refer to from now on as the Gang Act, when that person, while associated with a criminal street gang, commits a crime that constitutes criminal gang activity. To prove a violation of subsection A of the Gang Act, as alleged in counts 50 and 57, the state must show the existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity, and a nexus, that is a connection between the crime committed and the gang, i.e. that the crime was committed to further the interests of the gang. To prove a violation of subsection B of the Gang Act, as alleged in count 51, the state must show the existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity in order to maintain or increase his status or position in the gang, and again, a nexus or a connection between the crime charge and the gang. That is, that the crime was committed to further the interests of the gang. Criminal street gang means any group of 3 or more persons associated together which engages in criminal gang activity. The existence of criminal street gang may be established by evidence of a common name or common identifying signs, symbols, tattoos, graffiti, or attire, or other distinguishing characteristics, including but not limited to common activities, customs, or behaviors. Criminal gang activity means the commission, attempted commission, conspiracy to commit any criminal offense that involves violence, possession of marijuana with intent to distribute, possession of a weapon, or use of a weapon. For purposes of count 50, 51, and 57, which are the gang counts, murder, possession of marijuana with intent to distribute, and possession of a firearm during the commission of a felony constitute criminal gang activity. For malice murder, the state must prove that a defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice where there does not appear to be significant provocation and all of the circumstances of the killing show an abandoned and malignant heart. The state does not have to show premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state may, but does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For possession of a firearm during the commission of a felony, the state must prove that a defendant had a firearm on his person or within arm's reach of his person while committing a felony, which is one of the following: a crime against or involving another person, or a crime involving possession of marijuana with intent to distribute. Murder and possession of marijuana with intent to distribute are felonies, and for purposes of this offense, a firearm includes any handgun. The indictment charges each defendant with possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. I am not going to charge you on that crime because the state concedes that the description of the crime in the relevant counts of the indictment left out an element of either the defendant having previously been convicted of a felony of the defendant having previously been convicted of a felony involving the use or of possession of a firearm. That should be or. So you will be considering only the lesser included offense of possession of a firearm by a convicted felon when you get to those counts. And for possession of a firearm by a convicted felon, the state must prove that the defendant possessed a firearm after having been convicted of a felony. Possession of a firearm during the commission of a felony and possession of a firearm by a convicted felon are both felonies. And again, for purposes of this offense as well, a firearm includes any handgun. For possession with intent to distribute marijuana, the state must prove that the defendant possessed any amount of marijuana with intent to distribute. Intent to distribute means intent to unlawfully deliver or sell. Marijuana means all parts of the plant of the genus cannabis, whether growing or not, the seeds, the resin extracted from any part of the plant, and every compound, manufacture, salt, derivative, mixture, or preparation of such plant, its seeds, or its resin. Marijuana does not include the completely defoliated mature stalks of such plant, fiber produced from such stalks, oil or cake, or the completely sterilized samples of seeds of the plant which are incapable of germination. And it does not include hemp or hemp products, and it does not include samples of tetrahydrocannabinols or THC. The state must prove that the defendant possessed the marijuana and or the firearm at issue in this case. Possession may be either actual or constructive. It also may be either sole or joint. Actual possession means that at the time of the alleged offense, the defendant knowingly had direct physical control over the marijuana or over the firearm, depending upon which count you're considering. Constructive possession means that at the time of the alleged offense, the defendant did not have direct physical control over the marijuana or the firearm, but did knowingly have both the ability and the intention to exercise control over the marijuana or the firearm. Sole possession means that only the defendant had possession of the marijuana or the firearm. Joint possession means that the defendant shared possession of the marijuana or the firearm with at least one other person. If you find that someone other than the defendant had an equal opportunity to possess the marijuana or the firearm, you would be authorized to convict the defendant only if the state proves that the defendant knowingly possessed the marijuana or the firearm. And I'm now going to define for you any alleged crimes that are alleged in the overt acts that I have not already defined in the substantive counts. So the following definitions apply only to certain acts that are alleged in count 1 of the indictment as overt acts. Aggravated assault with a deadly weapon. For aggravated assault, the state must prove that the alleged perpetrator assaulted another person with a deadly weapon. Assault means to commit or to attempt to commit a violent injury on the person of another. And to prove assault, the state doesn't have to prove the other person was actually injured. However, the state must prove that the alleged perpetrator attempted to cause a violent injury to the person. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. Aggravated battery. For this crime, the state must prove that, for aggravated battery, the state must prove that the alleged perpetrator maliciously caused bodily harm to another person by seriously disfiguring a part of the body. In deciding whether or not an alleged perpetrator acted maliciously, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the resulting bodily harm without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the particular bodily harm may result. For armed robbery, the state must prove that the alleged perpetrator took another person's property from the immediate presence of the other person by using an offensive weapon and with the intent to commit theft. An offensive weapon is an object that's either likely to cause or actually does cause death or serious bodily injury if it's used against someone. Conspiracy to commit murder. A person commits conspiracy to commit murder when that person conspires with one or more others to commit the crime of murder. Murder has been previously defined. Criminal attempt. A person commits criminal attempt to commit a crime when, with the intent to commit that crime, the person performs any act that constitutes a substantial step towards the commission of the crime. Criminal gang activity has been previously defined. Criminal use, a person of an article with an altered identification mark. A person commits the offense of criminal use of an article with an altered identification mark when he possesses a firearm from which he knows that the manufacturer's serial number or any other distinguishing number or identification mark has been removed for the purpose of concealing or destroying the identity of that article. Possession of a firearm by a convicted felon has been previously defined, but in addition, with regard to that offense, possession of MDMA with intent to distribute, possession of cocaine, and robbery are felonies. Possession of a firearm by a first offender probationer. For possession of a firearm by a first offender probationer, the state must prove that the alleged perpetrator possessed a firearm while on probation for a felony as a first offender. Robbery and criminal damage to property are felonies. Possession of a firearm during the commission of a felony has been previously defined, but in addition, for these overt acts, possession of codeine with intent to distribute and possession of cocaine are felonies. Possession of a machine gun. The state must prove that the alleged perpetrator possessed a machine gun during the commission of any of the following offenses: participation in criminal street gang activity, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, and possession of cocaine. A machine gun means any weapon which shoots or is designed to shoot automatically more than 6 shots without manual reloading by a single function of the trigger. Possession of controlled substances. For possession of cocaine or oxycodone, the state must prove that the alleged perpetrator possessed any amount of cocaine or oxycodone, both of which are controlled substances. Possession with intent to distribute. For possession with intent to distribute codeine, hydrocodone, marijuana, MDMA, or methamphetamine, the state must prove that the alleged perpetrator possessed any amount of marijuana or any amount of codeine, hydrocodone, MDMA, or methamphetamine, which are controlled substances, with intent to distribute. And intent to distribute means intent to unlawfully deliver or sell. Sale of marijuana. For sale of marijuana, the state must prove that the alleged perpetrator sold any amount of marijuana, and sell here means to transfer marijuana in exchange for money or anything else of value. Possession of a weapon by an inmate. For possession of a weapon by an inmate, the state must prove that the alleged perpetrator, while an inmate, possessed an unauthorized weapon. For possession of a telecommunication device by an inmate, the state must prove that the alleged perpetrator, while an inmate, possessed an unauthorized cell phone. Conspiracy to possess a telecommunication device by an inmate. A person commits conspiracy to possess an unauthorized telecommunication device by an inmate when that person conspires with one or more others to commit the crime of possession of a telecommunication device by an inmate. For terroristic threats, the state must prove that the alleged perpetrator threatened to commit a crime of violence and that the threat was made. Theft by receiving stolen property. A person commits theft by receiving stolen property when that person receives or keeps stolen property and the person knows or should have known was stolen, unless the property was kept or received with the intent to restore it to the owner. Knowledge on the part of the alleged perpetrator that the property was stolen, or evidence sufficient to show beyond a reasonable doubt that the alleged perpetrator had reason to know the property was stolen, is an essential element of this offense. Knowledge that the property was stolen may be shown by circumstances that would excite suspicion in the mind of an ordinary person. The burden is on the state to prove beyond a reasonable doubt that the alleged perpetrator had knowledge, or under all the circumstances should have had knowledge, that the property in question was stolen and was in the alleged perpetrator's possession. All right, that's it for the overt act crimes. All right, the law provides that criminal action shall be indicted and tried in the county in which the crime was committed. In a prosecution in any case in which it can't be determined that what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt it might have been committed. We don't have that here, do we? So essentially just the state must prove that the criminal actions alleged as counts in this case, that they have to be tried and indicted and tried in the county in which the crime was committed. So venue, that is that the crime was committed in a particular county, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment just as any other element of the offense. Venue may be proven by direct or circumstantial evidence or both. To prove venue for the RICO count, the crime is considered to have been committed in any county in which an incident of racketeering occurred or in which an interest or control of an enterprise or personal property was acquired or maintained. The defendants are each charged with certain offenses that are set forth in various counts of the indictment. Each count is a separate and distinct offense, and you must independently evaluate the evidence against each defendant and as to each offense. The fact that you reach a conclusion with respect to one offense or with respect to one defendant does not necessarily mean that the same conclusion will apply to any other charged offense or to another defendant. Each count of the indictment before you is separate and distinct. You must evaluate evidence as to one count independently from evidence of each other count. You must evaluate the evidence as to each defendant independently, and you must render a verdict as to each count and as to each defendant individually. If, after considering the testimony and the evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt the defendant in Fulton County, Georgia, committed an offense as alleged in the indictment, you would be authorized to find the defendant guilty of that offense. In that event, the form of your verdict for that offense would be to find the defendant guilty. If you do not believe the defendant is guilty of an offense as alleged in the indictment, or if you have any reasonable doubt as to the defendant's guilt of that offense, then it would be your duty to acquit the defendant of that offense. In that event, the form of your verdict for that offense would be to find the defendant not guilty. You are to make a separate determination of guilty or not guilty as to each offense and as to each defendant. Your verdict as to each count must be unanimous. That means that you must be unanimous in your determination that the state has proven every element of that count as defined and listed above beyond a reasonable doubt. And you'll have a copy of these instructions out with you so that you can see what each of the elements of each of the offenses is. Again, the elements are listed above where the crimes are defined, and you must be unanimous that each element has been proven. Let me explain what that means for a few of the elements for count one a bit more specifically. And that's the conspiracy to violate the RICO Act. You must be unanimous as to the pattern of racketeering activity that the defendant agreed would be committed. But because count one is charged as a conspiracy to violate the RICO Act, it's not required that the state prove that any conspirator actually committed an act of racketeering activity. And on the overt act element, you must be unanimous that a conspirator committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. And you would note on your verdict form that and any of other overt act committed in furtherance of the criminal conspiracy to which all 12 of you unanimously agree. By no ruling or comment that the court has made during the progress of this trial has the court intended to express any opinion upon the facts of this case, upon the credibility of witnesses, upon the evidence, or upon the guilt or innocence of either defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status for or against any party. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Talk with each other and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it's wrong. However, you should never give up an honest opinion simply to be congenial or to reach a verdict solely because of the opinion of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. And these rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous, that is, agreed to by all. The verdict must be in writing and signed by one of your members as the foreperson, dated and returned to be published in open court. During your deliberations, any communications from you to the court must be in writing, signed and dated by the foreperson, and given to a bailiff. And let me add that given that the evidence is closed, my ability to respond to questions may be limited. Evidence that was admitted by audio or video recording can only be played here in the courtroom, so any request to review or listen to that evidence again must be made in writing by you to the court, and then it'll be replayed in the courtroom. And that is the end of my instructions. I'm going to excuse you all to the jury room now to elect your foreperson. Don't begin deliberations until you have the indictment, the evidence, and the verdict forms and some copies of this charge out with you. And I'm going to ask jurors number 387, 409, 449, and 508 to hang back with me. And the rest of you can return to the jury room to elect your foreperson.
All rise for the jury.
All right, y'all are the alternates in the case. Considering the length of this trial, it was critical that we had alternate jurors in case we lost any jurors. And as I think y'all know, we in fact started with 2 more of you and lost 2 along the way. I don't know how long deliberations are going to take. And so it's possible that even now we may end up losing a juror or more. So y'all are still on jury duty. You're not going to be deliberating right now, but you continue to be under all of the instructions that have been applicable to you for the entirety of this trial. You cannot discuss this case with anyone. You cannot allow anybody to discuss the case with you. You cannot go now and look up any articles about this case or anybody involved in it. You can't look at any kind of social media or any other kind of accounts of this trial or anybody involved in the trial. Essentially, you're still on jury duty. I am going to, for the next hour or so, keep y'all around here. And Sergeant, maybe, I don't know, I'm sure there's probably another jury room that they can retire to. While y'all are on jury duty and the jury is deliberating, I want y'all to stay within an hour or so of this courthouse. If we're ever on a break, you know, we've got Thanksgiving break coming up. Obviously, y'all can go and do whatever your Thanksgiving break plans were because the jury's not going to be in session, court's not going to be in session, we're not going to be deliberating. But even when you're on those breaks and any others that might occur during the deliberation process, you still can't talk to anybody about the case or allow anybody else to talk to you about the case or look for any information in any way about the case. So essentially you remain on the same instructions, just when we're on break, you're on break too. When the jury is deliberating, I need y'all to be where, if we need you, we can get you within an hour, down here within an hour or so, okay? So for right now, y'all can go and grab your things. You can say goodbye. It's been great. I may see you again to your fellow jurors. And then we'll have you in one of the other jury rooms for a little while at least. And if I'm going to release y'all for the day, I'll let y'all know that. But again, just kind of stay within an hour or so of the courtroom. And just like you've sort of kept your cell phones in a way that we can communicate with you, continue to do that in case we need to. Thank you very much. Are there objections to the chart?
Just a few things that you noticed, Your Honor.
Okay.
Page 2, Your Honor.
On page 2? Okay.
When reading participation in criminal street gang activity for count 50, you said subsection 1 and not A. So I just wanted to
Hang
make
on
sure.
a second. Let me get there. Page. Where are you talking about?
So count 50, where it has participation in criminal street gang,
Yes.
you said section 1 and not A.
Okay. Do you want me to call them all back in and say I meant to say A, or they'll have copies of this out there and it'll be on the verdict form correctly?
Yes, Your Honor.
All right.
That's fine. I didn't know if I had something different than what you had, and so I wanted to make sure that what I have in front of me was correct.
Okay.
Only as to page number 9, when you, last paragraph, any out-of-court statement,
Hang on. Yes.
as we were reading it, the thought came that maybe we should add any out-of-court statement made to law enforcement, made to the police, made by one of the defendants on trial in this case after the alleged criminal act.
We probably should have.
So just,
I gave y'all this, I don't know how many different times to look at and ask you. I don't know how many different times for any kind of comments or corrections. So what do you want me to do?
can we add it, and then when you send it back,
Just, sure.
that's all, Your Honor. I'm just going back.
Made by one of the defendants, made to law enforcement by one of the defendants on trial?
Yes, Your Honor.
Okay, we can do that.
And as of right now, those are the only ones that I see.
All right, appreciate it. Thank you. Anybody else?
I have no objections to your reading of the jury charges, Your Honor. I just need to renew my request and objection to exclusion of jury charge 3.01.10, which is the justification, as I requested justification for my client's possession of firearm by a convicted felon. I requested that charge, so I'm just renewing my objection to the exclusion of that charge, as well as the separate and distinct charge that overt acts need to be proved. An overt act needs to be agreed upon unanimously by all the jurors. I know, Your Honor, stance that you referenced the need for unanimity, being unanimous. I always struggle with that word.
Okay.
Within the jury charges, and I understand that, but I'm just going to renew my objection.
Okay.
Thank you.
All right. Then we will, y'all have agreed as to what evidence goes out?
Yes, Your Honor, there is we're including a flash drive with a list of the exhibits, the Stillwell exhibits.
Okay.
And I thought it would be appropriate, and if it's not appropriate, please object. It's just a list of the exhibit numbers, because the flash drive is little, so we can't list them all. So we're printing on a piece of paper,
Okay.
and we're just going to attach the flash drive to the piece of paper.
Okay. And those don't go out. You're just saying you're listing them.
My understanding, well, they can't play them. My understanding is that all the media was going to go in the back room. They can't play it, but then they could ask if they wanted us.
Just so they'll have a list of what it is?
I'm not even proposing a list of what it is, as in what each exhibit is, but just that these are the exhibits that are on this flash drive. I'm not suggesting.
We don't normally send the actual media out with them.
Okay,
I mean, they
had
can,
this-
it's certainly in evidence and they certainly can consider it. They just would need to say, hey, you know, I'd like to watch the FedEx tape again.
Okay, my understanding, I had spoken to some members of the state about this. The understanding I had was that the media was going to go out, but of course they have no way to play it, but then they could request.
Okay, are they gonna even, if it all, for instance, goes out in a bin, are they gonna even know what it is? Like, are they all labeled? Yes? I mean, it's fine with me if that's the way y'all want to do it.
The only other thing we were going to ask to do, and I believe the Defense Council has an objection, we were going to send a legend out with the letters and what letter is associated with what act, so that they would know.
What
We
letters?
organized
I
them.
don't know what you mean by that.
So every act that we presented, so for example, VV was the Chamel Drinks homicide, so that they could know when they pick up a letter, what that was in reference to.
I'm going to object to that, to the state's kind of direction of compartmentalizing the evidence. And quite honestly, some of the evidence that was admitted under certain letters applies to certain other cases. I mean, these aren't distinct. I know that they're charged as distinct overt acts, but Walter Murphy testifies, for
Right.
instance, and he has things they admitted to Walter Murphy might have a WW, just for instance, but what he testified to involved different acts.
I mean, I think that as they were listening to the evidence, they could write down the number of the exhibit. So if they want to flip through their notes and say, you know what, I was really interested in 53 WW, then they can find that, or if it's media, they can ask to re-listen or replay it. I don't think that it's really appropriate to say, here's kind of the state schematic of the evidence. Okay. So have y'all otherwise agreed on what evidence goes out with them and what evidence doesn't?
So I've been presented some case law this morning and we've discussed it. I don't have any problem with the GBI reports going back. I know that was one bone of contention. I don't have any problem with the ME reports going back. We've been going back and forth about two issues, the CAD reports and the demonstratives. I'm objecting to both the CAD reports and the demonstratives going back.
Okay. You wanna?
I join in.
Okay. All right. Does the state feel that the CAD reports or the demonstratives should go out?
Yes, Your Honor, we have case law regarding demonstrative evidence.
Okay.
That demonstrative evidence does go back to the jury, and it's not a violation of the continuing witness rule.
Would you like to share that with the court?
Yes, Your Honor.
Okay.
The state will cite Ruffin v. State, which is 333 Georgia Appeal 793, which is a 2015 case.
Okay. And then how about the CAD reports? Is the objection, what's the objection to the CAD reports? Okay. And does the state have a position on that?
Your Honor, the state does not believe that the CAD reports are a violation of the continuing witness rule, and we are looking, I thought we had the case on point, but we are looking for that case as well.
Okay, so I do remember distinctly that in a federal case, the judge didn't allow the monstrous evidence to go back to the jury deliberation room. And I want to say this was it was a civil case involving the blogger Tasha K. Also, guys, did you notice how the state wanted to try to get a schematic of the evidence brought back to the jury room of their belief on how the flow of the evidence is? And I agree with the defense. Oh, no, let them refer to their notes because they took notes and they're able to refer to their notes if they have a particular question. That's the whole purpose of having a notepad. So you can jot down evidence ID numbers and different moments in the trial that you want to get some kind of reference to. So
Okay.
let's see.
I have a case, Your Honor, it's a March 2021 case. I'm gonna spell it PATTAROZZI, state 385 Georgia Appeal 675. It stands for basically what the continuing witness rule applies to, and capital court would not be something that is listed as something that wouldn't go back because it would be a continuing witness because it's an original evidentiary document and it's non-custodial in its nature.
Does it cover CAD reports at all, or is it just kind of, here's what continuing witness means?
It's just kind of just what, here's what continuing witness means. I couldn't find a case specific or on point as it relates just.
It's hard to believe, honestly. You know?
Which leads me to the conclusion they go back.
Yeah.
Well, that's your conclusion. Is that the judge's conclusion? Your conclusion is not the judge's.
So does the defense have any case law on CAD reports? So I'm looking at a case, Muse, from the Supreme Court from last year, 316 Georgia 639, and it also doesn't cover CAD reports specifically, but it's talking about surveillance videos. And it says, here the surveillance videos were not the reduction to writing of an oral statement, nor a written statement provided in lieu of testimony. And a CAD report, I mean, it contains the reduction to writing of an oral statement, doesn't it? So it may be that it can go out redacted. What does CAD stand for? Computer aided
Dispatch.
Well, there's computer aided dispatch and computer aided designs. So CAD typically is referred to a graphical application that is used by engineers. Years ago, I used a program called Harvard Graphics that created computer generated designs.
Mm-hmm.
I wanted to share this in case it helps. My thinking is with the arguments we've had on CAD reports and 911 calls,
Mm-hmm.
in our, many days of going through upcoming exhibits, the court made determinations on testimonial versus non-testimonial with how we walk through and redact it. And so my understanding with the continuing witness rule is if a document is non-testimonial in nature, then it's not a reduction or substitute for the person's oral statement or testimony. In terms of that non-testimonial analysis is part of the genesis of the continuing witness rule. But, and that was why I wanted to share that. And this is coming from, I believe it's the same case that Mr. Abadi cited, the PATTA. But that, I just wanted to share that because it just hit me that that pre-analysis, of course, with the CAD and 911 specifically, we have argued and the court has ruled on that part. That was all I wanted to share, Your Honor.
There's another case, it's pretty new, Davis v. State, 371, Georgia Appeals 469, 2024 case.
I mean, in the Paterazzi or whatever it is case, the continuing witness rule is inapplicable where the documented issue is original documentary evidence or where it's non-testimonial because it's not a reduction of or substitute for oral statements or testimony. It's certainly not a substitute for oral statements or testimony. And it is original documentary evidence. And I think we already redacted out of every CAD report, at least since I've been involved, any hearsay, right?
It is true. It is what Mr. Atkins said, to my recollection, is completely accurate. As we did have a series when we went through these CAD reports, a series of hearsay objections and confrontation clause objections.
Right.
And some were redacted.
Yeah. All right, so then I think it would be my conclusion that it is all right for them to go out as long as they are all redacted to cover the evidentiary rulings that I made previously, or that the predecessor court made previously. All right, did y'all, I hadn't had a chance to look at the demonstrative law yet.
I don't think it should go out to the jurors. Jurors shouldn't have demonstrative evidence in the jury room. Sound like Ms. Percival's mic is acting up. We're just gonna kind of kill a sound. Well, we won't kill a sound because the jurors, they gotta find out who's the foreman. I guess they gotta pick their jury foreman.
All right. My reading of reference is that demonstratives can go out with the jury. If y'all got something contrary to that.
Can you just be clear what demonstratives we're talking about?
Uh-huh. Mhm.
I believe there's some physical evidence that Ms. Weaver may have in her.
She's got guns and drugs.
So the drugs kind of.
Neither of those is going out to the jury.
Okay.
If you have pictures of them, those can go out. Or you suggest, is there anything besides guns and drugs that she has?
We're going to look at the evidence
Okay.
list.
Y'all aren't suggesting that either of those go out with the jury, are you?
No, we're talking, we have the jewelry upstairs.
Okay.
Some of that may or may not.
Not sure we want that to go out with the jury either, considering the allegations in this case by one of the attorneys. Unless we've got an armed guard in there.
We're going to go over the exhibit list, trying to see what else Ms. Weaver may have.
Y'all got pictures of the jewelry and pictures of the guns and the drugs, right?
Yes.
Okay.
Judge, do not
Those are
judge.
those in evidence?
Don't send the watches and the diamonds and gold. And don't do that, Judge. And those allegations are real. Don't send another Richard Milley out there.
Mhm. Sure, absolutely. Yep.
Oh no, and definitely not the guns, and the drugs. But yeah, don't send the jury and all other stuff back.
There seems to be pretty
Excuse me, Your Honor.
yes.
Regarding Ruffin v. State, having looked at the demonstratives the state plant would like to send back to the jury, these are demonstratives that were, if not all, at least for the most part, I think all, produced by the state for use with their witnesses.
Okay.
Whereas in Ruffin, that was an anatomical chart apparently used. Well, actually, I can't tell if that was, it looks like it was used by a medical examiner in the parenthetical.
So I'm looking at, it's a fairly old case from the late 90s, but it says items of demonstrative evidence. It's Gabbard versus State. Hang on. Let me find that part.
Oh, Gabbard v. State,
Yeah.
Your Honor,
Mm-hmm.
233 Georgia App 122.
Yes.
Let me pull that up.
These were also anatomical drawings to illustrate victims' testimony.
There's a more recent case, Morby State, Georgia Supreme Court case 311, Georgia 506. It addresses demonstratives as well as cell phone presentation and things of that nature going back.
Sorry, was that Morby State?
Yes.
Thank you.
311, Georgia 506.
Thank you, Mr. Abate. This case, Your Honor,
Mm-hmm.
I think it seems to imply that the lead detective is the one that prepared the PowerPoint summary that went out to the jury, not a demonstrative prepared by the state. Unless I'm reading it quickly, but it appears to be a distinction there.
Okay, so I'm looking at a case, McKinsey versus State, 300 Georgia App 469. It says the continuing witness rule does not apply to demonstrative evidence designed to illustrate testimony given by witnesses. Here, the documents complained of were designed by an investigator of, it was the DeKalb County DA's office, based on other admitted exhibits, including cell phone records, dates and times that checks were cashed. The documents were admitted at trial and served only to summarize the other admissible evidence. There was no violation of the continuing witness rule. I mean, that was more like a summary document, but I guess that was demonstrative and summary. And it was prepared not by the witness, but by one of the parties, and it was not subject continuing witness. Seems okay to me.
I'm going to have more of a challenge distinguishing that one, Your Honor.
All right.
Yeah, I don't know.
So I think unless y'all come up with something else, that I'm going to overrule the objection to both the CADA reports as described, redacted, and demonstratives going out. Other.
So there are some pieces of physical evidence, Your Honor, hats.
Okay.
Other clothing items that
Yeah.
we're having someone go to retrieve to bring them down.
Okay.
And I think by the time we retrieve that, gather everything, we'll be ready to
All right.
collect everything and have it sent back.
One other matter, there are two demonstratives that were admitted by Mr. Steele.
Okay.
These were admitted at some point during the trial.
So I'm
In January.
yeah.
I go-
Those are just blow-ups of
Yeah.
the language of certain
Yes, Your Honor.
overt acts.
It was admitted when Trontavia Stevens was on the stand. I don't particularly have a strong feeling one way or another about them going back. I'm not sure.
I'm thinking those aren't needed because they're going to have the indictment itself out, and that's really just a magnification of certain of those items. on the indictment. So we won't send those out. And if y'all want to look through whatever other demonstratives there are, it might be a good idea. I feel like I asked y'all to do this several times, several weeks ago.
They just went through it, I
Hmm.
believe, Mr. Atkins.
All right. Okay. Well, good. Thank you. So I keep. Hmm? Can you do that? Yes. Hmm.
The state has used demonstratives which were the result of him writing during testimony.
Right.
I don't believe that those are covered under the case law that we're talking about. This was just literally writing in trial. I don't think that makes it a demonstrative. Essentially, they were writing to encourage the jurors to write, is kind of the way I saw it. Send a message, write this down because it's important. But I don't believe it's appropriate for these to go back.
Thoughts? I mean, it didn't seem like that was being used to help the witness illustrate their testimony. It was more to help the jury kind of. Okay, so those will not go out.
So I'm gonna put these right here with the, not those.
Okay. All right, y'all can continue to do this. Let's take a quick recess though. And y'all do that during the recess and then maybe we'll come back and once it's settled, okay?
All right, ladies and gentlemen, gather around. We will be live streaming until there is a jury verdict. If it happens today, we will be here. If it happens tomorrow, we will be here. If it happens after the holiday, we will be here. So make sure you are locked in, because once we get an update on jury questions and or a possible unanimous decision, we will bring it to you live. With that said, ladies and gentlemen, lock in, and we will periodically be checking in. The seal is up in the courtroom. So we are here into the conclusion. With that said, we'll see you guys shortly.
Y'all can just put a joint exhibit sticker on here or write joint exhibit 1 on here. That'll work for that. We've got copies of the redacted indictment to go out. We do not. We still have to sort out the language of those last couple of overt acts that we highlighted earlier. So can we figure that out? And do we otherwise have all of the evidence that's going to go out?
Your Honor, there was a challenge during the lunch break to get into Judge Lambert's chambers.
Uh-huh. The deputies can get into anybody's chambers.
They just got it maybe about 5 or 7 minutes ago.
Okay.
So they're getting the evidence, they asked for a chain of custody form, and so they're trying to get a chain of custody form.
Okay, well, I mean, it goes from one court reporter to another, so do you want the court reporter to just walk up there and take possession of the evidence?
Yes.
That's probably the best way to do it. Then we don't need a chain of custody form. It just is with the court reporter. Yes, we'll do that. All right, so we will recess for our delightful new court reporter to do that. Thank you, Ms. Taylor. Judge Glanville's chambers is going to, it's apparently a significant amount of evidence. They're going to basically wheel it down here to this courtroom, and Ms. Taylor, our current court reporter, is going to take possession of it. So that'll happen in the next 10 minutes or so. Can somebody, I guess I could do that, look in Odyssey and find out the date that's on the original re-indictment to put on this one? You know, when they signed, or who's got possession of the signed indictment? So that might still be, is it in here or is it still with, is it making its way downstairs? We need the date, so we need to see the. I would think that would be. Yeah, I would think the case manager would have it. Right. All right, have y'all looked at the highlighted language for the proposed ways to handle those couple of overt acts as an A and a B?
Yes, Your Honor, and the state had a proposal to, I think, simplify
Okay,
the matter in terms of starting with 183.
okay,
If the state just redacted possession of codeine with intent to distribute and possession of cocaine, because this is the street gang charge, so the jury will still be tasked with the other revisions of did Arnold or Williams possess those items individually. So for purposes of 183, the state proposal is to redact to where it only remains possession of marijuana with intent to distribute and possession of firearm during commission, which tracks the language.
okay. So leave all three of them and have those two kind of offenses only.
Yes, Your Honor.
Okay,
And for 187, the state's proposal is the same, to remove possession of codeine with intent to distribute and possession of cocaine.
okay.
Can I ask a question? So would that mean that we would end up with what?
What is essentially 187A
183A?
and 183A,
Okay,
right?
thank you. That's what it seems to me, and I just want to make sure my.
But those
understanding is
wouldn't
correct.
say A anymore. They would
Right.
just say 183 and 187.
Yes, Your Honor.
Okay, yeah, that works if that's,
And the state, and I can email this, but with our previous discussion on the 133 charges and the language, the state, if you stop, like, for example, take 189 or 190,
okay,
if you stop after an associate did commit the felony offense of possession of firearm by convicted felon, and then redline everything up to where you start by possessing a Glock, and then we would obviously remove for 189 specifically, we would remove the machine gun,
right. Okay,
and then just pick back up, possession of a firearm in indictment, and then cite the felony and the date, and keep it overt action furtherance.
that works as long as, so the question on the floor for that had been, can an overt act be modified to drop it down to a lesser, essentially? Do we have an answer to that?
Your Honor, I'm going to let Mr. Floyd
Okay,
address that with the court because we do have a,
give me just a sec.
yes, Your Honor. Yeah. Yes. I wasn't here that day. Maybe I was here.
All right, thank you for your patience.
Of course, John. So the approach we took in this, to try to avoid any problems was only to remove language, not to add anything. So
Mhm.
nothing's been added.
Right,
I want to be clear, it is not exactly the same situation, but the most analogous thing I could find in the time available is an 11th Circuit RICO case, United States v. Watchmaker, spelled exactly as it sounds, 761 F. 2nd, 1459 at 1468. It's a 1985 case.
okay.
In that situation, analogous to this, the court found there were certain predicate acts for which no evidence had been presented. It removed them from consideration from the indictment that the jury saw.
Right,
That was held not to be a problem.
okay.
And so here we're removing actually less, we're actually removing a subset of that as it references the specific individual defendant in whichever circumstance we're talking about. The others are not at trial. They would have no ground to complain.
Right.
They're not parties.
All right,
So I think it's on all threes at least. But I can't really find a problem with it because we've restricted in this circumstance solely to deletion, not
Okay.
addition.
It would seem that, I mean, of course, I haven't had a chance to read this Watchmaker case yet, but if they're removing an entire predicate act, that would seem to be more analogous to removing the entire overt act rather than amending the overt act. But again, I haven't read Watchmaker. I'm just wondering if amending the overt act, we would be running into a constructive amendment claim, constructive amendment of the indictment.
Well,
Because-
two aspects. I didn't mean to cut you off.
No, please go ahead.
Okay. Two considerations on that, Your Honor.
mm-hmm,
One is the meaning of the word amendment in this circumstance. So if we were changing it to refer to another offense or adding words, that would constitute an amendment. This, to the extent it's an amendment, is exclusively an amendment by deletion. And it is tailored to those aspects where Your Honor found there was an absence of evidence. There's no prejudice to the defendant. It's favorable to the defendant. I'm not aware of anything that says you have to cut beyond the scope of where you found there was a shortage of a failure of evidence. And I don't think there's anything that compels that conclusion. In other words, I don't think this is a throw out the baby with the bathwater scenario.
I would argue that the amendment is actually not favorable to us. That amendment by deletion actually broadens out that overt act. It does not work in our favor because you're removing the
I agree,
elements.
it doesn't work in the defense's favor to make it easier for the state to prove an overt act.
Yeah, and that thus it's conduct beyond that which would appear in the original grand jury indictment, and that would amount to constructive amendment.
Yeah. You know, I mean, even I'm reading Watchmaker right now, and part of it says the court did not change the terms of the crime with which Keating was charged, which I'm not changing the crime, but I'm changing the crime in the overt act. I think the safer thing to do is just to redact the indictment to remove those overt acts. I'm not convinced that it might not be error to do the way you propose. I think logically speaking, it sounds like it should make sense, but in the absence of something that makes it clear to me that it's not error, I would hate to borrow a term from one of y'all, get to, the 90, y'all haven't said it, but almost, I don't know, it was never mind. It was some kind of football field reference that I'm not going to be able to do right. So just never mind. The 1 yard line. And then, yes, y'all probably
I
said
thought you were going to
2 yard
say
line.
risk introducing further error into this case.
No, I don't know that there is error in this case at all. I don't know.
Okay.
There is typically, there are no perfect trials. We know that. It will be up to potentially some other court to determine that issue down the line. But right here today, I would hate to be on the now 1 yard line and do something that does cause an error that couldn't be corrected.
And so, Your Honor, if I can respond to that, two points. One, it's important, I think, to be specific as to which acts we're talking about.
Okay.
So with 183, there's no change in the nature of the crime. We're only talking about striking out those specific instances.
Right.
I can't imagine any problem from that.
Yeah, no, I agree. I was talking more about the possession of a firearm by the whatever they were, 174, 175, 189, and 190. I'm just going to redact out completely. With regard to 183 and 187, I think those are fine to have just gotten rid of the things that I directed a verdict in Mr. Kendrick's favor on.
Thank you, Your Honor.
And Your Honor, with regard to, I had 2 points.
Okay.
One is, when you're talking about, forgive me if I get the number exactly wrong, but 170, I think it's 174, 175, 89, and 90.
Yes.
And so with those, the specter that's been raised is, to paraphrase the defense, the appearance of error where none currently exists, as we are at first and inches. However, because of the way you have instructed the jury to handle the overt acts, if they find these and if there's a defect, those in public court simply strike them from consideration.
Unless they're the only acts they find.
In which case we would know that as well.
All right.
Because they're going to number them.
Understood. I'm just going to redact them. Y'all will still have over 100 overt acts for them to evaluate. All right, so I am redacting out to delete 174, 175, 189, and 190. Don't know why it won't let me. And then on 183, it will be the language that is now 183A, but it won't say A, it'll just say 183. And then the same with 187. Yes.
This already may be fixed, but with both of those, of course, redlining or removing the possession of codeine, the intent to distribute and possession of cocaine from the bottom.
Right.
The last version I saw on 183 and 187 still had those included.
Oh, it doesn't anymore.
I think the state may be looking at the B language and not the A language.
That's perfect, Your Honor.
All right. All right, I think I can't do the rest of it until Ms. Percival comes back because she has the same document up and for some reason it's not letting me remove the highlights. All right, I see that our mainly physical evidence has arrived from Judge Glanville's court reporter's office. And Ms. Taylor, our current court reporter, will take possession of it. And do you all know what's going out and what's not? Because the jury has had this case for an hour and a half now, but they haven't been able to deliberate because they're awaiting the evidence. And that is why I told y'all for the last several weeks to make a determination about what evidence was going to go out so that when they got the case, they could get the evidence too and begin deliberating. So I'm kind of ready for that to happen. All right, Ms. Percival has what we think is the final redacted indictment. So with the changes we just discussed, so if everybody can take a look at those, they start on about page 40 or so. Just take a look at those, confirm that they are what everyone has agreed we're going to do, and then if so, we'll print it out and that'll be ready to go to the jury as well. At which time the last thing we will be waiting on is the evidence.
Yes, ma'am.
How far are we time-wise from getting this to the jury? Perfect. All right, while y'all are doing that, I'm just going to put on the record that with regard to the guns and any other physical evidence that's not going to go out with the jury, for instance, the drugs, the DA is the official custodian of that evidence. And so the DA will remain in possession of that evidence, and y'all need to keep that in your locked evidence room. The court reporter is not going to be taking custody of that, the guns and that other type physical evidence that is not going out with the jury.
I know, right?
Can some member from each team be dealing with the rest of what's just paper evidence and making sure that everybody is on board and on the same page with regard to that?
We've done that.
All right.
We just need to make sure we send them. I think we go with separate things. We just gotta make
Okay, I am ready to hand all of this to the jury in the next 5 minutes. So whatever needs to get done, let's do it now.
Yeah, those.
You can put it, I think that's extra. That's just extra stuff. Yeah. Working on the. They're just extra. You guys want, I don't have anything on.
This is stuff that's not going back.
That's extra, I don't know what they've been on, it's just extra. I think it's just folders. Yeah.
Well, and this is stuff that's not going back.
There's literally, it's just folders. I don't know if they belong to, they should just take them wherever they belong. Or trash it. I don't know if I've recorded this. Yeah, she could do.
I don't know, we do have pictures of the gun,
Uh-huh.
but in case the juror, for whatever reason, they want to see a certain gun,
Then y'all will have to wheel it over and we'll display it in the courtroom.
so we can't keep them here while they're delivering.
No. Mm-mm. No, I mean, they might deliberate for a month and a half. We might need to use, I'm going to be using this courtroom for the other defendants in this, on this indictment. So no.
Your Honor, Ms. Brisfield, these are, I separated these. This is investigator Dennis's stuff that was
We-
taken
mhm.
out.
Okay.
The Jimmy Winfrey, plea that was taken out,
Okay.
and, a transcript for, Mr. Sledge.
All right.
So these are all different things that were either removed from evidence, never in evidence.
Can you make sure that 444Y and 1AS are not going back? They were, I think maybe Ryan, I don't know, something to do with, no, I don't know what they were. I just have a note to myself that those are continuing witness.
Your Honor,
Mhm.
I've looked at the revised indictment that we just received, and it's acceptable to me.
Thank you.
Guys, do you know what wire?
That may have been Mr. Sledge's pleas or something like that.
Yeah, it works. See it, it's right there. You cover here, sir.
What was that number again on one? 444. I think it's the one state has it. You're looking for state there? Yeah. I mean, I have a small one.
Okay. Okay. What the heck is happening here?
Okay.
All right, and I'm just gonna put on, Ms. Taylor, I'm gonna put on the record that I realize if you put on the record for me, put on the record for me.
Okay.
Give me a second.
Okay.
All right, so 1AS that I referenced before, I've realized that is the exhibit number from Mr. Sledge's plea, and it's not the exhibit number for this trial. The exhibit number for this trial is 444Y. They were just the same thing. Yeah.
But the 444Y would stay in there.
It's in evidence, but I don't think it would go out.
So that came in because that was back and forth about. What was the other number that you were concerned about? 'Cause they're looking at
They're the same. No, that was it. It was 1AS, but that's not an exhibit to this trial. So it was just the way that exhibit was referenced in Sledge's agreement. So don't worry about that at all. Okay. Yeah. Okay.
You got that phone. You ready? Yeah.
All right. I mean, if we're ready to start wheeling it in, we don't have to have all 5 things at once. We can wheel in number 1, carry on number 2. I am.
He wants the verdict form.
They're all right there in the middle, right there. Yeah.
That's all of them right there. That's everything. Oh, is that in here? The indictment is not there. The indictment is not there. The indictment.
With the printed out.
Yeah. Yeah.
All those demonstratives that are right there go? Okay, thank you.
And Your Honor, this is just for the purposes of the record.
Okay.
The state has reviewed the revised indictment and it's going to be printed. I was just going to put for the record that the state, would object to the removal of the 133 counts, overt acts, that are 174, 75, 189, and 190. Thank you, Your Honor.
She's waiting for the I don't know. These ask them.
These are ready, right?
These right here?
Yes.
This,
You can use the lid, just don't give me that paper.
all this is ready?
That's the cover.
No, these?
No, red? Oh, okay. What happened?
So what?
They're over there. They're over there. LT.
Look, there's so much more room. I'm gonna double check on my list. No, I have a few things, but we're waiting. I just figured I kept all that together. I'm gonna try like speed. Stuff. Oh, good. Thank you, just in case we need it. Yeah, or wheel it back there. I don't know where you want it. I guess put it, you can take it into the jury room. All right, while the jury is deliberating, Ms. Persfield's going to check to make sure she has a cell phone number for each of the attorneys, because obviously we have no idea when and or if they might want to ask a question or look at evidence. And so we all need to be on standby. We're all still in trial. And I need for people to be able to get here, in 5 minutes time. Ideally. If you have a special place you need to be, we can talk, but in short order. And obviously the defendants will continue to come over each day that the jury is in deliberating, so that they can also be available to come to the courtroom if need be.
I apologize if the court has already stated this. When will the jury end their deliberations today, and what is the schedule for them tomorrow?
Oh, it's in what time?
Yeah.
Well, I have instructed them through the deputies that they need to stay at least until 5. If they want to stay beyond that, they're free to. I mean, not past 7 ever, which I don't think they're going to want to anyway.
Oh, yeah, they're going back there. Before that? Oh. All of this is like, all of this down. I'll put it up. I'll bring it up.
Yeah, I was like, I don't know what's going on.
All right, and so they would like to continue to come in and start at 9, which is fine with me. So I'm going to say, just like a regular day, 9 to 5 with a lunch break. There will be days that the court provides lunch for them, and on those days they can choose to deliberate during their working lunch if they want to, or they can not deliberate and just take a break and eat. I'll make it clear that they can only deliberate when all 12 of them are there together. With regard to tomorrow, since it is the day before Thanksgiving, I'm going to say that they can leave at 3. And other than that, if there is some day or time that we need to alter that schedule, we'll just take it up as it comes.
And if they, I don't mean to ask for such detail, but if they decide to stay past 5, will we be notified of that so that we know to stay around the courthouse after 5? Or if they decide to stay after 3 tomorrow, will we be notified of that? I just want to make sure I don't leave the courthouse if they decide to deliberate late.
Sure.
If I have cell phone numbers for everybody, I'll do a fun group text chain and then text everybody what the schedule is going on, very briefly.
Thank you.
No, Friday was already scheduled as a holiday day a long, long time ago. No.
May I approach?
Mm-hmm.
On the record, off the record. I'm gonna make sure, but let me do this first and then I will. Yeah, oh my God, that's hilarious. We're only using WhatsApp, come on. That's a good one. That was a good one. Yeah, she's getting it. Yeah. It's, yeah. My printer decided to be crazy. It has a mind of its own. Apparently, yes. Correct. Okay. Always put numbers. I know. Give me some numbers. You gotta put some. Okay, then you know how to go. It doesn't look like it, I swear. Oh, no, I get it. It's your system, so it doesn't have to look good to me. Oh, somewhere, this is all. Oh, there's a tiny page. Awesome. I know, right? Is it? Okay. Okay, thank you. We didn't say anything, but glad you told me. We didn't say anything.
All right, with that, That is everything. The jury has the case. And we are in recess until such time as we hear from the jury.
He put rapping in there. He put, because this for a lot in the boys in the hood, this is what they think about. I'm going to be a rapper and I'm gonna make it out. It's not unheard of, is what I'm saying.
Nasty.
Is what I'm saying.
Nasty. And the thing comes down to like his name. And people are picking at him. Not in a harmful way, but picking at him, picking at his clothes. Go ahead, Mr. Kokomo.
Look, my partner say the man stole his swag. No. Hold on. Let me wind it out. Hold on. My nigga, Lil Jeff say he the king of white swagging, right? Shut up one time. Let these folks see what you're doing, man. All right, you check them out now.
What happens there? I think about when I was young. If I had to struggle, if I had to wear clothes that I was embarrassed about, if I was embarrassed about anything, I would hide, I would run.
Deliberate late.
Sure.
I got some shorts too. Hold on, let me make sure we live and we active. I liked it better when it was off, but just because of this.
Mr. Steele, you ready to make your opening statement, sir? Yes, sir. All right, then go ahead. Happy holiday season to everyone.
Thank you.
Jeffrey Williams was born into an environment, a community, a society that was filled with depression, despair, hopelessness, and helplessness. He was born and raised in the Jonesboro South housing projects. That's here in Southeast Atlanta. It's a very small 3-bedroom apartment. He lived with his 4 brothers in one of the small bedrooms. His 6 sisters lived in the other small bedroom, and his mother lived in her small bedroom. In the wintertime, it was freezing. In the summertime, it was scorching, because there was not that much money to go around to pay for utilities. The refrigerator and the cabinets hardly ever had any healthy food, and sometimes no food at all. In order to have the appearance of being able to wear different clothing, Jeffrey would share clothing with his brothers and sisters, neighbors, and friends in the community. And although the clothing was oftentimes dirty, at least it gave the appearance that he can have a different look from the day before. When Jeffrey would exit into the community, most homes' windows were boarded up. There were burglar bars on every entrance. Litter. It's not uncommon to find shell casings and human blood remains from the shootings that occurred. There was glass on the ground from the broken window of the cars. The cars are gone. In this environment of severe poverty, severe crime, Jeffrey developed 2 deep, embedded beliefs about our criminal justice system. The first one is that it is not justice. Our criminal justice system was not just, at least for people that he saw. Jeffrey would see over and over again people in the neighborhood who were known to be the liars. These are the people that would lie to their kids, lie to their mothers, lie to their brothers and sisters, and then somehow those people would be used by prosecutors, allowed to come before judges. And they would have reduced charges, reduced prison sentences, reduced probationary sentences, no charges at all, on their oath that they come in the courtroom to tell the God's honest truth.
Your Honor,
You have an objection, ma'am?
I have an objection.
What's your basis?
Your Honor, I'd rather approach and not speak it out loud in front of the jury. It will take 1 second.
All right.
Thank you.
If I put your list in by sound, please.
Whoever's got their mic turn it really loud, turn it down. Okay? All right, Mr. Steele, go ahead.
Jeffrey learned that these liars, these snitches, these rats, they would come into the courtroom, take a witness stand to tell the God's honest truth. They were still the same liars. And they would testify against people accused of crimes. Jeffrey thinks that the entire justice system is corrupt. It should be blown up. And everybody who feeds into that are awful people, stealing lives away from others. The next abiding belief that Jeffrey had growing up is his despise for the police. He would see people walking on the streets. This could be an adult, teenager, a child. Wearing their backpacks, holding a football, bouncing a basketball, and the police just swarm in. They're aggressive. They search the backpack. They throw the football over the house. They kick the basketball down the road. It got to the point when people saw the police coming, they just ran. It's different experiences in different parts of America. It's different experiences in different parts of Atlanta. Jeffrey would be driving with his sister, the youngest sister, Dora. They're about a year apart. Dora is younger than Jeffrey. She's the youngest of 11 children of Jeffrey's mother. Jeffrey's the second youngest. He's the youngest young man. Those two, Dora and Jeffrey, have the same father. None of the other 11 children of Jeffrey's mother share the same father. And Dora and Jeffrey would be driven, get pizza by their dad, and constantly. The car would be stopped for a window tint violation, a failure to maintain a lane, failure to use a turn signal, illegal left turn. His father would be handcuffed and sat on the curb, Jeffrey and Dora on the other side of the curb, the police rummaging through the car, saying, if we find anything, these kids are going to defects custody. That's how he grew up. But what really solidified Jeffrey's distrust for the police happened 3 days before his 9-year-old birthday. Jeffrey's born on August 16th of 1991. We are now August 13th of 2000. Jeffrey's older brother, they called him Beanie. He was 20 years of age, 11 years older than Jeffrey. He's shot in the chest. He collapses outside, not far from Jeffrey's apartment. The neighborhood comes out. Jeffrey and his family come out. They're praying over Beanie. It's going to be okay. There's help on the way. 911 was called. And what seemed forever, when the police finally did arrive, they didn't go immediately to Beanie. They had to push back the crowd. Jeffrey's mother was hysterical. She was screaming for her child to survive. The police handcuffed Jeffrey's mother, put her on the ground. And when they finally went to Beanie, put a sheet over his face, Beanie was dead to the police, even though his chest was still going up and down, he's still breathing. The Jonesboro South housing projects were closed by the city of Atlanta in the year 2007. Jeffrey's now 16 years of age. His family was displaced. They were scattered. Most of them, not all of them, reunited and now living in the Cleveland Avenue area. Jeffrey was not educated in his home about go to university, work as a flight attendant for Delta. Somebody would loan you money so you could start a business. Jeffrey believed that the only two ways he can break the generational hopelessness and despair for his family, himself, and he wanted to break it for as many people as he could who were in this struggle, was to be a professional athlete or an accomplished musical artist. Jeffrey chose the latter. And from that day forward, every week, every month, every year, to this day, Jeffrey practices to make himself a better musical artist. In Jeffrey's neighborhood, rap, it's a subset of hip hop. Gangster rap is a subset of rap. That was the most popular music at that time. So Jeffrey sought to find out how can he accomplish his mission to be a successful rapper. So he had the internet. They were poor, but they had phones with the internet. So he would Google and look up and get on social media every accomplished rap artist and see what made them special. And Jeffrey would listen to beat after beat after beat. These are billions of musical chords that he listened to. And he tried and he forced himself to be able to speak fast within the beat and rhyme words. Jeffrey can't sit there and write out the words. He doesn't spell well. But he can listen and learn and look up what words mean, or just make up words to put them into the beat. And Jeffrey studied two rap artists particularly. He idolized a gentleman named Dwayne Carter. His performing name is Little Wayne. Jeffrey also idolized Tupac. And Jeffrey looked at what is Little Wayne doing that's making him so successful, because Little Wayne is right before Jeffrey. He is born on September 27th of 1982. He's 9 years older than Jeffrey. And Little Wayne, by the time that Jeffrey came along, has exploded. He is a superstar. And Little Wayne changed the culture. It was more than just the sound of the music. Now, Jeffrey studied Little Wayne so much, he sounded like Little Wayne. You're going to hear witness after witness that Jeffrey sounded just like Little Wayne. But Jeffrey realized that Little Wayne had a following, a fan base, and people who dressed like Little Wayne. It used to be that rappers wore baggy pants, big uniforms from teams. Little Wayne changed it. He wore proper fitting pants. Little Wayne tattooed his face. He's the first one. Jeffrey has tattoos on his face. Jeffrey changed the clothing. He took what Little Wayne did, and Jeffrey wore tight fitting pants. He's the first. He did that because when he would take his ill-fitting clothing from his sisters, they were tight jeans. Jeffrey wore tight necklaces. He wore dresses. He realized in order to become successful and to accomplish his mission of breaking those bonds, he had to capture people's experiences and make it interesting, both musically and creating a brand. He's advertising. Jeffrey was called Little Jeff. His father is Jeffrey Williams Sr. He was called Big Jeff. But Jeffrey is sounding like Lil Wayne. He's trying to emulate Lil Wayne on social media. To call himself Little Jeff and Lil Wayne, he thought that that doesn't sound true. That's a bridge too far. So Jeffrey wanted to have a performing name. So he looked to Tupac. You will learn that in 1983, the incomparable talent Michael Jackson released a song that went around the globe, P.Y.T., Pretty Young Thing. About 13 years later, Tupac is featured on a song with Smooth. And that song is P.Y.T., Playa, P-L-A-Y-A, Young Thugs. And on that song is a repeat of words. And this really connected with Jeffrey. It's a black man that not too many understand. That's what Jeffrey felt about people with nice color skin. Jeffrey had interest in women, but he never considered himself a player. A player to Jeffrey was somebody who had the girls kind of coming at them at all times. Jeffrey wasn't like that. Jeffrey was shy. He was really tall and really skinny. He was malnourished. His teeth were rotten. There was no money to go to a dentist. And all the sugar from the candy that he ate to keep substance in his body rotted his teeth. So Jeffrey would speak by covering his teeth with his lips, or often speak like this with his hand or his arm over his teeth, because he had low self-esteem. He was made fun of and bullied growing up. So he got rid of the player. That was not going to work for him. But he kept the young thugs. He got rid of the S, and he became a performer, young thug. And from that day forward, he insisted everybody call him Young Thug. On every type of tweet, Facebook, social media of any kind, on any records, he refers to himself as Young Thug. And that fit in to the appearance of the gangster rap. Because most people think about a thug as a criminal. But to Jeffrey, thug had a different meaning. Now, some of you read books about Tupac and what it meant to be thug life. Thug life, the hate you give little infants, Fs, everyone, meaning discrimination and racism hurts all of us. We teach that to our kids. That was not what thug meant to Jeffrey. Thug meant and means to Jeffrey something very personal. It was his path that if he could ever make it as a musical artist and help his family, himself, and as many others out of this endless cycle of hopelessness. He would be truly humble under God. That's what thug means. Jeffrey is talented. He worked so hard, he'd outwork everyone. He would stay up all night after night trying to rhyme words, put them to beats. When he had time and the opportunity to go into the studio, he wouldn't leave. He is a prolific creator of music. The neighborhood realized his talent. He was the best rapper in the neighborhood. So Jeffrey was invited to the underage clubs to perform. And he would be the introductory entertainer. He would be able to perform 5 or 10 minutes, $50, get paid $100 sometimes. He's about 17 years old, 2008, 2009. When Jeffrey would leave the establishment, he'd get robbed. And the money was gone. And that money may not be a lot of money for some of you in 2008 or 9, but to Jeffrey, it was food. It was meals for him and his family. The next time Jeffrey went for an event, he did not get on robbed. There's a man in the community who's a man of influence in the community. He was allegedly the leader of Raise on Cleveland, the supposed gang, rock crew. He was supposedly the leader of the Bloods in that area, in Cleveland Avenue. His name is Quentin Porter, goes by Boo or Big Boo. And when Jeffrey comes to make the performance, he's no longer there for 5 or 10 minutes. He is the lead performer. He's going to go last. As the time went on, the neighborhood got behind Jeffrey. The rock crew, the Bloods, the whole neighborhood, they would put up signs on the post, come out tomorrow night. Watch our own young thug perform at this establishment. The place is sold out now. This is no longer 25, 35 people. There are hundreds of people in the club. There are hundreds of people in the parking lot trying to get into the club. There are hundreds of people backing up in the streets, all to see Young Thug. The people who own these establishments are making money. They are attracting customers. Word gets out. Jeffrey's no longer just performing in the area that he grew up in the poverty-stricken area. He's now in Atlanta, South Georgia, Alabama, Florida, South Carolina, North Carolina, Tennessee. He is performing all of the time. By 2011, Jeffrey released his first album. It's entitled, I Came From Nothing. And yes, he speaks about killing 12 and people being shot and drugs and drive-by shootings. This is the environment that he grew up in. These are the people he knew. These are the stories he knew. These are the words that he rhymed. This isn't a ballad or a book. These are phrases in a song. And whatever the listener takes from it, you will learn that's what the song means. This is art. This is freedom of speech in America. As the years go on, 2013, 2014, Jeffrey's now 22, 23. It's unbelievable. He has 3 hit songs that are going around the world. Stoner, Danny Glover, and Lifestyle. He is making music videos professionally. He is working with some of the biggest artists in hip hop. It worked. It's unbelievable. He is not running this criminal street gang in Cleveland Avenue area of Cleveland to gain property, money, or power. Jeffrey Williams did it on will and hard work and determination without anybody's help, except the people from that area that he will not turn his back on. By 2014, to today, you will learn Jeffrey Williams has been nominated and won and recognized MTV, United Kingdom, American Soul Train Music Awards. He is a Grammy Award winner. XXL Awards, BET Awards, Billboard Music Awards. Every single year since 2014, that's what he has accomplished. He is not sitting there telling people to kill people. He doesn't need their money. Jeffrey's worth tens of millions of dollars. Jeffrey has been a sponsor for Puma, Calvin Klein. He has been featured on the cover of Rolling Stone magazine, GQ magazine, XXL magazine, Paper magazine, Complex magazine, Variety Interview magazine. He is at the top of his craft. Jeffrey is so talented in music, he doesn't only do gangster rap. He does rap, gangster rap. He has hits in country music, popular music or pop music, Latin music, Afro, beats. He's been featured on NPR, Tiny Desk. He's played numerous times on Saturday Night Live, Jimmy Fallon Show. Jeffrey has performed in almost every continent on the earth. He's performed in front of more than 300,000 people that come for him. His social media feed has more than 10 million followers. He's not the creator. He's trying to pull people out of poverty. Jeffrey has performed with the likes of Rihanna, Ed Sheeran, Sir Elton John, Drake, everybody in music. And Jeffrey didn't only stay in music. He did fashion. He's an icon in fashion. He has been to Paris, to Spain, all over Europe at the fashion shows. He has his own clothing lines. People are walking around the earth today with Jeffrey's picture tattooed on their calves, on their shoulders. They have his lyrics on their bodies. YSL, when Jeffrey was coming up and making it, Lil Wayne had and repped, talked about Cash Money Records. That's his label. Jeffrey's friends in Cleveland Avenue, they call themselves YSL. Because on the pants, the tight-fitting pants, the women's pants that they're wearing, it says YSL, Yves Saint Laurent. That's where that comes from. Ladies and gentlemen, Jeffrey stands before you, charged with some of the most serious crimes in the state of Georgia. I'd like to go through with you each and every crime that he's charged with in the indictment. The indictment's thick. You're going to have it. At the end of the case, the Honorable Judge Granville will give it to you. You should read it. It's the charging document that is critical in the case. There are many counts. Most of them Jeffrey's not charged with. But everybody, there were 28 people through the prosecution, through the grand jury, indicted together. They're all in count one. That's why this is a joint trial, because everyone's in count one. That was the decision of the prosecutors. You will learn that Jeffrey doesn't even know most of the people in this indictment. He doesn't know them. They all know him because everybody in that area knows Jeffrey Williams. He is known as the Michael Jordan of that area. He didn't get out and stay away. He tries to come back and give people hope because he knows what it is to be depressed, hungry, and have nothing going for you. The first count is a RICO conspiracy. And the supposed objective that the prosecution charged is that Jeffrey, along with others, had a meeting of the mind. They had an agreement. They had an agenda together. And that they wanted to preserve and protect and enhance the reputation, the power, the territory of YSL. That's the allegation. Jeffrey hasn't lived in the Cleveland Avenue area in a decade, more. He has homes from Los Angeles to Atlanta. But they charge him with, he wants the reputation, power, territory of the enterprise by obtaining money, weapons, or other property. Jeffrey needs no money from somebody on robbing someone of a car or doing a $30 drug deal or even $100 million. Like he's got his own source of legitimate income. So RICO conspiracy, there are then what's called overt acts. The judge will charge you on the law, but there are 191 overt acts. And those are separate instances that the prosecution said they're going to prove. Most of them don't include Jeffrey. But the ones that do, I'd like to go through with you. And I've broken it up into 3 categories because an overt act can be a crime. It doesn't have to be a crime, so I then wrote chats, social media, any type of statement, because the prosecution has been investigating Jeffrey for a decade. They have all of his personal chats. You think you're talking to somebody on Facebook in a personal chat? They have all of his thoughts. They put these in the indictment. The third category are lyrics. So I'd like to go through them with you. First is going to be supposed crimes, and these are the overt acts that you will see that involve Jeffrey. As you can see, Jeffrey has never been convicted of a crime. He stands before you, he's not a convicted felon. He can vote, he can carry a gun, he can be on a jury. But now, these acts are embedded in the indictment. So let's start with the first one. So this is September 9th of 2013. Jeffrey just turned the age of 22. And he's driving in a car, and he gets stopped, of course, for failure to maintain a lane. And the police officer comes up to the car, and Jeffrey doesn't have a license, doesn't have a valid driver's license. So now he's under arrest. Police officer says he sees pills, Xanax pills, 7 of them, on the console. Police officer searches the car, and underneath the front passenger seat, there's no passenger, is a gun. That weapon comes back stolen from Andrew and Ann Phillips months before. There's no evidence that Jeffrey's involved in that burglary of the Phillips home. There's no evidence Jeffrey ever touched that gun. You're not going to hear any type of DNA, fingerprints. In fact, Jeffrey says, "That's not my gun." Police officer wants to know, whose gun is it? Jeffrey's not talking to police. So Jeffrey gets arrested. That case got dismissed. But 10 years ago now, it's an overt act for you to consider. You will learn that this stop was video recorded and audio recorded. But the City of Atlanta Police Department, the District Attorney's Office of Fulton County, I demanded that. They can't find it. So you're going to rely on a report of an officer who doesn't remember this incident. That's it. That's an act in furtherance of the conspiracy. That's the entirety of that first overt act. The next one. This is overt act 5 through 7. You may notice that Jeffrey's not even alleged to be in this overt act, but now you're going to hear Jeffrey's supposed involvement. This is 2 days later. It's September 11th, an infamous day in America. It's 2013. Jeffrey was arrested, if you remember, from the last overt act, September 9th, 2013. He made bond. He just got out. Walter Murphy, he grew up with Jeffrey. He's one of the people that would exchange dirty clothing with Jeffrey. You will learn that they would have no money between them. One of them would come across $1. They would split the food that they could buy with that $1 together. Walter Murphy is with a person named Adrian Bean and Fred Plethora. And there is an armed robbery of Mr. Dotson. Gunfire went out. Police are always in this area. So when the gunfire was heard, police respond immediately. Adrian Bean is driving the car. This is a car that he borrowed from a friend. This has nothing to do with Jeffrey. He commits a crime in someone else's car. Adrian Bean almost kills a police officer, almost runs him over, driving so recklessly, high rate of speed, goes across a neighbor's lawn, over an embankment. The car is now airborne. It goes over, you'll see pictures, goes over a parked police car in a parking lot and slams into the side of a laundromat. The car crashes. Mr. Plethro is shot. Police are firing at the car. Mr. Murphy is shot. Mr. Bean runs away. He's captured. Mr. Bean, you will learn, is told, hey, we believe there was a fourth person in that car. If you make that young thug, we'll go lenient on it. Adrian Bean is in the Fulton County Jail talking with his wife. He said, I should have ran the way Thug ran. He got away. That's recorded anytime an inmate, a person is incarcerated, in a jail. Most of the time, unless they're speaking with a pastor, lawyer, their calls are being recorded. You will learn that Mr. Bean also stated on a recorded call, they gave us a story to tell. Mr. Bean is interviewed 4 days later, September 17, 2013, by Detective Quinn, City of Atlanta Police Department. Detective Quinn it's a big case because police officers are discharging their weapon. People are getting shot. Detective Quinn interviews Adrian Bean. And Adrian Bean tells him, they talk about this recording. Adrian Bean tells him, I lied to my wife. Everything on those recordings are not true. Jeffrey was never arrested for this. He was never charged for this. He was never prosecuted for this. He's not even in our indictment on Overt Act 5, 6, or 7. But now, we're going to hear from Mr. Bean. That's it for the next one. Somehow that furthered this conspiracy. Jeffrey was not even charged. Next Overt Act is January 7th of 2015. Now, this is a larger part of our case problem. God forbid, Donovan Thomas is going to be killed 3 days later. It's going to be January 10th of 2015. And in order to understand this rental car, and there's nothing clearly wrong with renting a car, but in order to understand this rental car, and then 3 days later, the killing of Donovan Thomas, you have to understand some background. So we're shortly before New Year's of 2015. And there's a man named Kenneth Copeland. He goes by Woody. And Kenneth Copeland is not friends with Jeffrey Williams. He uses Jeffrey Williams, just like a lot of people. Because Kenneth Copeland wants to be famous and have money. So he reaches on to Jeffrey Williams about a year before that. Well, Kenneth Copeland is a criminal. He is a notorious criminal. In fact, you will learn that he was ranked one of the 10 most violent people in Georgia by the federal prosecutor here in Atlanta. That is Kenneth Copeland. Kenneth Copeland breaks into cars. He steals property they're in. Donovan Thomas is the head of a gang called IF, Inglewood Family. Donovan Thomas and Jeffrey are friends. Jeffrey's friends with everybody. It promotes him. And Jeffrey tries to help other people at the same time. Kenneth Copeland breaks into Donovan Thomas's car. And he takes his expensive chain, Donovan Thomas's wallet, his driver's license, and Donovan Thomas's cellular telephone. Donovan Thomas calls his cellular telephone. Kenneth Copeland answers the call on Donovan Thomas's phone. Kenneth Copeland changed his voice, tried to disguise his voice, but Donovan Thomas knows it's Kenneth Copeland. Donovan Thomas has people on the street. And he tells Kenneth Copeland, "You have my stuff. I'm going to come and get it back." And Kenneth Copeland says, "Yeah, I'm glad you called me. Because one of my partners had your stuff. I realized it was yours, so I got it for you for safekeeping. No problem." When Donovan Thomas meets with Kenneth Copeland, he doesn't come alone. He comes with two other people, and they display guns. Kenneth Copeland's not alone. He's with his brother. They're really not related, but they call themselves brothers. His name is Demekian Garlington. Demekian Garlington and Kenneth Copeland are like this. They are inseparable. Demekian Garlington and Kenneth Copeland are together. When Donovan Thomas comes, he makes it known that Kenneth Copeland is on the menu. Meaning Kenneth Copeland is going to be first. He just stole Donovan Thomas's property. It is now January 6th. It's really January 5th. It's a Monday night going into Tuesday morning, January 6th of 2010. It's going to be the day before this first round party. And Kenneth Copeland is with a lot of people. Jeffrey's there. Jeffrey was performing on stage at Club Crucial. Monday night was Club Crucial night. That's where they all went. And Kenneth Copeland goes in the back, in the kitchen area, and he's met there by a man named Kelvin Watts. He goes by Shell Kel, and who's a half-brother of Donovan Thomas, and other people who are affiliated with Donovan Thomas, and Kenneth Copeland gets beat. He has bumps on his head, his eye is injured, he's being kicked. No one does that to Kenneth Copeland. Kenneth Copeland's the person who puts the bumps on the head, injures the person, kicks him. Kenneth Copeland's mad. And you will learn that Kenneth Copeland then went on a mission. He went to every place that he knew that Donovan Thomas or one of his brothers or friends were, or family members, and he would shoot at them with his weapon. On the 7th day of January 2015, Kenneth Copeland told Jeffrey, "I'm going to be with my child, just born. The mother of my child, her name is Miss Quarterman. And I don't want to be driving around in the typical car I drive around in, Dodge Charger. Can I use one of your rental cars? Jeffrey does this for everybody. People need to take someone to a doctor. People want to go out of the state. They don't have transportation. He rents cars all the time. Jeffrey says, yeah, there's a rental car here. It's a Corvette. Kenneth Copeland says, that's a two-seater. My child has a baby seat. That's too small. Jeffrey rents a car at the Atlanta airport on the evening of January 7, 2015, along with Kenneth Copeland. After they drop off the Corvette, the same location. This rental car is in Jeffrey's name. When they leave the rental car location, Kenneth Copeland wants to pick up his brother, D'Amica in Garlington. And after Jeffrey is dropped off, Jeffrey does not see that Infiniti vehicle until after the killing of Donovan Thomas. That Infiniti vehicle, that rental car, is in the possession, the control of Kenneth Copeland that whole time. The 8th of January, Kenneth Copeland is shooting at Donovan Thomas and his friends, associates. He's using this Infiniti vehicle. He's using another vehicle. He is on a spree. It's now January 10th of 2015. There's a New England Patriot, Baltimore Raven playoff football game. It's Saturday evening. Donovan Thomas is watching the game from inside a barbershop with a lot of other people, his friends. At approximately 7:22 that evening of Saturday, January 10th, 2015, Donovan Thomas is outside of that barbershop. His Chevrolet Tahoe is parked in that parking lot. Car drives by. You'll see a video, a surveillance video from the stores. You'll see sparks, it's gunfire. Donovan Thomas is struck fatally. The EMTs try to save him. He's taken to Grady Hospital, surgery after surgery, and he leaves us. 2 other people were shot as well, but their injuries were not fatal. Later that day, that evening, Jeffrey, we will learn, is in negotiations with his record label. They want to give Jeffrey over $800,000 up front. And the contract's worth millions to produce these records. That's what Jeffrey was working on. He was working on a music video. No one's going to say that Jeffrey was at that scene of the shooting. But later, Kenneth Copeland, when he's arrested, he tells the police lie after lie after lie after lie. Kenneth Copeland says Jeffrey Williams was involved in that shooting. Although Kenneth Copeland said, I don't know anything about it, I'm just telling you what I heard. Kenneth Copeland's one of those liars in the neighborhood. that everyone knows, that becomes a witness, swears to tell God's honest truth. You will learn that after the shooting of Donovan Thomas, his associates did not take that well. Immediately, word on the street is that Kenneth Copeland, Woody, is responsible. Kenneth Copeland, it's now after 10 p.m., it's hours after shooting. He's then at Jeffrey's home, along with a lot of people. They're all scared they're going to be killed. They're all telling, I had nothing to do with it. Jeffrey, you will learn, is friends with Donovan Thomas. Jeffrey puts Donovan Thomas in his music videos. Donovan Thomas invited Jeffrey just recently to come into his neighborhood to shoot a music video with him in it. Jeffrey's not happy. He is sad. Kenneth Copeland says, the police are calling Kenneth Copeland. The police are right on him. You will learn, and it's on recording, that Kenneth Copeland goes into the police station later that morning, so it's a very early morning hours, January 11th of 2015, and he's with Detective Thorpe. Detective Thorpe is recording this. And Kenneth Copeland says, yeah, I got your call. I was at Jeffrey Williams' house, Thug's house. Everyone knows Jeff. And I told him that the police won't talk to me. Jeffrey said, you had nothing to do with this. You should go talk to the police. That's what Jeffrey said. Detective Thorpe asked Kenneth Copeland, this is hours after the killing. Do you have anything to do with a rental car, an Infinity rental car? Were you in an accident in an Infinity rental car? And Kenneth Copeland says, no. He's just a liar. Kenneth Copeland tells Detective Thorpe, earlier today, during the time of the killing, I was at the Green Store. The Green Store is like a grocery store. It's green in color. It's called the Green Store. It's not far from where Donovan Thomas got killed. You will learn that there's video surveillance inside and outside of the Green Store. Supposedly, Detective Thorpe, who is a qualified law enforcement officer, he's been doing this forever. I'm being told that, no, we never got the video of the Green Store to support the supposed alibi of Kenneth Copeland. No one corroborates Kenneth Copeland and where he was. You will learn that Kenneth Copeland eventually says, it's now June of 2015, gets rearrested. He doesn't want to be in jail. He speaks with the police. He's now with Detective Dennis, Detective Gaither, also sitting around police officers. They're detectives with the gang unit homicide. Kenneth Copeland says, oh yeah, the night of the killing, Donovan Thomas, I wasn't involved. But I saw Jeffrey Williams. He's at the McDonald's on Cleveland Avenue. I saw him with all these other people. And then I followed him to his home. It's about 8 o'clock at night. There are videos at the McDonald's. They don't have any video. They never bothered to get any video. We even tried. But we have phone records. And phone records can show that they're not GPS. This is not like you're within 5 feet of this area, you can call E911 or something. But it gives a range, maybe 1.5 miles, maybe more. And tells you which tower you're hitting off of. Kenneth Copeland tells the police, I followed Jeffrey Williams' car to his house about 8 o'clock. That's not true. When you track Kenneth Copeland's phone records, he doesn't go near Jeffrey. He doesn't see Jeffrey that night. He doesn't follow Jeffrey home. He doesn't go to Jeffrey's home till after 10. This is all a lie. Kenneth Copeland was told by the police, we want Thug. That's how he gets a deal. Because Kenneth Copeland was also told, you're an armed career criminal. You're going to spend 25 years in federal custody for having a gun. You're going to be dying in the state of Georgia custody because we're going to charge you with gang crime after gang crime after gang crime. But you can help yourself out. On Kenneth Copeland's word, Jeffrey Williams stands here concerning that overt act. So Jeffrey Williams rents a car in his own name to use in a homicide of his friend. Kenneth Copeland, Antonio Sledge, they're all at Jeffrey's home, and they're all scared. They're saying, Donovan Thomas's friends are going to kill us. They think we're involved. Jeffrey gives money to Antonio Sledge so he and his family can get a hotel room and not suffer a potential drive-by shooting. As Kenneth Copeland said, they're all going to be killed. Kenneth Copeland made them all supposed targets by the IFN. Kenneth Copeland, Shannon Jackson, Demonte Kendrick, others go down to Miami shortly after the shooting. Jeffrey was performing. Jeffrey wanted them to be safe, not get hurt until people calmed down. Jeffrey then sent them back to Atlanta. Jeffrey then went on tour, because you will learn by April 2015, Jeffrey did his first nationwide tour. He did with a performer known as Travis Scott. In the summer of 2015, Jeffrey then toured Europe, performing there, and going to fashion shows. Jeffrey Williams is not involved. On the next overt act, you will see these are the people. This is overt act number 17 and 18 and 19 and 20. And this is charging murder and then attempted murder for shooting the second person who was shot that night, and then the third person, Mr. Sanders, who was shot that night, and then participation in criminal street gang activity. You may notice that the overt act doesn't even include Jeffrey. No one charges Jeffrey with murder, but here we are. The next overt act is April 26, 2015. Jeffrey is touring. He is performing. He's in Louisiana. Lil Wayne, his idol, Jeffrey idolizes him, came out against Jeffrey, called him gay. Jeffrey did a promotional social media release where there's people with guns on either side of him, and Jeffrey saying, come to this concert, we'll see what happens, come on to the concert. Jeffrey was told to do that video and release by his management team. Because when Lil Wayne says don't listen to his music, that impacts him. Lil Wayne is bigger than Jeffrey Williams at that time. So this creates interest in fans. You will learn that this is part of being involved in hip hop or rap. There's all these battles going across social media. It generates interest, much like the NFL have rivalries with the Saints and the Falcons, and how much they hate each other. It is generating advertising. It's branding. Jeffrey is in Louisiana. Here in Atlanta, Lil Wayne has a tour bus, and he performs concert, and his tour bus was fired upon and struck. There's zero evidence Jeffrey's involved. Zero. Jeffrey's not even named. And now you're going to hear about it. Because Jeffrey's the king slime. He just controls everybody, even without any evidence to support it. Because that's the theory of the prosecution and the police who have targeted Jeffrey Williams. The next overt act is July 7th of 2015. Jeffrey is at Perimeter Mall, that's located in DeKalb County. And he's in the mall and he's buying 50 to 100 sneakers, brand new sneakers. And he's going to do a video shoot. And he's going back to Cleveland Avenue where the children don't have proper footwear. He's going to give out these sneakers and allow the children to be in a video shoot. So that's why he's at the Perimeter Mall. He's there with friends of his. And he's on a Segway scooter. It's like an electric skateboard. And the mall security comes over and tells Jeffrey and his friends, and you'll see video of this. They have to leave the mall. You can't have a Segway inside the mall. But Jeffrey leaves the mall. But the security officers follow him. They follow Jeffrey and his friends to Jeffrey's Jaguar. And the security won't let Jeffrey leave. Won't let his friends leave. They're standing around the Jaguar. They can't shut the door to the Jaguar. They can't pull out. And they tell Jeffrey, you're waiting here. You're going to have to be here. They tell Jeffrey's friend, we're going to get a criminal trespass warrant for you. Allegedly, someone inside the car said, I'm going to go home, get a gun, and come back and shoot you in the face. That's the allegation. The security guards then supposedly step back, the car drives away. Nobody is shot. There's no incident. Jeffrey gets arrested on that. DeKalb County prosecutors dismissed that case. It was not even indicted. Now you have it here before you. The next overt act dealing with crime is September 24th of 2017. Jeffrey's with Sergio Kitchens. Sergio Kitchens is an unbelievably well-known musical performer. His performing name is Gunna. And he and Jeffrey both are under YSL. That's Jeffrey's record label. They signed Sergio Kitchens for Gunna. There's a third person in that car. His name is Cedric Jones. The car is going to Peachtree DeKalb Airport. gets pulled over for a window tint violation. The officer gets Jeffrey out of the car and handcuffs, Sergio Kitchens out of the car and handcuffs, Cedric Jones out of the car. Police search the car. They find in the car supposed methamphetamine, supposed hydrocodone, marijuana, and a stolen firearm. Jeffrey was on his way to perform at the Jimmy Fallon show that night. Cedric Jones said, I packed that stuff. Somehow that is now influencing and perpetuating and moving this supposed YSL conspiracy. That's the overdose. The next one. May 18, 2018. Jeffrey is driving a Porsche. Sergio Kitchens is in the front passenger seat. Supposedly Jeffrey is speeding. Supposedly there's another car that's in tandem speeding. Both cars get pulled over by police. There's videos. Jeffrey and Mr. Kitchens are asked to get out of the car. They're asked if there are any guns in the car. They say yes. There are guns in the car. Police get them out of the car. Any drugs in the car? No. Police have Jeffrey and Mr. Kitchens on the side of the road. Go through Jeffrey's car. They run the guns. The guns are lawful. The police put the guns in the trunk of the car. Tell Jeffrey and Mr. Kitchens, you're free to go. Give Jeffrey a speeding ticket. Jeffrey's driving away. He stops the police. Inquires about what's going to happen with the other gentleman in the other car. Police say, no. Go to jail. They have in the car weapons, 30-round magazines. It's not in Jeffrey's car. There's going to be zero evidence that Jeffrey put those guns in the car, knew those guns were in the car, had anything to do with them. That's your overt act. The next crime is an overt act. This is the date of Jeffrey's arrest. So it's broken up into several overt acts. So I grouped them. This is overt act 183, 184, 185, 186, 187, and 188. And what you'll see here is they're just different items. So Jeffrey's home is surrounded. On March 9th of 2020 by law enforcement. Law enforcement has tremendous military power. Law enforcement takes control of the scene, the area. Jeffrey and more than a dozen people are in the house. You will learn that Jeffrey doesn't live at the house often. But other people live there all the time. They take care of the house. You don't leave a house unattended. The house has a lot of Jeffrey's awards that you'll see. And in the house, law enforcement finds a small amount of cocaine. I'm talking about a small amount of cocaine. They find codeine, lots of codeine. Codeine's cough syrup. People drink it if you get high. Get very addicted. Marijuana in the house. And firearms. Other people had access to this home. Other people lived at this home. You will have no evidence that Jeffrey ever touched a firearm. Those are the overt acts involving Jeffrey. And somehow that furthered this conspiracy to create territory and property and money and respect and reputation. The next series of overt acts deal with videos that are released on the internet, photographs on the internet, chats. These are not released on the internet. The chats are personal. So this is when you really know what Jeffrey's talking with people, and then conversation. So the first one is November 3rd, 2014. That is Jeffrey in the red sweatshirt. That is Mr. Copeland. That's Kenneth Copeland, Woody, in the white sweatshirt. And they're wearing different colors. And the RG is Rich Gang. That is a musical gang, a musical artist. Rich Homie Quan, man named Brian Williams, Birdman, Jeffrey Williams. They had lifestyle that went across the world. Success. And Jeffrey is holding up his fingers. Suppose that's a YSL. That's what he's doing. He's wearing red clothing. That's the overt act. Jeffrey didn't release that. That's not his Instagram releasing it. But that's the overt act. The next one is January 3rd of 2015. That is Mr. Demekin Garlington in the red with the glasses on. That is Jeffrey, closest to us. There's money on that table. There's a double cup, styrofoam cup. And it says that Jeffrey posed for a photograph. Jeffrey's not even looking at the camera. Jeffrey didn't release that on social media. He didn't post it. That is Mr. Garlington. And that's Mr. Garlington's "We Ain't Going Back and Forth." Mr. Garlington and Mr. Copeland are brothers. They consider themselves one. What happens January 3rd, 2015? It's an important date. Shortly before New Year's, you will remember that Kenneth Copeland stole Jonathan Thomas's chain, expensive chain, his driver's license, his wallet, and his cell phone. That's Mr. Garlington saying, "We ain't going back and forth." That's the overt act. With Jeffrey Williams. Jeffrey didn't even post it. Next one is January 26, 2015. Again, this is Mr. Garlington. Now, what I'm showing you, by the way, are the overt acts from the indictment. You'll have the indictment. These are language of the indictment. And this goes to a video you will see. And it's Jeffrey. By this time, his rotten teeth are covered with gold. He's trying to fix himself, make himself a better image. It is 16 days after Jonathan Thomas is killed. And it says, Jeffrey saying, so an A lies to their kids, lies to their mamas, lie to their brothers and sisters, then get right in the courtroom and tell the God's honest truth. Don't get it. Y'all ends need to be effing killed, bro, from me and YSL. Exactly what Jeffrey's been thinking all the time. The criminal justice system is out of control. But what do you learn here? First of all, Mr. Garlington released that on his Instagram, not Jeffrey. Second of all, when was the video made by Jeffrey? Was it made, as the state told you, 16 days after Donovan Thomas's killing, and therefore somehow it's relevant to this murder. You will learn that that video was in existence before Donovan Thomas was ever killed. That is a repost. That is a repost by Mr. Garvington. The prosecutors, the police are misrepresenting the evidence. What does happen on January 26, 2015, though, is Donovan Thomas's close associate. He's also a very well-known musical performer. His name's Mr. Bennett. He goes by YFN Lucci. His mother's house he shot at. His mother, Mr. Bennett's mother, YFN Lucci's mother, is shot, as well as her boyfriend. That's what happens on January 26, 2015. This is released by Mrs. Garland. Because everybody wants to associate with Jeffrey. He's the only one who got out of that area. Everyone talks about him. You're going to see in the chats, they don't even know him. Hey, if I do this, how much will Jeffrey pay me? Hey, if I do this, will Jeffrey take me on tour? Hey, if I do this, will Jeffrey do this? Can I get Jeffrey's number? Can I come to his house? Will he buy me jewelry? They use Jeffrey. This has nothing to do with Donovan Thomas. But that's what you're being told. The next one is February 9th, 2015. Jeffrey is in a car. You'll see the video. He's singing. He's singing. And he's making signs with his hands that the prosecuting police say are gang signs. I can make gang signs. This is America. I can speak favorably to the Bloods, to the Crips, to Donald Trump, to anybody. That's the overt act, and Jeffrey didn't even release it. This is on Mr. Garlington, who Mr. Garlington wrote, "You did 30. YSL coming soon." Instead of the C for the Crips, you remove the C if you're in favor of the Bloods, and you use another letter, sometimes a B, just when you use an S. You will learn that in the YSL gang, it's now called a hybrid gang, because there's not only Bloods, there's Crips, there's anybody who wants to come, no rules. But now the experts in the Atlanta Police Department, those are the only experts, they're all the same, the Atlanta Police Department. Now it's a hybrid gang. That is the overt act. It's not written by Jeffrey, it's not released by Jeffrey, but they want you to fear music that talks about killing, drugs. It is art. If you don't like it, you don't have to listen to it. But this is America. It is art. And you will learn that rap is the most listened to music in the world. It's the number one. It is a multi-billion-dollar industry. You don't fear this, we encourage it. It generates money. It puts people to work. It's not meant for brainwashing. It's whatever the consumer chooses. It's art. It's like reading a book, looking at a painting, watching a movie, reading poetry. It's what you believe it to be. That's what we do, as opposed to Russia. They stop all communications. They censor. The next overt act is March 20, 2015. Jeffrey is with Shannon Stillwell, Diamante Kendrick, Mr. Garlington, Mr. Arnold. And they are using their hands to make signs. That's the overt act that furthers, that drives this conspiracy. That's it. Jeffrey didn't even release that photograph. Who releases it? Mr. Garland. Next. It's almost New Year's 2017. Antonio Sumlin also comes from the impossible life that Jeffrey was born into. He's with Jeffrey. And there's a social media captioned "Original Slime SHI." And Jeffrey's saying "Murder Gang BIT." And holding up his fingers, his YSL, until we're dead and pale. That's the overt act. That's driving this conspiracy. The next allegation is August 8th of 2019. That is Mr. Bennett. He's a very, very, very prominent musical performer, rap, gangster rap. It's August 8th, 2019. And this is Jeffrey's post. Jeffrey did post this. And he wrote, YFN, meaning Mr. Bennett, if I ain't like what you do for your mother and kids, and capitalize, I would have been kill you. That's supposed to be this rival, this leader of the YSL, the King Slime, against IFN. And here we go. What they don't tell you, but what you will learn, was the day before, Jeffrey released an album called So Much Fun. YFN Lucy criticized that album on social media. That it's awful. And what you also will learn is that in 2016, years before, YFN Lucy, he's not as high as Jeffrey. He does not have as much fan base or interest. He doesn't make the money that Jeffrey does. So YFN Lucy does what all these rappers do. They attach to somebody bigger to promote themselves. Jeffrey did that too. He did it with Lil Wayne. He did it with others. In 2016, Mr. Bennett, or YFN Lucy, he released on social media that he has been having sex with Jeffrey's fiance. So King Slime, all these years, this man saying that he sleeps with Jeffrey's fiance goes unharmed. Nothing done. This is the post that Jeffrey says, and it's a real threat. If I didn't like what you do for your mother and your kids, I would have been killed you. It doesn't sound too much of a threat. That's the overt act. The next one is March 12th of 2020. Mr. Huey and Mr. Williams. Now, this is not social media. These are actually conversations that the prosecution subpoenaed from Google, or from Instagram, or from Twitter, or from Facebook. You get all of Jeffrey's statements. This is very invasive. And what happened right before this, and if you look at the date, this is right before COVID hit in 2020 in America. Sergio Kitchens has a dear friend co-worker. He is a producer, an engineer, musical engineer. So Sergio Kitchen performs, this other person turns the music, the beats, makes it right, changes lyrics, does whatever they do. This producer or engineer's name is Chandler Durham. He goes by Turbo. And Turbo's car is stolen. And in that car are beats, lyrics that cannot be reproduced. They're the only copy. They're on in a hard drive in his car. The car is stolen. And it is alleged that Mr. Huey's friends or acquaintances or people that Mr. Huey knew took that car. Not that Mr. Huey did it, but that he knew who did do it, who has that property. And Jeffrey writes to him, if you don't take it back, you're going to die. Give back your property. You will learn that no one died. You will learn that the property was never given back. That is the real leader of this feared criminal street gang. He's ignored. That's it. That's March 12th, 2020. The next one is February 4th, 2021. Now this again is the personal chat. Tritavious Stevens, he grew up with Jeffrey. They exchanged clothing, dirty clothing. They went hungry together. And Woonie Lee is also a up-and-coming musical artist that Jeffrey wanted to sign, but Woonie Lee went to another record label. Jeffrey supports him to encourage his career. And this is February 4th of 2021. And what the indictment did by the prosecution through the grand jury is they put this together, and this is bad. I understand when you read it.
Objection, Your Honor, argument.
This reads YSL rule the world, kid. 24M on an N head. Y'all just start bringing me the money. Man, y'all and stop playing with me. So when you read that, it sounds like there's a contract on someone's head. Kill him, start bringing me the money. Stop playing. That's threatening. What you will learn is what the prosecutor did was they took these checks from various days. This is over a 3-day period. This is February 4th, 2021, all the way up to February 7th of 2021. And they cut out all of the context. And what you will learn is that on February 4th of 2021, Jeffrey wrote, YSL rule the world, kid. 24M on an N's head. What happened on February 4th, 2021, that was released on social media and went around the world is one of Jeffrey's artists that he signed, who developed, who encouraged, and who made it. This person had a supposed, maybe it's real, supposed $24 million pink diamond and had it surgically implanted into his forehead. There is a photograph next to YSL Rule the World Kid, 24M on an N's head. There's a photograph. If you click on it, it is the rapper with the surgically implanted pink diamond in his forehead. The police bury this. The prosecution buries this. I will show it to you. Now, the evidence will show, they may say, oh, it's on. There's no mistakes here. This is a big deal. This is a bill of indictment in Fulton County, Georgia in 2023.
Your Honor, argument.
That is misrepresenting. You will learn. You will see it. It has nothing to do with put a contract on someone's life. That's the evidence that's coming at you. You'll start, bring me the money. Y'all, and stop playing with me. When you read, this is a long chat. These people are struggling. Trontavious Stevens is struggling. He's sharing a home with other people. They're trying to pay rent. They're working jobs. These are hard jobs to work. They're trying to save money, trying to eat, trying to take care of their kids. And Trontavious Stevens is in the chat saying, I paid the rent last month. Jeffrey doesn't live with these people. He's just included in the chat. He's hardly on these chats. And Trontavious Stevens is complaining. And he's saying, give me the money for the rent. We got to pay the rent. I paid it last month. Everyone's supposed to put the money on the stove, in the kitchen. No, I'm doing what you said you do. We live together. And Jeffrey said, y'all start just bringing me your money. I'll pay the rent. Y'all stop playing. That's the overdone. That's furthering this conspiracy. That's what they did to that man. The next overt act is May 13th of 2021. This is the chat. It's again, these are the personal conversation not supposed to be seen. These are not released on social media. It's like a wiretap. This is supposed to be between these people. And it's Mr. Martinez Arnold, who, by the way, is a Crip. He's in YSL. Crips are blue, but that's why it's a hybrid gang. Everything moves to make it fit Jeffrey. Now it's a YSL gang that's hybrid. Martinez Arnold, Miles Farley, Quantavious Greer, that's Jeffrey's brother. Wani Lee, you just learned about him. He's an up-and-coming rapper. Signed to another label. Jeffrey's promoting his career. He's not even signed to Jeffrey's label. Jeffrey's promoting him. Trontavious Stevens, you learned about him. Grew up with Jeffrey. Antonio Summerlin and Jeffrey. And it's May 13, 2021. And Jeffrey wrote, y'all ain't beat him up or shot him yet. Y'all ends getting soft. Well, that sounds bad. But what you will learn is the conversation was about Trontavious Stevens complaining to another person who's in that chat. That other person tried to sleep with Trontavious Stevens' girlfriend. And the other person told Trontavious Stevens' girlfriend, Trontavious Stevens is cheating on you with another girl. And Trontavious Stevens and this other man are leveling each other over this chat. And they're going back and forth, and this goes on a long time. And Jeffrey, they're acting like kids. And Jeffrey wrote, y'all ain't beat him up or shot him yet. Y'all getting soft. He's talking to people that he tries to help and that he's known all his life. That is the overt act. He's totally taken to mislead you. I will present the evidence. And there's no apology accepted. When they say, oh yeah, we were out of context, we made a mistake. There's no mistake here. They built a theory. They have an agenda. This is wrong.
Objection, argument.
Next one. September 1, 2021. Mr. Mender is in the Fulton County Jail. When you're in the Fulton County Jail, not only are your jail calls, like a telephone call, recorded, but you can do things with loved ones where you can actually see them, like a FaceTime. Or I guess that's Zoom. But they're recorded. So it's about a 16-minute call and then it breaks off. It just, you can't talk longer than that. on the jail call. You got to call back and pay no money. And Mr. Mender is speaking with Mr. Huey. And the conversation starts with Mr. Huey driving in a car. You'll see this. And Mr. Mender is on his iPad or Mac Pro, whatever device he has. And Mr. Huey meets Jeffrey Williams at a jewelry store. Jeffrey has an image. He's very, very visible. He wants to be visible. It promotes his brand. He wears gigantic jewelry all the time. His face tattoos, his tattoos on his body of the bloods, of 5 stars, of his kids' names. He has 6 children. His brothers and sisters' names. Of the struggles he's been through. Jonesboro South. And Mr. Huey goes into the jewelry store. And Jeffrey walks up. So now you see Jeffrey in the viewfinder, in the video. And he sees Mr. Mender. And Mr. Mender knows that Mr. Huey's in a jewelry store, because Mr. Huey before that showed him. And Mr. Mender says to Jeffrey, "Hey, I need something." And Jeffrey points to Mr. Huey. He says, "Speak with him," and walks away. Jeffrey's on that video audio for 31 seconds. That promotes the RICO conspiracy, that Jeffrey dares to speak with a person who's in custody and treat them well. He didn't buy anything for him. Jeffrey walked away. That's the next opening. The next one is September 4th of 2021, so a couple days later. And Jeffrey is with Mr. Huey. And Mr. Huey puts on his Instagram, it's not Jeffrey's post. Mr. Huey was in custody shortly before this. And he wrote, "From lockdown to a jet, slap is." Says Jeffrey poses for the photograph. Jeffrey's not even looking at the photographer. Jeffrey doesn't post this. That somehow promotes this conspiracy. This violent, territorial, money-gathering, reputation-building, fear-producing conspiracy. That's the overt act. The next overt act is November 14, 2021. It's again Mr. Huey, Mr. Williams. And Mr. Huey writes, and now this again, this is a private conversation. This is not social media. And Mr. Huey wrote, "You know I'm ready to handle the business and go sit down if I got to about any one of y'all on my mama." What the prosecution leaves out is the next line by Mr. Huey, where Mr. Huey writes, "But I don't even know if this is true or not." And Jeffrey writes, "Have you spoken with Gunnar or Sergio Kitchens?" And Mr. Huey responds, "Yes." And what they're talking about, if you remember, right before COVID of 2020, Jeffrey is telling Mr. Huey, get those people to return those beats. Those beats are not ever coming back. They're lost. That is proprietary information. That is valuable art. They're gone.
Mr. Steele, I hate to interrupt you, but you might have time. How much longer do you use?
An hour?
We're going to take a couple of breaks. 10 minutes, okay? All right, we're going to recess.
I'm ready to handle the business, go sit down if I got to about any one of y'all, my mama. And the next line that's omitted is Mr. Huey saying, but I don't know if it's true or not. And then Jeffrey Williams responding, have you spoken with Gunna, who's Mr. Kitchens, a well-known performer? And Mr. Huey saying yes. And this relates back to March of 2020, right before COVID. And Jeffrey Williams is telling Mr. Huey, you know the people who took the property of Mr. Durham, known as Turbo, who works closely with, is one-on-one with Sergio Kitchens. Mr. Huey is not in well graces with Sergio Kitchens. Sergio Kitchens holds a grudge against Mr. Huey this time. And Mr. Huey is writing here before this, I need money to support my family. I want to work for the business. This is a big business that Jeffrey has. There are people who make the flight arrangements, book the buses, carry the bags, pack all the equipment, get the restaurants, the hotels, work in the studios, work on promotion. These are a lot of people that he employs. And the record label that he works with. He works with a publicly traded record label. And Jeffrey says, Mr. Huey's asking, can I have a job? And Jeffrey says, Mr. Huey's like, I'll sit down. For any one of y'all, or my mama, I don't know if this is true or not. Meaning he's saying, I don't have the information that Mr. Kitchen wants. And Jeffrey's response is what I told him. If you're speaking with Gunna or Sergio Kitchens, yes. That's the conversation. That's the overnight. And this is already November 2021. That's their overnight. The next one. This is something that Jeffrey posted on his Instagram. This is New Year's. It's December 31, day before New Year's, 2021. And Jeffrey made this very popular. He didn't create it, but his fans love this. And it's wipe your fingers across the nose. Wipe an end's nose. And to the prosecution, the police, the district attorney's office, that is a rally cry for violence. That's what they're going to tell you. You will learn, people do this all across the globe. You will see images of NFL football players catching a touchdown, take off their helmet, going like this. Baseball players hitting a home run in the playoff game, going like this. This is nothing of criminal activity, but it is to the district attorney's office of Fulton County. Jeffrey's also wearing across his chest, you'll see YSL. It's a very expensive pendant. And that is it. The next one is January 16, 2022, and Jeffrey releases this. It's on Jeffrey's Instagram account, and the prosecution is targeting, that's Jeffrey taking a selfie in the mirror, and he has his hand up, and the indictment that the prosecution had the grand jury return says he's holding up a blood sign, and that furthers this conspiracy. There's nothing wrong with holding up a blood sign, but that's not a blood sign. The blood sign is like this, it looks like a B. That is a P. Jeffrey's fingers are down. And what you'll learn is that Jeffrey just released with Sergio Kitchens, performer known as Gunna,
a song that is wildly popular. It's around the globe. It's called Pushing P. And it's positivity. It means any circumstance you're in, if you think positively about something, you can make it through. You're pushing positivity. You're pushing P. Jeffrey is showing the P. It's not a B. But that became, from the district attorney's office in Fulton County, from the City of Atlanta Police Department, a reason that furthers this supposed conspiracy. That's the evidence that they're showing you. The next one. This is Jeffrey. It's February 12, 2022. And Jeffrey's wearing YSL chain or pendant. Here's a bracelet. It'll blow up. It says slime. Like that's some bad word. Jeffrey did not invent slime. Slime comes from Jeffrey's idol, Lil Wayne. Lil Wayne made slime popular. Jeffrey uses it. Jeffrey's really popular, so people talk about slime. Anything Jeffrey does, people copy. I'm not saying you copy him, but there are people, there are fans, and everyone from his neighborhood copies him. He's a hero to those people because he's breaking those genes. He has a tattoo. We'll blow it up for you during the trial, but it's on his right chest area, and it's a B, and it's colored red. Jeffrey doesn't run away from the fact that he knows people who are in gangs from all sorts of gangs. He promotes himself to these people. He talks with these people. Just like Jeffrey, you'll find out, talks to heads of industries. He talks with everybody. He doesn't believe he's above anybody. It doesn't mean the fact that he talks with, or I talk with, or you talk with, or the prosecutor talks with, a person who's in, that represents the Bloods, or the Crips, or the fashion show, or the Atlanta Hawks. We don't criminalize association. That is the next overnight. This is March 9th of 2022. That is Mr. Kitchens, who we've been talking about. He's in the forefront. Mr. Williams is in the rear of that photograph. This is Mr. Kitchens' Instagram. Mr. Kitchens released Slap Business, YSL for life. Slack is a term, it's like drug. It means anything. You will see images on the internet, children singing songs, sliding, 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 sliding. People say, "What's up, Slack? What's up, slime?" That's what's being criminalized. That's the overnight. The next one becomes lyrics. Now, I separated these to just group them together, but these are songs. Some of them Jeffrey performed, some of them he didn't perform these lyrics. Some of them, the lyrics got changed because he doesn't write them down. The prosecution did not have the lyric find them. They went out and they did a database. And they searched all of Jeffrey's Instagram, all of his Facebook, all of his lyrics to try to find any mention of Bloods, Color Red, drive-by shooting, Tahoe, killings, 12, drugs. They searched for it. These are not confessions. These are not admissions. This is art. You will hear from the most prominent expert in hip hop and rap. he will tell you that these words, the lyrics, they're common. These are not unique and say, oh, that's the Donovan Thomas killing that Tahoe. Jeffrey sings about cars all the time. He names all different cars. They just pulled out the Tahoe. Drive-by shootings. These are common themes. This is, you will learn, studio gangsters. They're in the studio. They are creating music for us to listen to. If you go to the first one, that's April 20th, 2014. It's a song released on social media, a song called Ooh. Red just like Elmo, but I never effing give go. YFL won't fold, pick his A off the balcony. There's no evidence anyone got picked off a balcony. YSL, wife at ends, nose, which I showed you. I'm an F for the cash. Then she's getting robbed by Tick. Tick is another name for Trontavious C. He will tell you he had a rough life. He's been in custody. In a Bentley on Wesley, getting trailed by sniper, there's no evidence of that. All I ever wanted was some money. Put your hands in the air if you dare. And the MF to step over here, F&N, that's a type of gun. Put him in the wheelchair. These are lyrics that rhyme. Those are taken out of context in that song. But they're lyrics. If we're going to criminalize lyrics, you will learn. We all should watch what we say. You will learn that Bruce Springsteen sings about going out west, driving with a gun on his passenger's lap. They're going to kill everything in sight. Nobody prosecutes that. But rap lyrics, you'll find out is prosecuted. Next one. March 25, 2016. Jeffrey released a song on YouTube. It's called Slime, S-H-I. Hey, this slime, S-H-I. Hey, YSL, H-H-I. Hey, killing 12, that means police, S-H-I. Hey, flick a jail, S-H-I. Hey, cooking white brick, that would be like making crack cocaine. I'm not new at this, hey. I'm so true to this, hey. I've done put a whole slime on 100 licks. Slime or get slimed. I'm the VIP and I got that pistol on my hip. You praying that you live, I'm praying that I hit. Hey, this that same slime, S-H-I. FF the police in a high speed. Hundreds of rounds of the Tahoe. The next line has taco. These are rhyming. There are not 100 rounds in the Tahoe of Mr. Donovan Thomas. You'll have no evidence when that lyric was even created. Prosecution doesn't care. These are release dates. They have no clue that this is what they're giving to you. And is it 100 rounds in a Tahoe like bullets that hit a Tahoe? Or is someone driving a Tahoe with 100 rounds in it? It's up to the listener, I guess. But the police officers in the city of Atlanta, district attorney's office, Fulton County, everything. It's like 24 M's on the N's head. Everything is viewed wrong. I'm prepared to take him down. Got banana clips for all these ends. Acting monkey. This says slime, S-H-I. This says mob, S-H-I. F the judge, YSL. This is mob life. That's the over there. It rhymes. There will not be one person to come in here. There will not be one document that comes in here. To say the intent of that song was to brag about something that happened to Donovan Thomas or anyone else. Jeffrey's being targeted. The next one, April 12, 2018. Jeffrey released a song on YouTube. It's entitled Anybody. Jeffrey said, I never killed anybody, but I got something to do with that body. I got the streets on my back, carrying like I'm moving a body. I told him to shoot 100 rounds, like he's trying to move the body, ready for war like Russia. I got all types of cash. I'm a general. You will hear that other artists use the same type of lyrics. Before Jeffrey, after Jeffrey, these are typical. You also learn that this is a song that Jeffrey did with Nicki Minaj. This song is a gigantic success. Now it's become a confession. It's not true. The next one, January 15, 2019, Jeffrey on YouTube, song called Bad Boy. I shot his mommy, so now he no longer mentioned me. I had, those are shoes, when I shot the C, act like you want war, they're gonna smoke you like a blunt. I shot at his mommy, now no longer mentions me. So the police are gonna tell you, the prosecutor can tell you, huh? Mr. Bennett, wife and Lucy, her mother was shot in drive-by shooting. That was done by Mr. Coke. It's not Jeff. It's also January 15, 2019. That shooting happened on January 26, 2015. There's no connection. Plus, wife and Lucy, he still mentions Jeff. That's how bad his album is. He says in 2016 how he slept with Jeffrey's fiance. These are just lyrics. These are art. Criminalized books, movies, and other forms of music. How come other forms of music don't get criminalized? Next, September 16, 2019, Mr. Arnold, Jeffrey Williams, it's called Just How It Is. Jeffrey supposedly saying, I escaped every one of the licks because I was supposed to be rich. I don't care nothing about no cop. I'm telling you just how it is. Hit him with a Mac now, his whole body scab. I done for the crew, I done did the robbing, I done did the jacking, now I'm full-time rapping. Last end tried me, almost got popped at Lennox. Ask the cops, ask the detectives. They all know the business. Ask the cops, ask the detectives, all the jurisdictions. Gave a lawyer close to $2 million. He handles all the killings. We don't speak about S on wax. It's all mob business. We know to kill the biggest cats of all the kittens, and that has to be done in Thomas, right? It just has to be done in Thomas. There's no evidence that that's true. That's what you're told. $2 million for the lawyer to handle all the killings. The authorities got all of Jeffrey's finances. How much money Jeffrey paid to lawyers? For other people? Hardly anything. You'll see a chapter, Jeffrey's asked to pay $2,500 to someone's lawyer. Who doesn't even do that? He's asked to pay for lawyers all the time. Who doesn't do it? He's not the head of conspiracy. He's not in a conspiracy. They are lyrics. The next one. It's December 18, 2020. This is Mr. Kendrick, Mr. Kitchens, and Jeffrey. And they released a music video, Take It to Trial. This is a very popular song. This song was based on another song called Take It to Trial. They changed the lyrics. So that was the inspiration. Take this MF trial. I wept for my life for real. For slimes you know I kill.
Trial. I done beat it twice. State. I'm undefeated like feds. Came and snatched me. I don't know. No point in asking. I was unbelievable. That would be like Cleveland, except the C was dropped for the B. Stuck like a magnet. BITASS. And I shot at your mommy. Need to stand down. I up my stamina. Take it to trial. Get an appeal. Take it to trial. Yeah. You're gonna whack them. Pay for the casket. It's just if we whack them. My young ends pulling up Bentleys, Aston Martins, those Teslas strapped with an FN, choppers, carbons. YSL, slimy and shady. Watch me whack that B, pop them like a cyst, Glock with the assist. And that is your confession. Stuff goes around the world. Now it's held literal. Jeffrey, it's outrageous. The next one. It's April 16, 2021. Jeffrey released a song on YouTube. Really be slime. The lyrics, my end really, they slime. We committing them crimes. Hop out and shoot. Roll one up for the gang. Want to be a slime? Go catch a body. Me and little bro, we used to steal from the store. We had to stick it and go. That's a confession to an armed robbery. Had to stick them up and go. That's what we're dealing with. I'm also not telling you that these lyrics are accurate. This is the interpretation of the City of Atlanta Police Department and the District Attorney's Office of Fulton County. You will not hear from the District Attorney's Office call one witness who's an expert in lyrics, in rap, in hip-hop, in gangster rap. They're not going to do it. They're going to do it through gang experts, because the gang experts know what they're doing. And they have 5 gang experts, but they really have 1, because you're not going to get experts from different jurisdictions, from different types of teachings, from different learnings, from different thoughts. Your 5 gang experts in this case from the District Attorney's Office of Fulton County all work together in the City of Atlanta Police Department. Those are your 5 gang experts. They teach each other. They talk to each other. They decide what the rules are. None of them gave a report. It's just they know it because they are controllers. That's what you're going to be told. They know it more than you, more than me, more than Jeffrey. They just know. We're going to have 5 people designated as experts. They all are biased. They all targeted Jeffrey. They all work together. They have an agenda with the District Attorney's Office, Fulton County. That's our crime. The next one. This is April 16, 2021. Mr. Kendrick, Jeffrey. It's called Slatty. I killed this man in front of his mama, F little bro, sister, and his cousin. I shoot out, kill him, not leaving a trace. I had to break the safe. Yeah, I didn't leave even a trace. Dissect your body like science class N. Gangster cards, you got a body, little N. Magazine clips, so you might get your issue. You think you gangster because you got a pistol. Look at my trigger starts to issue. YSL, we going overboard. Oh yeah, the lyrics found the prosecution. They searched for this stuff. There is no safe in this case. These are simply art. Next one. April 16, 2021, Mr. Arnold, Mr. Kitchens, Jeffrey did appear in a video titled Ski. I F with slacks, we come to eat rats. I came with some effing piranhas. I towed an FM on me called Nietzsche Nietzsche. His Glock, he keep rolling, Duke rolling 60s. He locked in C. Duke is the name that Mr. Martinez Arnold used. It was by Duke. Rolling 60s with the Crips. That's the C. Some of these words are not really the lyrics, but you can decide for yourself. You'll hear the songs. You decide what the lyrics are. It's a wildly popular song. It's now become criminalized. The words in America are criminalized in Georgia. Next one is count 56. So those were the overt acts dealing in count 1, the RICO conspiracy, deals with Jeffrey. There are 191 overt acts. Most of them don't deal with Jeffrey. But the prosecution has indicted it through the grand jury to say Jeffrey's in this conspiracy. So the acts of a Christian Eppinger somehow roll onto Jeffrey. Jeffrey's not in the conspiracy, you will find out. That is everything pertaining to Jeffrey and count 1. Then we have to skip. So you're going to have that count 2. Count 2 is the murder of Mr. Donald Thomas. Jeffrey's not indicted for murder. And you keep going down until you hit count 56. And you're going to go through 56, 57, 58, 59, 60, 61, 62. Those pertain to Jeffrey. So that's what these are individual counts. It's not, these are just separated out. They're all in the overt acts, but now they are separated out into crimes. So 56 is from the 12th day of May of 2018 to the 8th day of May 2022. The dates are there because the indictment was returned the next day, May 9th of 2022. That's why it ends on May 8th, 2022. And it goes back the 4 years because that's something called a statute of limitation. The Honorable Court will charge you on that. But that's why you have a date range. And it says that Jeffrey, he occupies the position of an organizer, a supervisor, a management, a leader in the YSL criminal street gang and did engage directly or indirectly. Either conspired with the following criminal street gang activity: murder, aggravated assault with deadly weapon, armed robbery, hijacking motor vehicle, sale of marijuana, possession of marijuana with intent to distribute, theft by receiving a firearm, possession of a weapon by a convicted felon. Jeffrey's not a convicted felon. They're saying that, well, Jeffrey is in bed with these other people, and therefore their acts are attributable to Jeffrey. Jeffrey doesn't even know most of these people. That is charging Jeffrey with participation in criminal street gang activity. Criminal street gang activity, you will learn, it is not enough to be in a gang. That's not illegal. It's not enough to associate with a gang. That's not illegal. It's not illegal to have a blood tattoo on you, wear red. It's not a crime to promote a criminal street gang. What makes it a crime is if you're doing all those things and you're wearing the colors and you are promoting the gang, and then you do a crime to further that gang's activity, the agenda of the gang. That's the crime. Otherwise, we couldn't associate with someone who's part of the Ku Klux Klan, not that anyone would want to, or the Aryan Nation, or any other despicable organization. America would wipe them all out. That's what Jeffrey's charged with. That's count 56. Count 57 also charges Jeffrey with participation in criminal street gang activity. This is along with Mr. Arnold and Mr. Kendrick. And this on May 9th of 2022. May 9th, I may have misstated earlier, May 9th, I don't think I did, but May 9th, 2022 is the day of Jeffrey's arrest. When law enforcement surrounded his home, there were more than a dozen people there. And what the prosecution did now is say that this is criminal street gang activity. This furthered the gang YSL because in Jeffrey's home, where other people had access to, there's marijuana with intent to distribute. Jeffrey doesn't have to sell any drugs to make the money. possession of codeine with intent to distribute, possession of cocaine, it's a very small amount, possession of firearms. And it's alleged in count 58, 59, 60, and 61 of the indictment, which we'll get to right now. That somehow promoted the gang. That was in furtherance of the gang. Being in a house where other people have access to it with these drugs now furthered the gang. That's the allegation. That's it. Next count. The 58. Mr. Arnold, Mr. Kendrick, and Jeffrey. They possessed marijuana with intent to distribute the day of Jeffrey's arrest. Marijuana is found in Jeffrey's home. There's marijuana and it's bagged up. It was bought at a dispenser, excuse me. It said Brooklyn, New York on it. That's found in Jeffrey's home. Now Jeffrey, there's all these other people have access to it. There's no drug test that Jeffrey's using marijuana. His hands, his clothing don't have marijuana on it, and nobody's going to tell you. But now he is charged, out of all the people, with Mr. Kendricks and Mr. Arnold with possession with intent to distribute marijuana. That's count 15. That's the day of his arrest. Next one. It's count 59. Mr. Arnold again, Mr. Kendrick again, and Jeffrey. It's the same thing. It's the day of his arrest. It's May 9, 2022, and found in the home is codeine. There's a lot of codeine in the home. Buckets full. There's all these separate glasses, bottles of codeine. Jeffrey didn't possess it with intent to distribute. It's in the home. That's it. That's it. The next one is 60. Mr. Arnold, Mr. Kendrick, and Jeffrey possessed cocaine. It's the same day of the arrest. This is a small amount of cocaine. I'm not pro-cocaine. This is a small amount of cocaine. Now he's charged with it. Of all the people in the house, they just picked these. Next one. 61. Mr. Arnold, Mr. Kendrick, and Jeffrey, possession of a firearm during the commission of the felony. It's the same date of his arrest when the police took over the home and searched it. And it says that Jeffrey did have on his person, or he conspired with others, a party to crime with others, a Glock 30S firearm, a Glock 357 firearm, F&N firearm, Glock 919 firearm, Smith & Wesson M&P firearm, Glock 45 firearm, which has a converter. While involving the felony of marijuana, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, and possession of cocaine, they're saying that the gun and the drugs are in close proximity to each other. And therefore, having a gun, which is not illegal for Jeffrey, except for the machine gun, converted gun. But if you need drugs, and guns and drugs should not be together on the wall. You'll have zero evidence that Jeffrey was with a gun near any drugs. There are all these other people at the house. These other people were living at the house all the time. Jeffrey would go from place to place. Jeffrey just got back into our country. He was in Ireland. He was watching Sergio Kitchens perform. He just got back the weekend before. The next count is count 62. Mr. Arnold, Mr. Kendrick, and Jeffrey were in possession of a machine gun, Glock 45 firearm with a converter switch, extended magazine. During the commission or attempted commission of participation in criminal street gang activity, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, possession of cocaine, as alleged in count 57, 58, 59, and 60. You will hear zero evidence that Jeffrey ever touched a gun with a converter. You will hear zero evidence. This is a knowledge. You have to know. We don't trick people. You have to know that the gun is transferred into an illegal machine gun. You'll hear zero evidence that Jeffrey had anything to do with that gun. The purchase of it, the possession of it, even knew what was in the house. Knew that it was a machine gun. That's the count. Ladies and gentlemen, that was the indictment against Jeffrey Williams. That is everything. Jeffrey has been targeted. Jeffrey does not trust the criminal justice system. Spent 10 months to choose you to decide his fate. Jeffrey trusts you. There's a wiretap in this case. There's actually two. Antonio Sumlin's phone, a wiretap. Wiretap just means that it's called wiretap because we used to have phones with wires, and the law enforcement would get into the phone system, the AT&T system, and be able to connect to the wire for that phone. And they can listen to all incoming and outgoing calls. Today, we don't, our phones are cellular, but it's the same exact thought. And law enforcement, with a court's permission, or without a court's permission, that's illegal, can get into a cell phone on the frequency so they can capture your Google searches, your text messages, your phone calls, everything you do with that phone, your GPS. And Mr. Garlington's phone was wiretapped. Mr. Sumlin's phone was wiretapped. And you will learn that these people who are so embedded with Jeffrey in crime, Jeffrey's the king slime, the leader of this organization. You know how many conversations in any way they have with Jeffrey? 0. He is not on a wiretap. 0. But others speak about Jeffrey. Hey, we did this for King Slime. He should pay for our lawyers. Jeff doesn't pay for anybody's lawyers. Hey, how much will King Slime, the biggest, pay us to kill YFM Lucci, Mr. Bennett, who's in the Fulton County Jail and we have access to him? How much will he pay? Jeffrey pays nothing. He doesn't encourage it. He's not even on it. But everyone talks about, oh yeah, he's gonna pay big. That's a big one. He really wants it done. Those people don't even know Jeffrey. Jeffrey treats whoever he is with the same. Whether he's with some giant president of a company, or he's with somebody on Cleveland Avenue who's been in and out of prison, a gang member. He knows where he came from. He came from nothing. Now he stands before you. We trust you. Jeffrey's not guilty.
All right, ladies and gentlemen, how about some lunch?
Yes.
Good? Okay, all right. What we're going to do at this point in time, ladies and gentlemen, it's almost the hour is 1:45. Let's come back at 2:45 and we'll see where the day leads us at that point in time. Remember the admonitions that I gave you earlier. They apply to you, well, unless you have any other inquiry of me. Remember, I told you if you leave your headquarters, leave your notepads in there. And remember all the other admonitions I told you about contact and otherwise discussing anything with each other. You're not permitted to do any of that and the other admonitions I gave you. So we'll see you back at 1:45 and we'll like I said, we'll continue with, I'm sorry, 2:40. Okay, all right, I'll give you a few minutes. All right. So, yes, come back at 2:45. All right. Unless there's anything else, ladies and gentlemen, let's enjoy your lunch. We'll see you at 2:45. All right, all rise. All right, ladies and gentlemen, please be seated. All right, unless there's any other inquiry of me, I'll see you all back at 2:45, okay? All right, we're in recess.
Your Honor, before the court leaves, I just wanted to make certain that I have an opportunity to address the matter that we addressed at the bench during the state's objection. I can wait until after lunch or whatever time the court designates.
It was already taken up and recorded at the bench, so.
That part, not the objection, Your Honor. It was a motion in limine that the state wanted to make that goes along with that. I can wait until whatever time the court designates.
Let's just do it now. What is it?
Okay. Your Honor, I wanted to move the court in limine to preclude any attempt to admit self-serving hearsay if it does not come from Mr. Williams himself. Anything that Mr. Steele has represented to the jury that Mr. Williams thought or felt. Mr. Steele announced at the bench that he expected that information would be coming in through evidence. And so if there is no such evidence at the proper time, the state may move for a mistrial. I don't
know
what'll be done at that time.
Here's the thing. If he doesn't prove what he says and he has already promised that there are ways to deal with that. So I'll leave that within your wise discretion and lawful means. Mr. Steele, anything else, sir, in terms of that particular conversation? No. All right. All right. So with that, unless there's anything else, we'll go ahead and recess until 2:45. All right?
Thank you.
Okay. We're in recess. Bring your check. I can't hear you. You said repeat all again after? So what, Judge? You said repeat all again after? Bring your check. You good? I can't hear you. If you can give me hold on just a second. All right, Sergeant Ingram's everybody back, sir?
Yes, sir. Everybody's present and accounted for.
Okay, how about our jurors, sir?
Everybody's present and accounted for.
Okay, all right. Council, if we could take our seat, we'll go ahead and call for our jurors, please.
All right, ladies and gentlemen, please be seated.
All right, members of the jury, you good?
Yes.
All right, that's like what I like to hear. We're going to go ahead and continue with the presentation of opening statements. At this point in time, who is the next person to give openings? Or? All right, Ms. D. Williams, you are welcome to begin whenever you like, madam.
Thank you, Your Honor. Hope everybody had a good lunch. So I'm attorney Angela D. Williams, and I have the privilege of representing Rodagis Ryan over there in the back. Poor, young, convenient. That's all it takes to become the target of the state. I'm gonna break that down for you. Poor. Rodagis was born on a couch. Let that sink in. He was born on a couch. From day one that he was brought into this world, he has been fighting to survive. The hospital was only 5 minutes away. I don't want to throw a school under the bus or anything, but the elementary school and middle school that he went to, 98% of the children there were on free or reduced lunch. What that means is they live at the national or under the national poverty level. At one point, the Atlanta public school system was under scrutiny. They accused educators of cheating the students. The DA kept going around saying, we got to think of the children, we have to think of the children. These children are victims. The only time the state cares about poor people is when they can exploit them. For the RICO trial for APS, they got a conviction of educators. And they didn't give any of the students any.
Our cases, ours is coming, us the same objection. Go ahead.
And in this case, they're trying to get a teenager for RICO. Young. Growing up on Cleveland Avenue is a very dangerous, destitute place. Rodalius learned early that he needed to adapt. And he did what most teenagers and preteens do. They mimic. I remember when I was younger, growing up on social media, I used to hold up the C symbol all the time because I used to love this group called Cold Rain. It was my favorite group. I used to hashtag everything, cold rain, cold rain, cold rain. After every post, it would be cold rain. It would be rain emojis. Fortunately for me, I didn't grow up poor, so the state didn't care what I was doing. Unlike Rodalius, if I had grown up on Cleveland Avenue with all these rain emojis and C, I would have been accused of being a crypt. I would have been a gang member.
I stand.
They would have said that I was.
I'll overrule that. You can go ahead and continue, madam.
Thank you. They would have said my rainy emoji said some murder that happened. Convenient. Rodalius is here because when he was 15 years old, the state told this incredible tale of murder, and when you're young and you don't have the means, it's hard to refute those claims. From the age of 15, Rodalius has been in 3 different prison systems. He's been to juvenile detention because they were holding him for the murder. He went to Fulton County, waiting for the murder, and once he finally turned 18, they sent him to the Department of Correction. And I don't know about you, but a lot of people in here haven't been to prison. But if you've ever gone to prison, you would know it's overcrowded, it's underfunded, it's violent, and you have predators everywhere. And unlike maybe college or a new job, you don't get an orientation when you first go to prison to figure out how you need to do anything. Rodalius had to do what he's had to do since day one, survive in prison. And if you look at Rodalius, you can see he's maybe 100 pounds soaking wet. So he posts things. He posts things on Instagram. And I wouldn't even call them Instagram posts. I would call it a survival post. He has to boast, he has to be boastful. He has to show people, this is what I have. Because he has to protect himself. It's prison. So you put poor, young, and convenient together, and what do you have? You have the perfect scapegoat for the state. This indictment has 28 co-defendants. And the prosecutors keep saying, we're trying to clean up the streets of Atlanta. We're cleaning up Fulton County. We're trying to drive crime down. You just heard me say Rodalius is in prison. The jurors got it wrong in that murder case, and they convicted him. He's going to be there for life. They're not cleaning up the streets of Atlanta. They're cleaning up the prisons. And I promise you, the people in the prison, the wardens, they know how to handle their inmates. They don't need the DA's help. They have it.
I stand objection.
Out of 65 counts in this indictment that you guys had to listen to, Rodalius is only in 1 count. He's only in RICO, that's it. Out of 190 overt acts, Rodalius has 8 of those acts. 3 of them are for the murder that I've already told you about. 5 of them are survivor posts. He has to do these posts so he can survive prison. So why are me and Rodalius here? Because the state was to put on a show. Rodalius is in less than 1% of this whole indictment. This reminds me of this anime named Bleach, where it's 16 seasons. Every episode is about 18, 20 episodes. Sorry, every season is 18 to 20 episodes. And they have season 4 and 5. They have these bouts. They're the villains of the whole thing in season 4 and season 5. The main characters are trying to get them out of soul society. You go to season 6, you don't hear about the bounce. You go to season 7, you don't hear about the bounce. Why don't you hear about these important characters? Because they're filler characters. It's a filler season. Me and Rodalius, we're fillers. We're not integral to the story. They just dragged him out of prison to jail to make this bigger than it has to be. We're basically distractions. So as a juror, what can you do to tell the state, we're not going to be distracted? We don't need to listen to filler. You come back at the end of this with a not guilty for Rodarius Ryan. You tell them we do not want to waste our time on fillers. We just want to get to substance. So I guess sit back, enjoy the show, get some popcorn, because this is not justice, this is a circus. Thank you.
All right, who else wishes to make an open statement? Mr. Apt? All right, go right ahead, sir.
It is more important that innocence be protected than it is that guilt be punished. For guilt and crimes are so frequent in this world. That's a quote from the man who wrote into our Constitution what the presumption of innocence means. His name was John Adams. He was the second president of the United States, right after George Washington. Why is that quote important? Why is the presumption of innocence important? Why did that get included in our great Constitution? Because we want to make sure that we don't accidentally send innocent people to prison. Innocent people don't get punished. I have the great honor of representing Diamante Kendrick, who's sitting in the gray vest at council table with me, along with my co-counsel, Doug Weinstein. Doug, stand up so everyone can see. Also, you'll meet or hear from, at times, Katie Hingerty. She was here yesterday. She was the tall woman with blonde hair. And the three of us have the great honor and privilege of defending Mr. Kendrick. I've been practicing law here in Atlanta for almost 30 years, exclusively representing innocent people like Mr. Kendrick. He is not guilty. He is not guilty of every accusation and every count in the indictment that the state alleges. Let me say it a third time, just so you're clear. He is not guilty of every single charge against him. He is presumed innocent, as our great Constitution demands. And we won't have to prove anything to you, as the judge told you. The burden will always lie on the state, and boy, is it a high burden, beyond reasonable doubt. Now, it's not a mathematical certainty. The judge, Judge Granville, is a great judge, by the way, and very smart, and knows the law really well. He will instruct you as to all the law, none of the lawyers will. But that beyond a reasonable doubt standard is a tough standard for them to meet. And the evidence in this case against my client is so very weak. The state's not going to be able to come anywhere near the standard required. My client, Mr. Kendrick, grew up here in Atlanta in a tough neighborhood. He did not come from money. He was poor, hungry, deprived, socioeconomically disadvantaged. But he had a loving mother, a mother who's been with him the entire time of this case and will be every day. And she made sure that he had the best upbringing that he could. You heard Mr. Steele earlier talk about the disadvantage of how Mr. Williams was brought up, and my client had a similar upbringing. It was tough. Food, clothing were sparse. But he dreamt of a better life for himself and for his family. And through hard work, through creativity, maybe a little luck and fortitude, he became a very successful musical artist, a rapper. Now, despite Mr. Kendrick's mom's best efforts, he did get into some trouble. And we acknowledge that. We don't hide from it. We don't skirt it. Mr. Kendrick, you'll find out, went to prison between 2015 and 2020. So the state is actually limited because during those years, he's locked up. He can't possibly be committing any crimes they've alleged. You'll also hear that he pled guilty to a crime right here in Fulton County in 2017 while he was locked up. And he admits that wrongdoing. He owns it. He paid his debt to society. But he also worked hard and obtained success in the music industry. And not just for fame or money. Mr. Kendrick did it because he wanted to give back to his community, a community that was disadvantaged. And that's exactly what he did when he got successful. He did tremendous civic duty. You'll hear evidence that he volunteered, he helped coach a youth football team, and he gave back to his community. He gave back because he knew it was the right thing to do. Now the state, and the evidence will show, the state, the police, and the prosecution want to use Mr. Kendrick's past. They put it in the indictment. Despite having paid his debt to society, the state is going to use his prior conviction to try to bootstrap these old crimes that he's already paid his debt for to get you, to convince you that he's guilty of these new offenses. They're going to try to get a second bite of the apple, despite the fact that he served his time, that he pled guilty. They want you to find him guilty again because of a debt he's already paid. And that's not right. They can't prove, using actual evidence in this case, the new crimes that they're alleging in the indictment, so they have to get you to pay attention to the old past he left behind. The evidence will show that he is not guilty of the charges in the indictment, and that the police and the prosecution's case is so incredibly weak. But they have to distract you with the old Mr. Kendrick. The Mr. Kendrick that paid his debt and pled guilty and served his time. It's like a bad magic trick. You ever see a bad magician who's like, look over here, while they're picking your pocket? That's the evidence the state wants you to pay attention to. I've been involved in a lot of RICO and murder cases in my career, in almost 30 years of doing this job. But the judge told you, and the prosecution told you, this case is unique, different. Why? It's going to take months. There are going to be hundreds of witnesses. It is massive. It's definitely the biggest case that any of us have ever been in. Maybe the biggest case in the history of the state of Georgia. Why is that? Lots of murder cases, gang cases, RICO cases take 1, 2, maybe 3 weeks to try at most. Why is this case going to take months? I'll tell you why. Because the evidence will show the government has got to drag in hundreds of witnesses to dance around the weak actual case that they have. They've got to bring in 5 experts to tell you what a game is. They've got to bring in an expert to tell you what an Infinity is, an Infinity automobile. They've got to bring in dozens and dozens of witnesses that are not going to say, Mr. Kendrick committed a murder. Mr. Kendrick possessed or sold drugs. Mr. Kendrick possess illegal firearms. They're going to tell you everything under the sun that dances around the facts and hope that after hundreds and hundreds of witnesses, you're either so confused or so worn down that you'll believe the state's theory. If the case were direct and the evidence were true, it wouldn't take long to trial because they bring to court someone to say, I saw Mr. Kendrick kill Donovan Thomas. They don't have that. And we're going to talk about what else they don't have, but they don't have enough evidence to prove my client guilty of any of these charges. And so to put lipstick on a pig, they've got to try and bury you with hundreds of witnesses that won't tell you that my client's guilty beyond reasonable doubt. Why not bring in someone to say, Mr. Kendrick's fingerprints were on a firearm. Mr. Kendrick's fingerprints were on a bag of drugs. Mr. Kendrick's fingerprints were in the Infinity that was used to kill Donovan Thomas. Mr. Kendrick's DNA was present at the scene of the crime. Why not bring in one witness out of the hundreds that you're going to hear from that will just say, I saw Mr. Kendrick do it? Why not? Because it doesn't exist. And our Constitution and our set of laws and our democracy demand more. They demand that high standard. You may not like Mr. Kendrick or any of these other defendants, but we are not here for a popularity contest. We are here to decide something so much more important. And the state doesn't have the evidence to do it. The evidence doesn't exist, not real concrete evidence. The evidence will show that the state is trying to find Mr. Kendrick guilty by association. That's what they want you to believe. Because they want you to find him guilty because who his friends are. The evidence will show that he had friends, that he knew people, that he associated with people. I thought in America, we had freedom of speech, freedom of association in the First Amendment. But the state wants to present evidence to show you that those freedoms are not true, that the Constitution does not matter. They want to present evidence that Mr. Kendrick is guilty by who he hangs out with, the color of the clothes that he wears, the symbols he makes with his hands, and the beautiful lyrics that he writes and sings. Those aren't actual crimes, that's just free speech. And that is what is on trial here, the First Amendment of the Constitution. They want you to look at evidence and say, these people are guilty because they exercise their right to free speech in America. That's not just wrong, it's un-American. Now, the evidence will show you in 2020 that when my client did get out of prison, due to his hard work, his talent, he became a famous rap star. Almost like buying lottery ticket. You know, the chances of a young person going in the music industry and making it are very, very small. But that made him successful. He used his brain, his creativity, and his really hard work to make his family and his mother proud. And the government wants to punish him for that success. They told you in their opening argument to find him guilty because of overt acts. And they had the gall to tell you that those acts didn't even need to be crimes. Judge, that's what the evidence will show. That's what the state says the evidence will show. They told you that those overt acts don't even have to be crimes, but you should, as a result, find him guilty of criminal RICO. This isn't a civil trial, this is a criminal trial. And they told you he doesn't even need to commit a crime, that you should find him guilty of a crime. Does that make sense to you? Does 1 + 1 equal 3?
Misstatement, argument.
I stand in the issues of that. Ladies and gentlemen, disregard counsel's last remark.
What are the charges against? Thank you. What are the charges against Mr. Kendrick? The first and the biggest is a murder. We've heard a lot about the murder of Donovan Thomas already. Now, Donovan Thomas is not, and it's tragic, and murder is wrong. The state had the nerve to show you an autopsy photo in opening argument, not because they needed to prove that Donovan Thomas died, but to exaggerate and scare.
Objection, argument on what the evidence will show.
The evidence will clearly show that Donovan Thomas died. We can see that, and it's a tragic occurrence. And my client and his family grieve for the family of Mr. Thomas. We don't think it was acceptable. But my client had nothing to do with that man's death. He died because of a drive-by shooting at a barbershop on January 10th, 2015. And what happens next? The police arrest the wrong group of people. They admit they arrested the wrong group of people. You heard Mr. Sharp and Mr. Steele tell you about Kenneth Copeland and Demetrius Garlington and the others who were arrested for this crime. And the police charged them. And what is the evidence that turned out that those people got their charges dismissed and Mr. Kendrick got charged instead? Are there fingerprints of Mr. Kendrick on anywhere at the crime scene, on the body of Mr. Donovan, in the car that was used, on a firearm that was used? Are there fingerprints anywhere that tie my client to that crime? No. What about DNA? Is my client's DNA anywhere related to the death of Donovan Thomas? No. What about ballistics? Are you going to hear evidence that there was a match between the bullets or the gun used to kill Donovan Thomas that was a gun ever possessed by Diamante Kendrick? No. Are you going to hear from a single witness out of the hundreds of witnesses that are going to be brought here by the state? One. I beg you for one witness to come to court and stand right here on this witness stand and say to you, I saw Diamante Kendrick kill Donovan Thomas. Will that occur? And the answer is resoundingly no, because my client is not guilty, ladies and gentlemen. He's an innocent man, wrongfully accused of a murder he didn't commit. And if that doesn't get you upset, I don't know what will. It makes me angry. Not one witness. There's videotape that the state will present of an infinity automobile driving by the barber shop and being used to kill Donovan Thomas. Are you going to hear witnesses that say my client owned the Infinity, rented the Infinity, leased the Infinity, was the rightful driver of the Infinity? Nope. Will you hear or see evidence to the contrary? Oh, yes, you will. Shortly before Donovan Thomas dies, the state has another video of my client getting into, are you ready? A Pontiac Bonneville. Not an Infinity, a Pontiac Bonneville. So, will you see evidence? Will the evidence show that my client is Superman and can fly through the sky from one car to another? No, you will not. He is not Superman. Maybe he's Mr. Spock and he can teleport. You will not hear evidence of his ability to teleport from one car to another either. And yet, the state claims he's guilty of murder. Now remember, you heard previously about a man named Nicholas Robinson, whose real name is Spencer Wright. He came in and told the police, and they made arrests of Mr. Copeland, Mr. Garlington, and others. The state's key witnesses. But you've also heard evidence that Mr. Copeland is a terrible liar and a terrible person himself. A gang member, not to be trusted and not to be believed. But that's the state's key witness who says, oh yeah, it wasn't me, it was Mr. Kendrick and others. Why do we know he's lying? Not just because his lips are moving, but because he was one of the people who was originally charged with the murder. How naive does the state have to think you are to not understand that the incentive for Mr. Copeland to lie is as simple as, I'm charged with the murder. If I say someone else did it, then I don't get charged with the murder. It's a ridiculous theory that they have, quite frankly. And the evidence is so super thin and super weak. It reminds me of nothing more than a Krispy Kreme donut. Thin air. In fact, Mr. Garlington, when he's interviewed by the police, says, yeah, I don't know who killed Donovan Thomas. They have no way to corroborate it. They have no actual evidence. The state wants you to buy into this theory of murder, and our Constitution demands you don't. They charged a bunch of people, the police, the Atlanta Police Department, figured out, oh, we messed up and got it wrong, but now we're going to charge a bunch of other people. But trust us this time. Does that imbue trust to you? Is that evidence that you'll hear about that seems trustworthy? No, it is not. That evidence is completely untrustworthy and unbelievable and unreliable. It's a bad magic trick. No fingerprints, no DNA, no witnesses, no ballistics, and videotape that actually exonerates and proves that he's not guilty. Krispy Kreme donut hole. What's the next charge against my client? Well, there's a bunch of them involving guns. And 3, to be exact. One is that he's charged with possession of firearm during the commission of a felony. If you're committing some other felony, you're using the gun, you get charged as an extra charge. The second is possession of a machine gun. Ms. Love described to you, Mr. Steele described to you, what a fully automatic weapon is. Pull the trigger once, all the bullets fly. That's illegal. And the third is possession of firearm by a convicted felon. And yes, Mr. Kendrick's a convicted felon. So he's not allowed to possess a gun. And he knows that. And again, the indictment. We've talked a lot about the indictment. You're going to get it. It's a document. It's a long document. But the indictment charges my client with those 3 firearm charges, all stemming from one date, March 9th of 2022, the date that Mr. Kendrick is arrested. So what happens on March 9th of 2022? He's at a house owned by Jeffrey Williams, his friend and colleague. who he's made beautiful music with, wonderful music that's entertained millions of people. And at that house, and there's dozens and dozens of people at this house on the night of March 9th of 2022. It's not like there's 2 or 3 people there. Dozens. And there are guns in the house. So, how do we get to firearms being in the house to Mr. Kendrick possessing firearms? We don't. We don't. There's not going to be a single piece of evidence showing that Mr. Kendrick's fingerprints are on any of the guns. There's not going to be a single piece of evidence showing his DNA is on the guns. And quite frankly, you'll learn, and the evidence will show, there's something called touch DNA. What is that? You're going to learn that if I touch this table and my hand is here for a couple seconds, I don't just leave my fingerprints behind, I actually leave some of my DNA behind. And that can be tested, forensically tested by the police and by the GBI lab and the state of Georgia. So there's no fingerprints on the guns that belong to Demonte Kendrick. There's no DNA. There's not a single person at the party or a single witness who says Demonte Kendrick had any of these guns. No one is going to say he bought any of the guns. No one's going to say he sold any of the guns. No one is going to say he possessed any of the guns. But they're going to want to do a dirty magic trick and show you his past. He pled guilty to a gun offense years ago. And so he must have been possessing the guns. That's their theory. Assume and speculate to find him guilty. That's not what we do in this country. That's not what we do in a democracy. That's not what we do with our Constitution. And that's not what we do when someone's presumed innocent and has to be proven guilty beyond a reasonable doubt. One witness, please, that says Demonte Kendrick was holding a firearm that night. Demonte Kendrick bought one of the guns. Demonte Kendrick used one of the guns. No one. No one's going to testify to that. And why is that? Because he didn't have any of those guns. He was at a house where there were guns. That doesn't mean he was in possession of illegal firearms. You could go to a party with 50 people, somebody has guns, you don't know about it, maybe you do, but it doesn't mean you're possessing the guns. That's what the evidence is going to show. He was there. It could have been a bazooka in that house. I don't care. Mr. Kendrick wasn't in possession of any firearms, illegal, machine gun, or otherwise. He didn't control a gun, he didn't use a gun, he didn't buy a gun, he didn't sell a gun, he didn't hold a gun. Not one witness. And there are dozens of people that they could call to say, oh yeah, I saw Mr. Kendrick hold a gun, but not one. And there could be hundreds of witnesses. I want to bury you with witnesses so that you'll forget about the presumption of innocence and what real evidence is required. Zero, not zilch, donut hole, reasonable doubt. What will they show you? What will the evidence show that night on March 9th? Well, they'll show that Mr. Kendrick was afraid. He's a black man in America, and there's a team of people swarming a house with firearms. He's not sure if the police or not. But in 2022, after COVID, BLM riots, people like George Floyd dying, he had a reasonable and healthy fear, fight or flight. Mr. Kendrick doesn't want to fight. He doesn't want to fight the police, and he doesn't want to fight people who aren't the police if they're armed. But he knew that there were people swarming the house with guns, and it turned out they were the police. So what did he do? He ran. He did the absolute smart thing to save his life. he was afraid and he ran. And the police caught up with him shortly thereafter. Now, he's not charged with fleeing the house. He ran because he was afraid, and that's a reasonable thing to do for him, given how he grew up, where he grew up, and the state we live in. And when the police caught up with him, just shortly thereafter, did they find him holding an FN, the type of gun he's described? Did they find him holding a strap machine gun? Did they find him holding a Glock? Did they find him with an AK-47, an AR-15, or any other kind of gun? No! He was unarmed because he never had a gun. There's not a scintilla of evidence that you should believe that Mr. Kendrick is guilty of any of those 3 firearm charges. Not a scintilla. Hundreds of witnesses. I asked for one to come to court and say, Mr. Kendrick was holding a gun that night. What about the next set of charges? They're drug charges against my client. But all the drug charges against him, possession of cocaine, possession of codeine, all the drug charges alleged against Mr. Kendrick are again from March 9th of that year. From the date he was arrested, the party at Mr. Williams' house. And apparently the police find drugs in the house where there are dozens and dozens of people. So again, I ask you, listen to the evidence. What will the evidence show? Will the evidence show my client's fingerprints on a bag of drugs? No. Will the evidence show my client's DNA on a bag of drugs? No. Will a witness come to court and tell you he was using drugs that night at the house? No. Is there videotape of my client snorting a line of cocaine? No. Is there going to be a witness who tells you that my client sold him drugs? No. Is there a witness that's going to tell you that my client bought drugs? No. Is there going to be any evidence that my client possessed, used, bought, sold, controlled drugs on the night in question? Absolutely not. There were drugs at the house. My client was at the house. There are dozens of people at the house. 1 + 1 does not equal 3. It's another Krispy Kreme donut hole for the prosecution. Zero, nada, zilch. You're not going to hear evidence that my client's blood or urine was tested and that it was in his bloodstream there was cocaine or other drugs. And the indictment says that the drugs that they're charging him with are from that date, March 9th, 2022, the day he was arrested, not any other day in his life. So the question you have to ask, the evidence you have to look at is he possessing drugs while he's at the party at that house? And there is no evidence of that, just like the guns. The next charge against my client is gaming activity. And the gang activity they allege, very specifically in the indictment, it's not just any gang activity, it's gang activity related to the possession with the intent to distribute illegal drugs from March 9th of 2022. And again, where is the evidence? Not one witness. They also allege that he committed gang activity based on the guns. Same thing. There's just no evidence of it. It is not illegal to be part of a group in America. Freedom of association. Otherwise, the Atlanta Falcons would be an illegal street game because they wear red and black and they have certain symbols they wear. And the Braves, certainly the Braves, because they lost in the playoffs. Maybe the state of Washington died back. it's not illegal for my client to want to wear the color green and do fancy symbols with his hands, but they're going to bring dozens of witnesses in to talk about that. So what? That's not a crime. Illegal gang activity requires my client to have committed a crime and be in a gang. And YSL is not a gang, but we'll get to that in a minute. They want to attack free speech and freedom of association. They're guaranteed to us in the Constitution. And if they want to do that, then they should go out and arrest the Falcons and the Braves too. Not one witness is going to come to court and say, Mr. Kendrick possessed, sold, bought, used drugs as part of gang activity. Or possessed, sold, used a firearm as part of gang activity. I want you to tally, keep count, take notes. How many witnesses the state brings in this case? Hundreds. And I want you to remember this conversation I'm having. This one-sided conversation I'm having with you all. About how many witnesses say, my client possessed a firearm because he was a YSL gang member. My client possessed drugs because he was a YSL gang member. What is YSL? It's a successful, massively, worldwide, internationally successful record label. And my client was a part of that record label and a successful rapper. And blessed with the ability to make that music. And last I checked, those lyrics, which the state is going to try and use, are just part of free speech. So we've eliminated murder, we've eliminated the gun charges, we've eliminated the drug charges, we've eliminated gang activity based on gun or drug charges. So what's left? What's left is count one, RICO. Ms. Love told you that's a term that most normal people don't use for good reason. It's a very complicated legal term. Most lawyers don't even understand it. I'm going to try to explain it to you. And you've heard a lot about overt acts versus predicate acts. Are you confused already? You should be. They want you to believe, and they want the evidence to show, that Mr. Kendrick is guilty of this vast conspiracy because who his friends are, who he hangs out with, the colors he wears on his clothing, and the lyrics that he writes, the rap music that he makes. And they suggest to you this is all part of a vast conspiracy. But the reality is, some of these lyrics may be offensive to you, and that's okay. Because in a free society, we have free speech. That doesn't make it a crime. The state says that the evidence will show that they dug to find out the murder and then used the lyrics to support it. You know, I watched Goodfellas. It was a movie about real crimes that took place. It was written by Martin Scorsese and acted out by Robert De Niro. Is the DA's office going to go arrest Mr. Scorsese and Mr. De Niro? They're exercising their free speech to tell a story. Why can't my client, Mr. Williams, do the same and write lyrics about crime? Maybe they're offensive. Maybe the movie Goodfellas is offensive because you see people committing crimes. But in a free society, we're allowed to exercise free speech. It's the price we pay to live in a free country, and it's a great price. Just because someone raps about murder or other crime does not make it a crime. Why do they rap about that stuff? Because it sells records and it allows them to creatively express their feelings about how they grew up and where they grew up. And they are proposing a war on the First Amendment of freedom of association and free speech. They don't like those lyrics. They want to send a message to all those inner city kids in Atlanta who dream about getting out of the ghetto and becoming successful musicians. And their message is, you rap lyrics about crime, we're gonna indict you and charge you and brand you a criminal. That's un-American. That's wrong. The evidence will show that the state of Georgia and the city of Atlanta have been blessed in the last 20 years by the entertainment industry. And not just rap music, TV and film, and all kinds of entertainment. And some of it's fictional. And that's okay. It's okay to rap about crime or life or your experiences, even if it's not true, even if it didn't really happen. That's just free speech, ladies and gentlemen. That's not evidence of a crime. That's protected in our Constitution. It's a protected part of living in a free society. YSL was a very successful record label, and there's going to be evidence of that. It made millions and millions of dollars. That's not a criminal street gang. But it's not just a successful record label. It gave my client the opportunity to give back, to volunteer his time and some of his money. He coached an inner city youth football team. Does coaching that inner city youth football team support their RICO accusation? Because they told you the overt acts don't have to be a crime. Maybe now we should criminalize civic volunteer work. I don't know where it ends if we start making free speech illegal. They want to lump Mr. Kendrick in. They want to have you find him guilty because of other people's crimes or crimes that he already paid his debt to society for. So the state presented you some of the examples of that. Will Wayne's tour bus got shot up. That's horrible. Whoever did that should be punished. But there's no evidence my client was there to pardon it. They're alleging that's part of this case. The shooting of Chanel Drinks you heard about, gunned down in a rental car. But they're not alleging Mr. Kendrick took part in that either. And what about the attempted stabbing of Rayshawn Bennett? Wyatt, who's known as Wyatt Benucci, another rapper. And the armed robberies, they allege. None of those incidents involve Mr. Kendrick. But what they're going to argue to you is that if Mr. Kendrick was part of the YSL label, or what they call the YSL gang, then even if he's not charged with those crimes or involved in those crimes in any way, he should be found guilty of RICO conspiracy, even if he didn't commit a crime. And that's wrong. It's just wrong. That's why they have to go to such great lengths and bring hundreds of witnesses in to establish other crimes, other acts, other incidents that my client had nothing to do with. It's a bad magic trick. Look over here at Will Wayne's tour bus. If they actually had evidence of my client committing a crime, we'd be here for a week, not months. The conspiracy they want you to criminalize is being a rapper in America and being successful. They want to attack the First Amendment. They want to attack free speech. They want to attack capitalism because they don't like rappers who rap about criminal behavior in Atlanta. And they're telling you that this is a pattern of activity, a trend to attempt to control and exert influence. But really what they're showing you is, if we don't like your speech, then some free speech is wrong and illegal. And you should find my client guilty as a result. They don't want you to find Mr. Kendrick guilty based on his actual actions, just based on the words he wrote and sang. They don't want you to find Mr. Kendrick guilty of his actual actions because they don't have the evidence of it. They don't have the evidence of a murder or illegal guns or illegal drugs. They don't actually have that. So instead, they've got to play their bad magic trick. But you're smart and you can listen to the evidence and you will see it's nothing but a Krispy Kreme donut. That's what the evidence will show. You heard about wiretaps. It's basically the police listening in on people's phone conversations. And that's fine. They get a judge to approve it, they're allowed to do that. And there's hundreds and hundreds of hours of wiretaps. And I dare you to listen to all that over the next few months and hear one time my client saying, I have a gun, I have some drugs, I committed a murder. It doesn't exist. Nowhere. I'm part of the YSL gang. Remember, they told you that the YSL is this sophisticated gang, so there's no written agreement, there's no verbal agreement. It's just something you have to trust them with. Does that sound right? Just trust that. Take the government's word. And they're going to bring in experts on gang activity to tell you that the record label is a gang because they think so. Well, they work for the state, for the police. They're going to tell you what they want you to hear. But use your brain. Use your common sense. All those wiretaps, you're not going to hear Mr. Kendrick say one time, I'm going to do something illegal. Whether it's a violent crime, a gun crime, a drug crime, or admitting he's part of a gang. Not once. In hundreds and hundreds and hundreds of hours of wiretaps. And why? Isn't you won't hear that? Because what is he actually? He's a former convicted felon, a former gang member, and a current recording artist, a current rapper with YSL, and a current member of society doing civic duty. They have to point at his past and get you to only look at that because the actual evidence from March 9th and from January 10th, the 2 dates in the indictment that accused my client, there's no evidence of him committing a crime. The state turned over to us, prosecution, 6 terabytes of data in this case. Now, I'm not a computer expert, but I want to talk to you about what the evidence will show. A lot of that evidence you're going to hear and see. What is a terabyte? It's an enormous amount of computer data. And here's what I'll sort of tell you the analogy is. If it were pieces of paper, 6 terabytes would be 420 million pages of documents. 420 million pages. That's how much evidence there is in this case. Is there one page? Is there one witness? One set of fingerprints, one set of DNA, one videotape that shows my client committed a murder, that shows my client possessed illegal drugs, that shows my client possessed a firearm, that shows my client committed illegal gang activity, or that my client conspired with others to commit crimes? It's a donut hole. It's a Krispy Kreme donut hole. You don't get the glaze, you don't get the donut, you just get air in the middle. What did Mr. Kendrick do? Oh, they have pictures of him flashing gang signs and wearing green. They have pictures of him standing on the hood of Rayshawn Bennett's car at Lenox Mall. Oh, God forbid. He stood on the hood of another rapper's car, and they want you to believe that is the evidence that he's part of this vast conspiracy. No, standing on someone else's car, it's a nice car, is juvenile. It's silly. Maybe it's even a misdemeanor. But they didn't charge him with that misdemeanor. Instead, they charge him with RICO conspiracy. Standing on the hood of this other rapper's car must be proof that he's part of this vast conspiracy they're alleging. Quite frankly, the real juvenile behavior is all these hundreds and hundreds of witnesses to try and prove something that doesn't exist. There are lots of other overt acts, and I'm not going to belabor each one of them to you because you heard most of them from Mr. Steele and from the state. But you've also heard from me. If there's a witness who says Mr. Kendrick possessed a firearm or possessed illegal drugs or murdered Donovan Thomas, they saw him murder Donovan Thomas, then bring that person to court. Mr. Copeland, their star witness, is going to come to court and say that Mr. Kendrick admitted to him, Mr. Copeland, that he was part of the group that killed Donovan Thomas. You going to believe Mr. Copeland, who has every incentive to lie? That's the evidence they want to rely on? That's what they're keeping us here for months and months for? The guy who was charged with the crime, who now says it's not him, it's my client instead? Please tell me there's something better, something else that we're here for. Please tell me we have anything near proof beyond a reasonable doubt. We don't. There's no real or concrete evidence my client committed a crime. Not a single offense. Not RICO, not gang activity, not guns, not drugs, and definitely not murder. Ms. Love talked about the wolf pack. I understand that. She thinks the evidence will show that. But I really think it's more like the boy who cried wolf. You know that old story. There's a wolf, there's a wolf, there's a wolf. And it turns out there wasn't a wolf. That's the state's case, ladies and gentlemen. And that is why you will come back many months from now and find my client, Mr. Diamante Kendrick, not guilty on every single count. Thank you.
Mr. Harvey, you wish to make an open statement this time, sir?
Judge, on behalf of Mr. Nichols, Ms. Westmoreland, and Mr. Gardner, we would reserve our opening statement under Uniform Superior Code Rule 10.2 until the completion of the state's case.
So noted, sir. All right, Mr. Matthews.
Yes, sir.
All right.
Thank you.
Good afternoon, ladies and gentlemen.
guys just need to stretch or anything. My name is Carrington Matthews, Senior. Attorney Teresa Mafu and Attorney Carrington Matthews Jr. We have the pleasure and the honor of representing Mr. Marquavius Huey in these proceedings. Who is Marquavius Huey? Marquavius Huey is 27 years old. He is 27 years old. He was born and raised in Atlanta, Georgia. Born and raised in Jonesboro South housing projects, as you have heard about over these last several hours throughout these various opening statements. He has 6 other brothers and sisters, and he actually graduated, ladies and gentlemen, from South Atlanta High School in 2014. He has 2 children. He has a 4-year-old son, Major, and a 1-year-old daughter, Journey. Mr. Marquavius Huey is not a convicted felon. He can sit on a jury. He can own a firearm. He can vote. And he can do what other law-abiding citizens can do as a non-convicted felon. He has goals, ladies and gentlemen. He has goals of being able to one day open a store, a retail store that sells men's and women's clothing. It's one of his goals. And when he grew up in Jonesboro South, ladies and gentlemen, he grew up with various folks that live in that community. As any community that you live in, you gain friendships and you grow up together. And Mr. Huey, he grew up. He grew up with Jeffrey Williams. They were friends from childhood. That's what the evidence will show. You will learn it. Now, let's get into the Overt Act 76. This is a theft by receiving of a handgun in 2018. That's one of the overt acts in this case, ladies and gentlemen. Now, in that particular indictment back in 2018, that actual indictment was brought by the Fulton County District Attorney's Office. They brought it in 2018 against Mr. Huey. Also in 2018, they reduced it to misdemeanor disorderly conduct. They gave him 12 months probation, and they agreed to that reduction. This table, this organization, this agency, in 2018. Now, in 2018, they reached that agreement with Mr. Huey. Now here we are in 2022 when this case was indicted, and now in 23 when it's being heard, they're using the same charge that they initially charged him with, of theft by receiving of a handgun. They reduce it down to a little misdemeanor, disorderly conduct. And now they say, hey, let's tell the ladies and gentlemen of this RICO trial that This is an overt act in a RICO conspiracy in a YSL case. That's what they have brought to you in this indictment. The evidence will show that in 2018, this had nothing to do with anything concerning RICO. Because the evidence will show, had it, now keep in mind, the dates 2013 to even the present is what the government just told you all yesterday, was this RICO conspiracy. So in 2018, ladies and gentlemen, if this particular overt act has anything to do with a RICO conspiracy today, why did the same agency decide in 2018 that a felony theft by receiving charge negotiated, agreed to, should get reduced down to disorderly conduct? But this is what the evidence will show. You will learn it, and this is what's been handed to you. Now, let's break it down. This indictment. Counts 3 through 7 we're going to go through first, and then we're going to go through another grouping of counts. But these are, there are a lot of charges in this indictment with respect to Mr. Huey. There are a lot of charges, right? But when these charges are put together the way that they are supposed to be, you will see as we get through this case that there are 2 cases that we're dealing with in these groupings, and then we're going to talk about another incident concerning the Fulton County Jail. So just stay with me. We're going to get there. Let's first talk about April 26, 2019. These are counts 3 through 7. Count 3, overt act 88, Mr. Huey is charged with armed robbery. They're saying that on April 26, they're alleging that Mr. Huey, as a party to a crime, committed this armed robbery against this gentleman by the name of DeJuan Maynard. That's what that particular count talks about, an armed robbery, using a firearm with an unknown person to take these items from this person. We're going to get into details, but I'm going to go over the charges first. Count 4. They are charging Mr. Huey with overt act 89, aggravated assault, saying that with that same firearm that Mr. Huey pointed the weapon at Mr. Maynard as he took the items, and that this makes up an aggravated assault. That's the charge. Going over the charges, then we're going to get into what the evidence is going to show. That's count 4. Count 5, the same one case we're talking about, the same one grouping, aggravated assault, because there was this other individual by the name of DeMond Jenkins who was with Mr. Maynard. So they have charged Mr. Huey with this ag assault on the DeMond Jenkins. Same grouping, same incident, April 26, 2019. And then count 6 are these tag-along charges that you typically come when you get charged with an armed robbery. You're going to get an ag assault, you're going to get a possession of a firearm during a commission felony. That's how the government, that's how they indict cases. Those are the charges. We'll get into all that later, but these are the charges. We'll get into that at a different stage in this trial. But that's count 6, saying that Mr. Huey had in his possession this firearm when this alleged incident happened, where they are claiming that Mr. Huey was involved. We're going to get into it. And then 7 is that same gun charge against Mr. DeMond Jenkins. So that's 3 through 7, ladies and gentlemen. April 26, 2019. So what happened? Let's get into it a little bit. April 26, 2019, around 12:39 a.m. in the morning at 741 Morosco Drive, Northeast, Atlanta, Georgia, at this apartment complex called Core Lindbergh Apartments. That's a stock photo of that particular complex. Now, here's the story. The story is that, and we're not disputing that this incident happened. We're disputing that Mr. Huey is ever a part of it. Mr. Huey stands before here. He signed an indictment and indicated that he is not guilty and he is innocent of these charges. And we stand here straight and we look you in the eye and we stand tall that Mr. Marquez Huey is innocent. So, April 26, 2019, you've got three individuals. They have left the apartment unit, and these three individuals are walking in the parking deck, right? They're walking to their car. Three individuals. As they're walking to the car, these three individuals, they see two black males get out of a vehicle they describe it as a black Mustang with a temporary tag. So these three individuals, they're in the parking deck, they're walking to their car, and two other individuals get out of the car and they begin to chase these three individuals. There's video surveillance in the parking garage. You will likely see this video surveillance. It's the government's case, and they get to present their case however they choose. If they choose to show you a video, you will see it. Right? Now, let's talk about these three individuals that are walking from their apartment to their car. Damon Jenkins, he lives there. He knows the apartment complex. He knows the parking deck, right? So he lives there. He's familiar with his spot. He's familiar with his crib, right? So he runs down the parking deck. So he sees them. He's walking. He sees them. He goes down. So he goes essentially left. Okay? That's Damon Jenkins, the apartment lessee, the owner of the apartment, his crib. DeJuan Maynard. DeJuan Maynard is with Damon Jenkins, right? What does he do? So he's visiting his friend, Damon Jenkins. Damon Jenkins has the keys to Maynard's vehicle. Maynard is the one with the jewelry and the items, right? Maynard, he goes right, and he goes up the parking deck, right? And he's running. Now, you've got this armed robbery that is occurring. You've got Damon Jenkins going left, down the deck. You've got Maynard going right, up the deck. Now, pay close attention. The two perpetrators, they decide that they are going to go after one person, not two, right? This is an armed robbery.
right? You got 2 perpetrators, you got 3 victims. One of those victims goes left, Jenkins, Maynard goes right. Maynard is the one person out of those 3 that those 2 perpetrators go after. So you got 2 individuals that are the perpetrators chasing Maynard up the parking deck. The third male, I guess he goes down and he is not chased. He goes down, one goes left, he ducks, the other one, Maynard goes up the deck, the 2 perpetrators chase Maynard. That's the story, that's how it's happening. Now, the 2 perpetrators, they reach Maynard. When they reach Maynard, ladies and gentlemen, Maynard, he says he got hit with, one of them hit him with a firearm, and that they took items. Now, these are the items that Maynard says were taken. This is what he says were taken. He says a ring, a diamond 5-point star ring. He says 2 gold chain necklaces, one with a cross, another with diamonds, 1 pair of diamond earrings, a gold Gucci bracelet, a SunTrust debit card, a Gucci bag, a Louis Vuitton bag, and some cash. So you got all this grouping of items that Maynard says that was taken from him. You've got police officers galore that come over to the scene, right? So you've got responding officers, you've got white shirt officers, you've got sergeants, everybody's responding there, trying to figure out what happened. They talked to Maynard and Jenkins, right? They talked to the security guard, Joel Hines. Joel Hines, he says that, I was patrolling the area. I saw this black vehicle that had been parked and running for about an hour or so. It had tinted windows, and I couldn't see inside. And, apartment owners, sometimes they'll come sit in their apartment in their cars before they go inside, so I didn't think anything of it. I didn't see anybody. I didn't get a look at anyone. So the security guard, he doesn't see any individuals that are in the black vehicle. They canvass the parking deck. The officers, they get surveillance videos from the parking garage. So that's what the officers are doing. That's what they did that night, right? Now, here's where it gets interesting, ladies and gentlemen. On April 26, 2019, at 12:39 in the morning, that's when this incident happened. Demond Jenkins, when he goes left, Demond Jenkins, who's the apartment owner, when he goes left, he goes downstairs, he runs out, and he happens to see an officer, he flags him down. So that officer's right there, pretty much. All right? And then other officers start coming and converging on this incident scene to try to figure out what happened. But on that same day, later that day, Maynard, the one whose items he claims were taken, he does this, I don't know if he does an internet search, what he does. How in the world of millions of social media people that are on social media, Instagrammers, people that have pages, Maynard calls into zone 2 and he tells the police that he just happened to be scrolling Instagram and he saw a person wearing his diamond 5-point star ring. Imagine that. Less than hours. So what does he do? Maynard calls in. You will hear evidence that when he calls in, that he sends some photographs. I'm going to get to that. So the case is assigned to Detective Jeffrey Henderson on April 28th, 2019. So the case now has a detective Couple days later, Detective Jeffrey Henderson now has this case. What does he do when he gets the case? Well, he gets Maynard to send him these photographs. He views the video surveillance footage that he obtained from the parking deck, from the apartment complex. And he asks him to send some pictures of the jury. So send this information that you found on Instagram, send me some pictures of your jury, and send me some videos, and let me take a look at the video surveillances that I was able to get from the parking deck. So these are the photographs that Maynard, the victim in the case, he sends Detective Jeffrey Henderson 2 separate Instagram pictures of 2 separate people. On the left there is a picture he sends of someone else, some person in the world on social media. Maynard sends that photograph, and he sends the one on the right. The one on the right is Mr. Huey's Instagram. The one on the left is someone else's Instagram. He sends these to Maynard, to the Detective Henderson. 2 different people with the same ring, or the similar ring, or some ring that looks like the one that he owned. The same day. So he becomes his own detective. Now, the video that was obtained from the parking garage, ladies and gentlemen, that video, it shows the 2 perpetrators running after Maynard, right? One of those perpetrators has on like a black jacket and maybe some red pants or something of that nature. The other person has on a gold puff jacket and some black slacks, pants or jeans or whatever. So that's what the video is showing from the parking garage. So what does Detective Henderson do? So he goes on to Mr. Huey's page, and I guess starts scrolling Mr. Huey's page. Oh, Mr. Huey has a gold puff jacket. But guess what, ladies and gentlemen? In this particular, Mr. Huey's is on the right, standing in front of a black Infiniti vehicle that belongs to his lady, Justice Woodard, who is the mother of their 2 children, Major and Journey. On the left is a photograph. You heard Mr. App talk about that huge discovery that was sent to us. The evidence will show that particular photograph is part of the discovery that came to us in this pile of evidence that is a part of this case. That on the left are 2 young men. And what's interesting here, ladies and gentlemen, is that apparently that year, the gold puff jacket from Zara was a very popular item for young people as part of their wardrobe. We know that because you're going to learn that this is what was sent to us, and that is what was going on with the dress back in 2019. 3 different people with the same gold puff jacket that was provided to us in discovery, that the government provided to us.
So the gold puff jacket is relevant here. Why? Because what was Detective Jeffrey Henderson's investigation at that point? Maynard sends him these two hands with the similar jewelry. Maynard sends him a piece of jewelry of his own to say, hey, you know, this is what was one of the items that was taken from me. And the video, ladies and gentlemen, from the apartment complex shows a person with that similar gold puff jacket. And what does Detective Jeffrey Henderson do with that information, ladies and gentlemen? He completes it. He completes his investigation. This happened on April 26, 2019. 4 days later, he gets a warrant for Mr. Hughes' arrest on that investigation. That is the case. Now, there is no photographic lineup that was ever done. Maynard never says he saw Mr. Huey that night on April 26, 2019. They're not wearing masks. Mr. Devon Jenkins never selects Mr. Huey out of any photographic lineup. In fact, there was none done. There was no photographic lineup performed or attempted to be performed by Detective Henderson for the benefit of Maynard or the benefit of Jenkins in this case. He took what he got from that video surveillance, went on to receive the information that Maynard sent him, and decided that there was enough for a warrant. No photographic identification, no fingerprints left at any of those scenes, no shell casings that are linked to any firearms belonging to Mr. Huey. None of it. That's what you're going to learn. You're going to learn, ladies and gentlemen, that at any arrest that was made against Mr. Huey, any arrest that was made against Mr. Huey with respect to these items that Mr. Maynard says were taken from him, a gold 5.5-star ring, these necklaces, these items that we're talking about here, the Gucci, the Louis Vuitton, the debit cards, none of those items have ever been found on Mr. Huey's person, on Mr. Huey's any car, in any residence, none. That's the state's case for those grouping of charges, ladies and gentlemen. No DNA. Detective Henderson didn't even, when they arrested Mr. Huey for those particular charges, those groupings of charges, he didn't come down to the jail and even pull him out of the cell and say, hey, I want to talk with you. Are you willing to talk with me? Of course, that's Mr. Huey's right to either talk to him or not talk to him, but he didn't even try. No other witnesses out there at that location that are going to tell you that they ever saw Mr. Huey at that location. That's what you're going to learn about that grouping of cases. No photographic lineup. Ladies and gentlemen, this is interesting. Listen to me very closely. You will not hear any evidence of a cell phone tower locating Mr. Huey at 741 Morosco Drive, Northeast Atlanta, Georgia. You will not hear it. In the technology-driven